Ladies and gentlemen, good morning. My name is Rob Litz with U.S. Arbitration and Mediation, and it's my pleasure to present our full-day best practice CLE. I believe this is the third annual full-day best practice CLE, but it's our 84th best practice program over the last approximately 15 years. It's really a pleasure for us to provide these to you as a service to the bar and to the bench. The proceeds of our programs are going to a variety of terrific nonprofit organizations, and it's with the funds that you have provided, we can together do some good in the world. I want to thank all of you for attending. We have people from Arizona to Switzerland on this Zoom and everywhere in between, and it's nice to see many names of some old friends of USA&M. We have a fabulous program. I'd like to first thank all of the folks in advance who have taken great time to provide materials to you, which I suggest you take a look at. The materials this year are really outstanding, and also to recognize that the time and the experience and the talent of our presenters who've given voluntarily to present to us a great variety of topics today. We're going to lead off. Before we do that, I just want to mention in your materials there are two things. I think it's on the second and third page of the materials. One is an evaluation sheet that at the end of the program, we'd like for you to email to Kelly Spiller. Kelly is the one you've been communicating with, so that we can have these on hand. MOBAR requires that we have the evaluations. And one of the most important things for us is to craft programs that are relevant to you and the needs that you have. So at the bottom of that eval, we ask you to provide topics that you would like to see us present, as well as speakers. And we do appreciate receiving that. The next thing is a certificate for MOBAR credit, and that's the next document in your packet. In that, on that page, there has the CLE program number from Missouri. It's 723574 for getting CLE credit, but it is on that certificate. So let's go to the leadoff position. Leading off today, a topic on the power of apology. This has been researched some over the years, but I see it in action, as many of the mediators do, and how powerful and important that is when we're mediating cases, or frankly, when lawyers are trying to negotiate settlements. So CJ Larkin and Kim Kirn, two of our mediators and also members of our senior arbitrator panel, are going to tag team in this initial session, talking about the power of apology. Both are just outstanding lawyers and ADR professionals, and I'll turn it right over to CJ and Kim. Thanks so much.
Thank you, Rob. I'm going to see if the technology is going to work. We will see. Nope, we did it wrong.
There you go.
Yeah, I don't think that's what we want. Hold on one second.
So CJ, we can see your PowerPoint.
Oh, so we don't have to, okay, we don't have to pull it up, right? Is that what you're
Correct.
saying?
Yes.
Great. I'm sorry. We thought we had to.
Okay, very good.
Hang on, let me try to stop share.
No, you want to keep
Am
sharing.
I okay?
But we're gonna, Rob, let's just make sure our advancing works.
Yes.
Do you see the next slide now? Rob?
I did not. I have the first intro slide.
Now?
No.
Okay, so hang on one sec.
So it's not letting us advance, so that's not good.
I think let's see what
escape.
happened. Yeah, that may be bad. Here, we're trying to, sorry, we have it up on a screen, but it is not. How about this? Oh, sorry, guys.
I don't know how to get out of where you are.
Yeah, I know. It's not,
Sorry.
sorry, guys, it's not letting us get out of where we are. So that's problematic.
Kelly, maybe you want to come down and do an assist for us. But I think we can go on and start talking while we're waiting
Yeah,
for that.
That's great, guys. Sorry about that. It is not letting us get back into to share things or not. Okay, so we'll start talking when Kelly gets down here. She'll help us. All right.
Yeah.
So, so the basically the outline for today is we've got 50 minutes. We've got a lot to say. We're going to have to maybe speak. I don't know. We're going to try not to. But we're going to, first of all, we're going to cover the legal protections for apology, because frankly, for most lawyers, it is lawyer attorneys who are also mediators or advocates in a mediation. That's their concern. And I think the parties concerned the same. Kim is going to take us through sort of a discussion of what's out there to protect. There are some med mal protections she's going to talk about, just generally, doctors talking to patients, et cetera. But we're going to talk about the special protections of when you're in a mediation session negotiation. Okay. So I think we are going to, I wish we could pull this up for you. Hang on.
To do the rest of the outline though, of what we're going to talk about.
Yeah, all right, thanks. So then we're going to go through apologies effectiveness. We're going to talk about some studies by Jennifer Robinal, very well-known professor of ADR. And she's done a lot of research about what's effective, what's not effective, how it affects settlement. We're going to talk about the studies she's done of the differences between attorneys and their clients and how that affects the presentation and acceptance of apologies. We're then going to give you a fact pattern, and we're going to ask you how you would apologize. And we're also going to talk about acknowledgements, which are kind of rolled into apologies.
And how not to apologize.
And how not to apologize, right? Very importantly. So we're going to give, and then eventually we'll give you what we think is a pretty good apology. And of course, Rob will help us get your commentary. All right. Kim,
So questions, feel free to address those to Rob, and we want him to interrupt us and ask questions as we go. So please ask questions or comments.
why don't you start? I'll go get Kelly.
Sounds good. All right.
Kim, I'm going to ask you to stop sharing your screen. I will then try to open up your PowerPoint and then just tell me when to advance.
Rob, we have tried to do that, and the laptop we're on is not letting us even stop sharing. So
Okay.
that's weird.
All right, we'll see what we can come up with.
We'll get it going. Don't worry.
Thank you.
I want to talk about the statutory protections, and there are really a couple different ways that an apology in litigation is protected or in mediation is protected. Because so often what we find is that the lawyers and the parties may feel that an apology is a good idea. And I'll tell you, just as a little bit of background, as a mediator now for more than 15 years, I've had apologies work quite well in some mediations, particularly cases where there was some kind of personal relationship beforehand. I think maybe they're best in employment cases. They can be helpful. They can also be helpful where there was some serious personal injury. And I had one case where it was there was some criminal sexual misconduct. The wrongdoer was in jail, so the wrongdoer wasn't giving the apology, but the employer wanted to give an apology. I don't want to say was willing to, I want to say wanted to give an apology. And it was really helpful to have that as part of, I think you need to think of apology as one tool in your toolbox. And there are certain times where it really can be useful. So
Rob's gonna go.
yeah, good. Thank you, Rob. You
Let me-
can go to the next slide, Federal Rule of Evidence, slide 3.
Yes, tell me.
Thank you. Okay, no, this will be easy. Thank you, Rob. So a lot of times lawyers and clients are hesitant to give an apology or even an acknowledgement because they think it will be used against them. And what CJ and I have researched and what we have done in our own practices is make sure that the apology is protected and sometimes by a couple different layers of statutory protection. So the first one I want to talk about is the fact that if the apology occurs within the context of settlement discussions, including a mediation, of course, it is confidential and it is not admissible in evidence. And so this is the federal rule of evidence. And if you can look at, A1, that's the federal rule that makes that confidential. Okay, next slide. This is the Missouri Supreme Court rule that offers protection to the ADR process. Thank you. Okay, and then you can go to the next slide, which is Missouri Rule of Civil Procedure 88.8, which also refers to mediation and the confidentiality of conversations and communications. I guess communication is the word they use as part of the mediation, and that is confidential and not admissible. And then the next slide, Missouri Statute 435.04. talks again about confidentiality within the mediation. And that's why in my cases, when mediation comes up, or I'm sorry, when apology comes up, and it doesn't come up in every case. Sometimes I'll suggest it. Sometimes one side will ask for it. But I make it very clear and that whatever is said in the mediation, including an apology, is not admissible and cannot be used elsewhere. And I had a case recently where we danced around the idea of apology, and one party was not willing to give it. And that's okay too. If it's not going to work, I don't push it. This is the lawyer's case. This is the party's case. It's not my case. I just throw it out there as, hey, is this an idea we want to explore? And if we don't, that's okay.
It's interesting in that section to look at point 2. It talks about arbitration, conciliation, whatever that is, and mediation, right? That whole proceeding, those are considered to be negotiation settlement, right, and protected.
Right.
And that is why it's so important to have the agreement to mediate, because it says, yep, we mean to be doing this, right, and we're covering it.
Yeah, good point. All right, next slide. This is a statute specific to Missouri. 38 other states have something similar. They vary state to state, but this is the benevolent gestures statute. And I have to tell you, I was searching for apology. I'm like, I know Missouri has an apology statute. Let's find, I'm looking. Well, it's funny. The word apology never exists in this. It's a benevolent gesture. But you'll see there's some very specifics on here. It has to be made to the person or to the family. And I think probably the most important part is if you look down at the bottom, it does not prohibit admission of a statement of fault. So if you were going to rely upon this statute, you'd want to be very careful that you're not admitting fault, but rather you are expressing condolences, and you might even want to use that word benevolent gesture. This statute isn't litigated very often, and that's true in all of the 38 states that have it. Some of the 38 states go even beyond what Missouri statute has and do cover admissions of fault. So you'd want to look very carefully at your statute.
And also to add, to put this in context with mediation, this isn't in the context of a mediation process or an ADR process. This is saying generally, if some doctor says to a patient, I really messed up, I shouldn't have put the stent in that way or something, right? Now, if they said that in a mediation, protected. Just out in the cosmos, no. And so you'll find a lot of, if you do med mal, you might want to do some reading about how much it's recommended that there is some level of apology, benevolent gesture, acknowledgement by the parties and the doctors, hospitals, whatever, but to be careful. But that there's a lot of research that shows, particularly if that's done early on, it can forestall litigation and help settlement early, pre-case.
Yeah. Okay, next slide. Just quickly, a couple of exceptions to the confidential communications, the settlement agreement itself, the agreement to mediate. Next slide, Rob, please.
There he is.
Okay, good. And, so the final one I want you to look at is written consent of all the parties and the mediator, if everyone wants this to be public. And sometimes that's true. The Philadelphia Museum of Art CEO gave a public apology. So, while that wasn't in the context of a mediation, there are times when you want it to be public. Okay, next slide. Just really quickly, I did a little research on Missouri case law and apology, and I think this Browns versus Harrah's case is kind of interesting. Dr. Brown was gambling at Harrah's. He was accused of cheating. He was thrown out of the casino and asked never to come back. And the casino reported that to the Missouri Gaming Commission, which then issued an arrest warrant. Interesting. So Dr. Brown continues to gamble, but in other states. And in the meantime, he asks the casino, could you please look into this and do an investigation? They did, and they found that maybe they jumped to conclusions, and they issued a letter of apology. So a letter of apology, not verbal, but letter of apology. Later, Dr. Brown was gambling in another state, had an encounter with law enforcement, and they checked out and they found this Missouri arrest warrant, and they arrested him and put him in jail for 3.5 days, during which time he was beaten up. So the moral of the story is don't spend any time in a county jail in Florida. So, yes, I know. So the letter of apology was discussed by the appellate court. Its admissibility was not discussed, but I thought it was really interesting that that was part of the case and an important part of the case. All right, so let's move on. We want to get to the Robineau article. So Rob, next slide. Thank you.
Thanks. So we mentioned Jennifer Robineau, formerly of Mizzou. I don't know if she's still at Mizzou, but she was a home team girl at one point. Her main focus, she has a combination of psychology background and law. So she focused on several sort of practical, trying to find some data-driven information on a lot of factors, one of them being apology. So she created a study in which there was a bicycle pedestrian accident. Clearly the person who hit the person on the bicycle, it was their fault. And in all the different permutations of apologies, because they gave different examples of levels of apology, the money was the same. So let's say $10,000, whichever way you'd like to assume. Let's say 10,000. Let's go with that. So they have no apology, partial apology, which is I'm sorry you got hurt, right? That might be considered benevolent, and full apology, which is I'm sorry you were hurt. I was riding too fast and not looking where I was going. Now, from my definition of full apology, that isn't even a full apology, but those are the three testing sites they used. All right, next slide. So
I'm sorry.
Yeah, let's not worry about that. So so here are her elements of full apology. Again, we're going to show you another much more extended, but it was you express your embarrassment, chagrin, sorrow, whatever. You know that what you did didn't meet expectations and you sympathize about what happened. You said repudiate what you did. It was wrong. I shouldn't have done it. I know what I should have done. I should have paid more attention than whatever else. And some sort of penance, I don't know. I love the religious aspect of this, or some sort of form of restitution. Okay, next slide. So this is what they found with the study. So they had these different groups of people. Here's your facts. Here's how much money's offered. Let's say 10,000. And so then let's see what people's reaction was. All right. So when there was no apology, like nothing, didn't mention it, which many times lawyers prefer, right? 52% accepted the money, the settlement. 43 rejected. 5 weren't sure. Okay, I'm not sure which way I go. The partial, which was I'm just sorry you got hurt, 35 would accept the settlement offer, 25 would reject it, 40 were unsure. The full, what she calls full, I'm sorry, I should have done this, right? 73% accepted the actual proposal, same money, and 14 rejected it and 14 were unsure. So what's interesting here is I think you see that no apology doesn't help very much, right? If you want acceptance of your offer, better to give a full, but giving a partial apology is worse, right? Fewer people accept it. You move everybody to the unsure level. So the point is, because many times people think, oh, you can't apologize, your lawyer won't let you. But if you start to do it, you need to do a good job. Next slide. So, why is it worse? She did some research on this, and what she found is that why people felt worse about someone who didn't apologize at all, or gave a, half-hearted apology that was considered like, oh, I guess that's all they're going to say. It didn't raise the issue of apology. But if you have a full apology, there's all kinds of halo event, sort of assumptions. You're a good person. You really understand this. I don't need to teach you a lesson because you got this and you explained it. All right, next. So it's interesting. She's gone on to do more research, which is that there's a difference between how attorneys feel about apologies and how clients do. Lay people, clients, they really like apologies. They want it. They'll tell the mediator sometime, I just don't know if they get this. I just don't know if they understand how serious this was. But when as a mediator, you talk to the lawyer and the client together, you can see the lawyers rolling their eyes, please. That's going to cost you $20,000 or $5,000 or however much. Now, interestingly, she did a study with law students, and she found that law students value apologies more than your average client layperson, but less than the layperson does, but more than an attorney. Now, she didn't do year 1, year 2, third year law school, so I don't know if it gets worse as you get there, but there is sort of a movement away from sort of the emotional human aspect of it. And I have been in mediations where the lawyer actually said they want an apology, taking $10,000 off the offer. Oh, right. And if it's written, 5,000, they get very little. So
CJ, do you ever have cases in which a written apology comes up? Because every apology I've ever done has been verbal. I have never had a written apology, and I would really question what's the value of that.
Yeah, why do you need that written apology? I think sometimes there have been, and when we talked about parties agreeing to having some statement after, I think that there have been cases in which they had a joint statement, particularly in academia, right? They had people where professors are being let go or some negative thing. They want some sort of statement to the community, which might include some acknowledgement or apology. But in general, I'm with you. Like, why do you need this, right?
So I'm all about best practice. So best practice, make that apology verbal, not in writing. And if it has to be in writing, I really would want to know why. Why is that important? What is the potential use of this? So
next slide. So, so we're going to talk a little bit about, Kim's going to go into more detail about how do you do it? How should it happen? This is a little more research by Robinol, and what she found is that it's very important who delivers the apology. If it's from the party themselves, like in the ear of, not carried by an attorney, not carried, frankly, by the mediator, that it means more to people and has more value. She didn't research specifically about mediators delivering apologies. I've had to do it before. I'm sure we all have. But the question is, if they can do a decent job, big question, then, or not undo it. I'm really sorry, this, that, and the other. On the other hand, you got to understand why I did this.
But I would tell you, I think a good mediator can deliver an effective apology. Now, is it as good as the wrongdoer? No, but sometimes, like I had a case, the wrongdoer was in jail. So the wrongdoer is not giving an apology. So who can, and how do we maneuver around that? And a good mediator, I think, can express an effective apology. So it's not to say, that only the party can give it. It's just saying, the party is the best, but there are also some other options too.
And I also think that the mediator can coach the apology. And this is sort of, you got to be kind of careful. You don't want them to give all their juice out, all their sorrow has come out. And then when you go have them actually do it in the other room, they're kind of flat because they've already done it.
Well, what happened in a big case I did was the CEO wanted to give the apology. And I had never met the CEO. I had the lawyer and I had the insurance adjuster, and was a number of cases, but I had never met the CEO. So when we were working on his apology, we did a practice session. We really did. We did a practice session. And I wanted to make sure that he used eye contact, that his body language was good. Because if you have a guy giving an apology whose arms are crossed and they're looking at the floor, it's not going to be as effective.
So in a minute, we're going to show you an apology scorecard, which is, you can score people if you want, like your husband or wife. Yeah, go right ahead. But mostly it is useful, I think, in preparing your client to give a good apology, or as a mediator to prepare someone. It's sort of a checklist of, do you have this in here or do you not, right? And then also it can be when an apology is given and the other side doesn't accept it, you can use it to pinpoint, they didn't talk about what they're going to do differently in the future. And you know what you have to correct. Okay. So you have this both. We'll show you the apology scorecard. And it's in an article that was attached that I wrote with another colleague about Will Smith's apology at the Oscars. We'll talk about that. So next
All
slide.
right, next slide. We're going to spend a little time on this, setting the stage for a good apology. So as CJ said, who is going to give the apology? All right, so that's a really important question, and make sure that it is the right person. When and where, so you want to set it up. Is it going to be at the mediation? Are you going to do it a week after the mediation? How and when is this going to happen? And live or by Zoom? And I'll tell you, pre-COVID, I would have said, an apology by Zoom? No way. And yet COVID has so changed our ways of interacting with one another, and certainly in the law profession, that I think there's some real benefit to giving an apology by Zoom. And here's why. If you're all present in person, let's say CJ and I are at USA&M. So let's say we've got, one party in one room, one party in another room. We're going to do this apology. You still have that awkwardness and that uncomfortableness of, okay, well, when I walk out the door, is this person going to be there? Zoom lets you have such a comfort level of, I'm doing this in my lawyer's office, so I know who's here and who's not here. Or maybe you're doing it at home and you know who's there. So I think a Zoom apology, I like it. I'm in favor. And I've done them. I think that's the important part, is I can tell you from experience, they will work. So who's present during the apology? Is the spouse going to be present, or other people with the person giving the apology going to be present? So this all needs to be orchestrated. It's a little bit like, you're choreographing a play. Really, because it's a ritual. This isn't going to change the structure of the deal, but what it is going to change is the mindset of the parties. And it can be just a critical, important element. So if you get to the stage, here's how to do it. Is there going to be a response? I think that's really important. Are you going to allow questions? And this is where, it's hard to choreograph, but you can at least make it clear. Are we going to allow for questions or comments? And part of that is, how long have you set this up for? Have you set it up? It's going to be just a half an hour. Is it going to be just 15 minutes? I would tell you to have a start and stop time. And generally they do go fast. People don't want to linger on all of this. So, will there be response? Will there be questions? Do you need to practice or to coach either side? And sometimes, what also happens? You get a mutual apology. One side wants to apologize in response. So that's cool too. If that happens, that's a good thing. Prepare for rejection. This is a good one, because sometimes the apology is, they want the apology, but they also want the ability to say no. And I tell you from a a mental health standpoint, that's probably not the healthiest place to go, but I understand, you know, sometimes you can't do that, but let's just make sure that we choreograph with the person giving the apology. What happens if they say, well, I don't accept your apology? You know what? That's okay. You gave it. That was the important part, but be ready for that, I guess, rejection. Okay, I think next slide.
So this is a couple slides full of the apology scorecard. And this is something that I drafted and worked with my students for years at WashU to try to perfect. We thought there's a website called perfectapology.com that had like 3 things you're supposed to do, right? So we ended up with much more. But what we looked how to use this, I think, is a couple of ways. One is to try to help your client if you're the mediator, help a party to sort of move through this if they're going to apologize. And also what I found is that it helps you to recognize what is it that people had a problem with. Before he passed away, Judge Cowden and I had done a federal training on apology, and he had said he had a big med malpractice case, lots of family members, and they got their number, they got their money, you know, fairly easily, but they just couldn't turn loose of it. And when he asked them, you know, getting to be 4 or 5 o'clock, he said, you know, what's the situation? They said, we just don't think that doctor really understands, is really sorry. And he said, I'm hearing it in the other room. Would it be helpful? And he coached the doctor and brought him into the other room. He basically went through something pretty similar to this, and they accepted the number.
So CJ, what would you do if the doctor wasn't there? I mean, I've had mediations where the surgeon or the doctor's present. And of course, that can be, you know, you can do it spontaneously and that can be great. But what do you do if he's not there?
If he's not there, then I think you have sometimes, God, it may be the insurance rep, it may be the hospital administrator. But I think let's kind of go through the good question. Let's go through those points to see if the hospital administrator could give, you know, could do this. There's some things they can do and maybe can't do. So let's look through it. So, and this is like you do a checklist. We use this with Will Smith's, 3 apologies after the Oscar slap. None of them were great, but anyway, first is they give a detailed account of the situation instead of saying, you know, what happened. It's like when this happened and this happened and that happened. Second is acknowledge their role in the event and situations. So the hospital administrator might have to say, we supervise Dr. So-and-so, or we set the standards and we have talked to him or her, right? So, but it's acknowledging what your part in, it's not, it happened, so sorry, it happened, this is what my role was. Take responsibility. You can have an explanation as long as it doesn't sound like an excuse. I was telling Kim, one of my least favorite things for somebody to say is, but you have to understand. No, I don't. So the idea, you might say, let me tell you how this all happened. People actually like that. They want to know how in the world did this all happen? Well, in the bicycle accident where it's hit by a driver, it could be, my baby dropped the bottle and I picked it up and I turned away. That's not an excuse. Should have kept your eyes on the road, but it gives some explanation of the situation, which people sometimes really want. Acknowledging the outcome. And I can see that this happened to you and you've expressed this and I didn't realize, but now I know that this also happened, right? Acknowledging what the outcome was. Next slide. Describe what they could have, should have done. I should have kept my eyes on the road. I should have taken more time with this. It doesn't have to be so much like I totally messed up, it doesn't have to be there. It is like, I should have had more options. I should have taken more time, whatever else, you can really craft that alternative to be as what somebody will be comfortable with, right? 6 is express sincere regret. This is the sincere part, the sincere regret for role and outcome. And that is where they've got to say, I'm really sorry that I did this and what happened to you. Right. They offered restitution, repair, or retribution. So sometimes I've seen people, obviously money, right, changes hand. But I've also seen people say, you know what, I am now going to do this from now on. I am going to take a class on this. I am going to take a hiatus from doing X, Y, or Z until I feel like I understand better. So
a charitable donation to a charity designated by the recipient of the apology.
There's kind kind of a famous case where a child died and the parents, the hospital planted a tree and a garden and a bench for the name of the child. I mean, so you would think that they wanted a lot of money, and maybe they did get some money, but this extra gesture really made a difference, right? Promise change improvement with a concrete plan. So, you know, Will Smith, if you think about it, at some point eventually said, I'm going through therapy about this. I'm stepping back from my work. But it's not just, I'm going to do this differently in the future and I'm going to work on this, but I have a concrete plan. Not like, and I'm going to try not to be so much like that. It is, I am going through these steps. If you think about police departments that have had to, in lawsuits, you know, make some sort of, when they've made a settlement, it is often, we are going to do this kind of training for all of our officers. That's the sort of thing we're talking about, right? If there's no concrete plan, it doesn't seem realistic. Now, number 8 is so amazingly important. You would think people are more worried about their own, you know, getting their own needs met, but people wanting you to learn from what happened is really key. It's a big issue to them. Listening to the aggrieved party. I mean, actually saying, so tell me, instead of just talk, tell me if I've missed anything, please tell me if there's more you'd like to say, right? Hopefully in the mediation, you have already had some listening. Next slide. You know, listen to the aggrieved thing, or was willing to answer questions. Now this is dicey, right? Like, you know, well, how much training did you have? Did anybody else help you? But sometimes it is, is there anything I can ask? And sometimes it's just, why didn't you do this? Or what did you think about that? Or didn't you notice this? And it can be very helpful and healing, which is the main thing we're talking about. Having people being in a position where they can move forward, and that may mean accepting your settlement. Now, the extra credit, this tells you that I'm a teacher, ask for forgiveness or other gesture of humility. I think eventually Will Smith got to that. I think he was saying, you know, I really have to explore myself, and I've just done so much damage, etc. But that really, if it's sincere, and that's the hard part, that can make a huge difference. All right. All right, next slide.
All right, I'm going to talk about acknowledgement. So think of this as apology light. Sometimes you need an acknowledgement of what went on, but you've got a client that won't go so far as to say, I'm going to give an apology. And, you know, that's okay too. If we can't get there, I would tell you, according to Robino's study, if it's a serious injury, because she flexed the scenarios a little bit and did one where the injuries were not so serious and one where the injuries were very serious. And when the injuries were very serious, anything less than a full apology had some pretty negative consequences. So this might be better in a lower severity, a case with less severity. But, you know, this is all, you know, talk about being in a gray area. We're more than in a gray area. We're so an acknowledgement is an expression by the offerer that they, you know, understand the situation. I think it's really important to always say, you know, this is not the outcome that we wanted. It's not the outcome that you wanted. We're, you know, we're sorry we're in this situation. We're sorry it had to come to this. I think that's that can be a useful thing to say. If you can, you know, this gets a little bit to the sandwich proposition, which is, if I'm going to say something to you that is negative, that you don't want to hear, and in negotiations it might be, I'm only paying $10,000, whatever. But if you can sandwich that negative statement with something positive on both sides of it, it can be really helpful. So I'll give you an example. My 24-year-old son lives with me. His friend was visiting this past weekend. They made a total disastrous mess of my kitchen and didn't clean it up. And I was not happy about that. So I needed to deliver a message to him. So what do I say? Seth, it was so fun having your friend here over the weekend. I really enjoyed spending time with them. But you guys were so busy. I didn't appreciate the fact that you didn't clean up the kitchen after you were finished. So maybe next time you can do that. And I hope he'll come back and visit, because he was a lot of fun. Did you notice that sandwich? Positive, negative, positive. And so this is a real life example. I'm not making this up. And you know what his response was? Yeah, you're right, Mom. We should have done that. And that's all I needed.
That was good enough.
All I needed. So think about that sandwich. If you can think of something positive that the party has done, this is a great time to bring it up. So using the example of the bicycle pedestrian, let's say that the pedestrian was willing to mediate this pre-suit. That's a great thing to say you're grateful for. Thank you for being willing to mediate this pre-suit. I appreciate it. And I do tons of pre-suit mediations. They can be very effective, and that's an easy thing to acknowledge. Recognition of the other side's perspective, recognition, I understand you went to the hospital after this. I understand, you had to have some additional testing done. So recognizing their perspective, which is different than your perspective. Okay, next slide, please. So you'd want to coach an acknowledgement much as you coach the apology, and what you can, you would want to explore this as a lawyer with your client. What is your client willing to say? Is your client willing to say, yeah, I was riding my bike too fast? Or is your client willing to say, yeah, I, looked in the back seat to get my child's baby bottle? The explanation can be really helpful. And, but think about it, you would want to practice this one too. Okay, next slide, please. We talked, why do it? Oh my gosh, this is so important. Why do this even apology thing? Because as lawyers, we walk away from the client when the case is done, but the client still has this scenario that they have lived through. And as a lawyer, you walk away and you're done with it, but they're still living with it. And as good lawyers, and I would tell you, we're also counselors, counselor approach the bench, that is part of our title. You want your clients to walk away from this dispute with a better mindset about what happened. And it includes their perception of the legal system. So if the apology can happen, or the acknowledgement, it shows goodwill, shows fairness, offers to build a bridge. I mean, if these two parties have to deal with each other in the future, so I do some education cases where we're mediating between the school district and the parent. Look, if you have a first grader, think about that. This school district and parent are going to be dealing with each other for another decade. So we want to build that bridge. We want them to be able to communicate with one another without getting their lawyers involved. So lots of good reasons to do it. But I think the most important reason is to let your client move on with their life and to have a much better perception of the dispute. Next slide. Who should deliver it? We talked about this earlier, but client is best. Sometimes if they're not available, the attorney can do it. And I'd want to coach with the attorney too. And I've heard, I guess this is what I would want to say. I've heard fantastic apologies given by attorneys. It's fantastic. So this also can be done. But if the mediator does it, so this is what happens. And I think this is so interesting. I'll say, okay, the other side is willing to give an apology for this. And, we can talk about the details of that, but they want you to know that that's part of this. And then we go on with the money. And the plaintiff will say, okay, well, we'll accept that apology. And then we move on and talk about the dollars of the case. The offer to give the apology becomes the apology. There's no apologies ever given. It has moved from the list of here's what we need to talk about to here's what we've already agreed upon. So no formal apology is ever given. Just the offer to give it becomes the apology. And I think that's really important. When not solicited or demanded, but we're in mediation, sometimes that happens. All right, next slide, please.
Okay, let's go, just because we only have like 7 minutes left. Let's forward
let's do the practice.
the facts employment discrimination, if we can go to that.
Rob, one more slide, please. Thank you.
One more still. Okay, we're gonna talk about it. So these are the facts, and probably we should maybe skip some of this. So basically, situation is that this person's still working at the office, which is a very important point. The employee's 30-year seniority, 10 years in management, 68, passed over for promotion, has been put on a performance improvement, demoted to a non-managerial position, lots of techno upgrades. We're seeing this a lot, obviously, right? Employees, employees, I'm sorry, request for training and educational support was denied. Right? This is kind of important. They asked for help and they didn't get it, right? So the new, and there's a fact, which is all the new hires are, millennials, Gen Xers, they're all new, 35 years old, et cetera. And the employee is claiming age discrimination. Okay.
All right.
Next
Next
slide.
slide. Yeah. So you get into mediation over this case. What should not be said? Go to the next slide, please. I'm sorry, but you're failing to keep up with changes. I'm sorry about that demotion, but we needed the slot for someone else. Notice all of these have one word in them, which should never be in an apology. The word but. I am sorry, but. I am sorry about your demotion, but. Okay, leave the word but out. Any excuses, leave them out. You can ask, can I explain to you what happened? And if they say yes, give that nice explanation. But I'll tell you what, most of the time, the plaintiff knows what the explanation is. So you're not giving them any information they don't already know. Okay, next slide, please.
So should you begin with acknowledgments? Do you have any suggestions to this? Should you bring up their performance issues that they were put on a PIP for? Can you imagine anything the employer could apologize for? And that's our question. So, Rob, I don't know if you've had any comments so far. Otherwise, we'll go to the next slide in a second, which will give our proposed apology. Okay, so this is not perfect. This is just our idea. Tom, you've been a valued employee for many years. You were one of the first people hired when we opened the Missouri office 30 years ago. You provided leadership and support, especially when you managed the Creve Core office. That's acknowledgement.
So who's giving this? Could it be the director of HR? Yes, right?
Sure.
Could it be the supervisor? Yes. Could it be president, CEO of the company? Yes. I mean, those are all, I think, good people who could give an effective apology to say this.
And sometimes people they hate the person in question so much that it would be nice to have a little remove and have somebody else. So like when we think of the Catholic Church priest cases, it wasn't the priest usually who gave any apology or acknowledgement. I'm pretty sure. I'm pretty sure it was some other representative of the church. So, but so that was the nice part, right? Then they have clearly things have changed over the years and we've become a techno-heavy industry. I think we owe you an apology for not honoring your request for additional training. We had a set training plan and budget, but we should have reconsidered, explored your request. As you've said, the denial of this request caused you to question your future at the company. Now, you may at some point have to say some other bad stuff like this isn't going to happen or whatever, but to the degree that the company could apologize for something and just say, you might even consider that an acknowledgement too. Like we acknowledge we probably could have been more open. And so maybe that's one of the offers. If you stay here, we will give you more. We'll give you a little bit more, training, et cetera.
Yeah. And it's funny in employment cases, training comes up a lot. You'd be surprised. They want training. Sometimes the disgruntled employee wants the supervisors to be trained. I mean, we will talk about training. So it's an important, again, it's another tool in your toolbox.
And it's really sometimes a part of the offer, as you mentioned, part of the offer contained an acknowledgement. We would like to offer training. We would like to offer something else because we know that this might help, or we acknowledge. Do you want to talk about the absence?
Yeah. So if you'll notice back when we gave you the scenario, this employee was 68 years old. So in mediation, I think what would happen typically in cases I mediate is we would be talking about the departure of this employee and what would that departure look like, when. And here's something I love, and I think it is underutilized, which is leave of absence. So maybe you want a 1 month, a 6 month leave of absence. Is it paid? Is it unpaid? Is part of it paid, part of it unpaid? Maybe we do maybe you would go from being a full-time employee to part-time or to being a contract employee. And if we do that, how do we get you benefits? And these are all super good topics that you can talk about in mediation. You have the cloak of confidentiality, but it's real world stuff, because if your 68-year-old employee hates technology and wants to leave, this can be a wonderful way to talk about what that departure is going to look like.
So we wanted to throw it out to you all and to Rob, if you have any perception, any questions you have. Would you say, I would never say that, have my clients say that in a million years, or I don't think as a mediator that would happen? Any comments about something we missed that maybe you would want to include, or obstacles you've met in trying to do apologies?
Yeah, we would love your comments back as chats to Rob. I think that's how he wants them. But I really like what we've written, and I could see this being given in a mediation, and I could see the mediator giving this, especially depending on, let's say you have the insurance adjuster and the lawyer at the mediation. Neither one of them are going to be maybe the best person to give it. I could definitely see the mediator giving this and it being effective. And
I think yes, I agree. And I think it's an interesting thing that's happened to me many times as a mediator. I don't know about for you, Kim, but where people say, do you think they're really sorry? Do you think they really get it? Particularly if you're giving something, you say, look, here's what they told me they'd like me to convey, et cetera. And they're like, do you really think so? You're put on the spot to, what do you do with that? I mean, it's got some confidentiality aspects to it. It's got some evaluative aspects that are a little uncomfortable. I know that in the case I was telling you about, where Judge Cowden had the big family whose I think grandmother had died, he said, oh, I'm telling you, he is so sorry. I'm hearing that in the other room. You're just not hearing it here.
And what you can do is go back to the offerer of the apology and say, hey, they've asked me this. Here's what I'd like to say. Or why don't you, let's talk about how you'd like me to answer that, because I'd like to tell them that you feel like you're taking this very seriously. And as CJ alluded to earlier, the idea of what are we going to do in the future to make sure this doesn't happen again? Ooh, that can be so powerful.
Rob, did you have any comments, questions from the group?
So I didn't see anything in the chat, but a couple of things I'll mention, and that is how I see this in practice.
Yeah.
In premises cases, when I have a defense representative, literally first words out of their mouth, we are so sorry you had any problem at our store. You are a customer. That's important to us. We're here to work out your claim, and we're going to work hard to do that. And thank you for participating in this mediation. When that is the lead, because you talked about when to do it, it takes the air out of the room. The plaintiff, when I meet with them separately, are not thinking the evil empire is in the other room. And it's just, I think it's very effective. And Kim, you mentioned the issue of an apology over Zoom. And I agree with you, it can be very effective. And one thing it can do is allow the party making the apology, allow a senior executive, like a CEO, who otherwise may not be flying to wherever it may be for a mediation or a negotiation, but to appear by video on a Zoom and say, this really is important to us. We are so sorry this happened, and we're going to do X, Y, and Z. I had a case yesterday. You look for non-economic parts of an apology or acknowledgement, where an institution said, as part of their offer, we agree to provide training so what occurred in this accident will never occur again, will never harm a family like in this circumstance. We're going to do that in craft materials in the next 90 days and have this training done in the next 6 months. We will provide a draft of the training to the family.
Wow.
And they can make some comments that, again, help so this never happens again. That non-economic component I think was critical to settling a.
And Rob, that is music to the client's ear. It really is. And I love what you said in the beginning about coming into the mediation with, you're a customer. We are so sorry this happened. I mean, that really can be a wonderful opening. And you're covered, the cloak of the confidentiality and the mediation covers that. A couple other things I've heard people say in mediation that I thought was really helpful is we want to make things right with you. We can't go back and redo this. So in our scenario, we can't go back and redo our decision to not offer you training. But what we can do is, whatever, and then whatever you're putting out there. So there are some good ways to do this. And I think.
Could I add one thing about what you're talking about, Rob, about the concrete plan? One of the assessments of a mediation and settlement is, do the parties believe it's really going to happen? Each side's going to do what they say. When you have a concrete detailed plan like you're describing, such an increase that it actually, in belief that it'll actually happen.
Yeah, sometimes they'll even suggest, like, we like the training offered by this company.
Yeah.
And we've, gone back and forth, and I can't say that that's accepted very often, but it is a concrete plan. So we would love to hear about your experiences with apologies in any kind of settlement discussion or mediation. So we've given you our names and numbers and email addresses. And I'm really serious, because this is an issue CJ and I are, we came to it independently, but we love it and we know it's important and we've seen it work. So thank you. And Rob, I think we're right on time at 9:55. You want to say?
Thanks very much. Guys.
CJ and Kim, thank you so much. This is a terrific topic. We see it almost every day in the mediations that we conduct, and bringing in both the research that you have done in conjunction with Professor Robinol, and then the practical side of your personal experience has been terrific. And I ask everyone, take a look at your materials article. Very good.
Well, this is useful in life. It's not just useful in litigation or mediation. It can be useful in life.
No question. Kim, thank you. CJ, thank you. Folks, we're going to take about another 4 minutes or so, and then we'll get started with Marc Lapp talking about updating us on ethics. Thanks so much. Marc, good morning.
Good morning. Rob, do you want me to take control of the presentation from my end? Can I do that?
Yes, I made you a co-host.
Okay.
You should be able to share your screen so that you control your PowerPoint.
I'm gonna try that.
There you go.
Good.
All right. So give it a couple of minutes.
Take your time.
I'm gonna go get a little more coffee and I'll be right back. Okay, folks, we're thrilled to have Marc Lapp, who's been practicing now, north of 35 years, to bring us current with some recent changes in ethical rules, as well as bring us some new cases in this area. Marc is with the as lead attorney for Nationwide in the ethics training, business operations, but he also serves as a special representative to the Office of Chief Disciplinary Counsel. And in that role, he knows these areas and keeps us up to date. And Marc, thank you again for today and as well as your prior programs.
Thanks, Rob, and good morning. Good morning, everybody. My pleasure to speak with you and bring you up to date on what's been a very, very busy year in the world of ethics in Missouri. First, I want to just acknowledge Kim and CJ said some very important things that are relevant in the ethics world. One of the big mitigating factors, if you ever find yourself facing an ethics charge, is to own it, is to apologize, is to take responsibility. That goes a long way with respect to the people who ultimately will make the decision regarding your license. So apologies are good in multiple places in the law. As Rob said, my night job is special representative of the OCDC. What that means is I assist the 2 regional disciplinary committees in the eastern side of the state of Missouri. Those regional disciplinary committees we refer to as Region 10 and Region 11. Those are named in Rule 5. Region 10 covers the judicial circuits 21, 23, and 11. If you don't recognize those, St. Louis County, Jefferson County, and St. Charles. Region 11 covers Judicial Circuit 22, which of course is the city of St. Louis. Who are the regional disciplinary committees? Those are committees that are composed of lawyers and non-lawyers, and they are the ones who will make the probable cause determination about whether there has been a violation of one or more of the rules of professional conduct. My role is to assist them, walk through the applicable rules, help get the conversation going. If they need more of an investigation, such as the presence of the attorney or the complaining party, I will arrange that. If they need documents that require a subpoena, I will issue that. But I do not participate in the vote. It's the group of individuals that are part of those committees that do that. I always want to give a plug to those folks that volunteer. It's a very rewarding job. I think it's a very important job for any lawyer who's interested in ethics to volunteer to be part of. It's a term of 4 years. We meet monthly. The committees meet monthly. And if you'd like to be part of it, you can send me an email and I'll ask for you to send me your resume and cover letter of interest. And I will get it over to Laura Ellsbury, who will then submit it to the court. And you will hopefully then be appointed to be part of one of those committees. So if someone wants to do that, interested about it, just reach out to me and I'll be happy to get you involved. As I said, it's been an extremely busy year with ethics, unusually so. First, I'm going to talk through statistics. We're actually going to look at statistics over the past 5 years, which includes COVID, which has really altered the statistics significantly. Then new Supreme Court Rule 5. Rule 5 is kind of the administrative and clerical world of how a formal complaint is handled, processed, goes through the system. It's a rule that if you want to read it, it certainly provides insight into how our system works. If you are an attorney that is the recipient of a complaint or formal charges, you will want to be absolutely familiar with Rule 5. I will just hit some of the highlights of Rule 5 as part of my presentation. There were 3 Supreme Court ethics opinions that were published over the past court calendar year, which is just unheard of. Most ethics complaints are resolved with the opinion is issued, I should say, with a 1-page memo from the court saying either there was no violation, period, or there was a violation of Rule 1.4, for example, and then the second paragraph says what, if any, sanction there will be. The facts of the case are not put into those memo orders, but once in a while the court has something to say about the ethics rules. Maybe they want to make a point, maybe there's some disagreements with respect to the final decision. I've never seen 3 in 1 year, and I'm going to go through those with you. And then finally, my public service announcement. If you haven't heard, effective July 1, there is a big change with respect to filing pleadings on CaseNet, you, as the attorney, are now responsible for redaction of personal identifying information, of names of minors, names of certain types of witnesses. Basically, the court clerk is no longer going to do the redaction for you. You, as the attorney, are going to be responsible for that. I'm going to talk about it briefly, and then I'm going to refer you to the Missouri Bar website, where there is a webinar that they have. I noticed on my latest edition of the Journal of the Missouri Bar, the front cover asks, "Are you redaction ready?" So this is big stuff, and you're going to have to start to understand what needs to be redacted, and have your staff or you knowledgeable about the redaction tools that are available, so that you don't run afoul of this new court operating rule. So here we go. Let's start with statistics. This is over the past 5 years. This looks at the total number of disciplinary actions taken by the OCDC and the court. First, let me define what a disciplinary action is. On the lowest end is what we call a letter of admonition. It's something that can be issued by one of the disciplinary, one of the committees, the Region 10, Region 11 committees that I talked about, or another committee across the state. The OCDC can issue what we call a letter of admonition. It's the lowest form of discipline. It basically it usually involves something that is not so significant that formal proceedings need to be started. It can be for a variety of reasons. As you'll see, we're going to talk about two subjects of lawyer conduct that takes up a lot of these letters of admonition, but that's the first level. The second level can occur once a formal charge is filed and a hearing is held, and a decision by the hearing panel is recommended, and then the court comes through and issues what that final discipline will be. The first level that the court can administer is what we call a reprimand. A reprimand does not affect your right to practice law, but your name will be published in the Missouri Bar, and everybody will know, and perhaps your clients will know. It's serious, but it is not so serious that you're going to lose your right to practice law. The next level up is a suspension. A suspension can be an actual suspension from the practice of law, which means you have to notify your clients and you have to stop practicing law. And that, of course, is a big deal. The court can stay a suspension, which means that you're allowed to continue to practice law as long as you comply with some probation terms. They can just put you on probation without a suspension. I've seen that before. Then finally, of course, is a disbarment, which is the most significant, the most severe form of discipline. As you can see, over the past years, our total number of disciplinary actions has fallen quite substantially. I think COVID is a big reason, certainly in 2020 and 2021. I'm not sure why we came down a little bit in 2019. If you look through the statistics of years before and decades before, we kind of are in that 130 to 150 range, as a profession. But for probably COVID reasons, we came down pretty significantly, and I expect it to tick up as there's more and more live court appearances and more opportunities for lawyers to find themselves in violation of the rules. Here's a statistic that should not surprise you at all with respect to the nature of complaints, the nature of the reason why someone would file a complaint. These are the top two reasons. It's been true since I've been doing this for 20 years. Sure, if we go back since the state has been founded, whenever whatever disciplinary system was around then, whether it was bar associations or the courts itself, communications with clients and diligence in working on your case. Those two are the number one and number two reasons why lawyers receive complaints. And as you can see over the last 5 years, that has remained very, very consistent. You might ask yourself why communication and diligence are the highest, have the highest numbers of complaints, usually by clients or former clients. It's because they want to hear from you, right? This is a big deal to them. The rule is simple. A lawyer shall keep the client reasonably informed about the status of the matter. I need to spell better on that. And they need to promptly comply with reasonable requests for information. The comment kind of says it all. If you need some instruction here on communication, a lawyer's regular communication with clients will minimize the occasions on which a client will need to request information concerning the representation. I always tell lawyers, you know what, when you have a client, especially a new client, you need to tell them what they should expect by way of communication, how often they should expect to hear from you, when they should expect to hear from you, how long is it going to take to return a call when they make a request for information. Since when a client makes a reasonable request for information, the rule requires prompt compliance with the request. What that means is either you return the phone call in 24 hours, I would recommend, or your legal assistant returns the call and says that you, the lawyer, will be returning the call personally at a certain date or a certain time, if that's what's required by the request. Here's a quote that I found that I think really sums up the emotions behind what can cause a complaint against a lawyer. While it may just be another case to you, it is important to remember that may be the most important issue in your client's life. And I know we all recognize that, but sometimes it's good to remind ourselves how important it is to the client that you're serving that they hear from you and that you communicate with them and that you return their calls. Diligence, again, nothing new here, a very simple rule. A lawyer shall act with reasonable diligence and promptness in representing a client. This comment says it all, in my opinion. Perhaps no professional shortcoming is more widely resented than procrastination. A client's interests can be adversely affected by the passage of time. Even when the client's interests are not affected in substance, unreasonable delay can cause a client needless anxiety and undermine confidence in the lawyer's trustworthiness. So again, up front, what you should be doing with your clients, particularly your new clients, is explain to them the legal system. How is this going to work? How much time is it going to take? The fact that there's going to be large periods of time where it appears that nothing is happening. If you explain it to them and that they know what's going on and they know bad things aren't happening, that can reduce anxiety and that can reduce the chances of a complaint by a client against the lawyer. So now that we know what they complain about, which types of clients are the ones most likely to file a complaint? You lawyers in the domestic arena and in the criminal law arena know this one well. You serve clients that statistically have the highest chances of filing a complaint against you. I could open it up, but a lot of the reasons why should be apparent. People that need your services in the domestic or criminal arenas are very, very vulnerable, right? They've spent, they're finding themselves in a situation that is extremely angst-ridden. They've spent a lot of money on you, perhaps, in the criminal world, the family of the defendant, your client, has spent a lot of money on your services. When something goes wrong, when the result isn't what they expect, they feel that you're just part of the vast conspiracy to deprive them of what they believe are their fair expectations from the legal proceedings. Anytime you have individual clients that are spending money on you, that are in vulnerable circumstances, unfortunately, you are more likely than lawyers in other practice areas to receive a complaint. That doesn't mean you've done anything wrong by any stretch of the imagination, but it's just a statistic that we gather, and domestic law and criminal law are always 1 and 2, or they switch year to year. And that's been true for the years that I've been doing this. Some good news in the world of statistics from the OCDC. Overdraft notifications from the banks that hold your client trust accounts have drastically decreased since 2015, actually, when a law went into effect that requires the bank to notify the OCDC in the event that a lawyer bounces a check from the client trust account. Okay, if you didn't know that, you know it now. If a check is bounced out of the client trust account, that's just something that should never happen, because the money in the client trust account belongs to the clients, doesn't belong to you. As long as you're keeping records and you know whose money is in there, there should never be a reason that a check bounces. If a check bounces and the OCDC gets notified, guess what? You're going to get a phone call from Kelly Dillon. She is our forensic investigator, and she's going to ask why. Sometimes it's going to be innocent, an innocent explanation. It's not going to be any problem. Once in a while, funds get deposited in the wrong account. It's something that can be rectified quickly, and Kelly is there to help make sure it never happens again. But sometimes a bounced check reveals much, much more. It reveals sometimes that you are not keeping proper records, that perhaps you're commingling funds, perhaps you're misappropriating funds. If she suspects that, she's going to issue a subpoena to your bank, and she's going to look through your bank records. And that's usually not a good thing for a lawyer, because that I describe it as a CT scan of your law practice. Whatever you're doing wrong in your law practice is going to be reflected in those records of how you handle your client money, or how you handle your operating account money, for that matter. So the good news is the word has gotten out that proper record keeping is important for lawyers, and therefore the numbers of bounced checks has gone down. So terrific news from the OCDC. Moving on to new Rule 5. Again, Rule 5 is the rule pertaining to attorney disciplinary matters. It's been 20 years approximately since it's been revised in any significant way. The court, I didn't even know this was going on until the new rule came out. The court's obviously been gathering data and anecdotal stories of disciplinary matters handled before a hearing panel or before it, and they've decided to round out some corners, fill in some gaps, provide some clarity to us at the OCDC and to the lawyers that are either the subject of a formal action or even just a complaint, as well as the lawyers who represent those lawyers. I just want to hit on these bullet points. You can see how wide-ranging these changes are. Some are minimal, some are major. The first one is it actually codifies for the first time that we can issue you what's called a guidance letter, which is not a form of discipline. It's just some friendly advice. What it says is basically that the disciplinary committee or the OCDC did not find a violation, and therefore the complaint will be dismissed. However, and it's the however that is the guidance that we will offer, and we'll offer our guidance. We'll say, you know what, next time you face a situation like this, you might want to consider A, B, C, and D so that you don't find yourself violating a particular rule. So we've been doing guidance letters since I've started, but this is the first time that the court has actually codified it. And now the guidance letters are part of the system, and you'll see in one of the cases that I'll describe, if you don't take the guidance letter seriously, that is going to work against you if you actually violate that rule in the future, since you've been warned about it in the past. The second bullet point allows the chair of the advisory committee to exercise his or her discretion to permit the filing of an answer out of time upon a showing of excusable neglect. The court wants disciplinary matters to move quickly through the system. They don't like a lot of delay. If somebody is going to ask for more time to answer a lawyer complaint, the chair can give that permission one time, and that's now been codified in new Rule 5. All of our hearings, if possible, are held in person. That became quite problematic during COVID. We obviously continued to have hearings, but they were all over Zoom. We had a problem allowing the public to participate and not just jump in and say something during a hearing. Hopefully we've fixed that. We have the OCDC in Jefferson City actually run Zoom hearings when we have them, but I haven't had a Zoom hearing now in over a year and a half. Everything's back live, and they are public proceedings, and the court wants the public to be able to attend and at least see and hear things if they're not going to be held in person. The next bullet point is if you've been disciplined in another state, you need to report that to our state within 10 days. The next bullet point talks about winding up your practice in the event you've been suspended or disbarred. The second to last bullet point raises an interesting point if you didn't know it. Lawyers who find themselves in receipt of a reprimand, a suspension, or a disbarment, there are court costs involved in that, so to speak, that go right to the advisory committee that help fund the disciplinary system. And there are also fees involved if a lawyer is seeking reinstatement following a suspension or a disbarment. And the fee for that reinstatement is codified to $1,000. Finally, the last bullet point, I hope you all know that we have a lawyer. Her name is Melinda Bentley. She's the legal ethics counsel in Missouri. If you ever have a question about ethics, am I doing the right thing? Am I going to violate a rule? What do you suggest? She will give you confidential advice. And she has, under this rule, no obligation to report you. Of course, she won't. It's confidential communication with you that you can, in fact, rely on in the event that somebody later complains about your course of conduct. The fact that you received advice from Melinda will obviously work in your favor, but this clarifies that she doesn't get into any trouble by keeping things confidential. Okay, as I said, there were 3 significant ethics opinions this year. They're all worth reading, if nothing more than the drama that each one of these goes into great detail about. In Re Hester, which I'll talk about in a moment, has to do with mishandling of client funds. I've got to tell you, there are 2 big no-nos in the practice of law. Number one, misappropriating money, right? That's why lawyers are held in such low esteem. Everybody thinks we're stealing money. And in those times that we are stealing money, stealing client money, the court has no quarter for you for that. And In Re Hester goes into great detail. And actually, the result was a disbarment, and you'll see why. In Re Pruitt has to do with a judge. A judge in his status as a judge and in his status as a lawyer with respect to some misconduct that he engaged in. Was worthy of opinion. And then a 4-3 decision that the In re Purdy case that has to do with the second big no-no in the practice of law. And that is a lawyer having sexual relations with a client, or sexually harassing a client, or sexually harassing anybody involved in our whole system of law. Again, a big no-no that's always going to result in a suspension or disbarment, but a little bit of a controversial case, and we'll get to it. So I want to just kind of go forward. Again, you can pull these up. I just cut and pasted the overview and the outcome that Lexis had, but I do want to get a little bit into the weeds about each of these cases so that you understand why the court did what it did. So Mr. Hester is a personal injury or workers' compensation lawyer. He was given what we call a guidance letter back in 2011. We called it a cautionary letter back then, but he was given a guidance letter that he should pay attention to the trust account rules in Rule 4-1.15, and that we recommended he registered for a course that we put on called Fundamentals of Trust Accounting, and to report his attendance. So he was told what to do over 10 years before this case ever came up, and that was going to be part of his undoing. He had a significant number of rule violations that the court went into great detail in describing. This is one of Judge Robin Ransom's first opinions, happens to be in the ethics realm. And again, the detail of it should be fair warning to anyone that handles client money, that you need to have good record keeping, get a good computer software system in it. If you're really lost in the area of how to take care of client money, attend the course on Fundamentals of Trust Accounting. There are so many resources out there that will help you not fail in the area. So what are some of the things he did or didn't do? Number one, he failed to deposit an insurance settlement check into his trust account and failed to notify his client that he had received the check. As to another client, he failed to explain what his fee would be for reducing liens and provider bills, and by providing financial assistance to his client, which is a separate violation. As to two of his other clients, Mr. Hester violated the rule of, again, advancing funds, and actually asked his client to sign a waiver limiting the client's ability to sue Mr. Hester for malpractice. That's another prohibition in the rules in Rule 1.8. You cannot have a client sign a document limiting his ability to sue you for malpractice. And he did that. Obviously, the client wanted his money, and he was going to sign anything to get his money. That was a problem. He gave one of his clients a check from his trust account that was not money that belonged to the client. It belonged to another client. He did not pay a full settlement, a full agreed settlement to a client. He kept some of the money himself and deposited it in the operating account. He did not take care of his promises of fighting some liens on some of the medical bills that he was supposed to negotiate on behalf of his client. And again, he misappropriated client money. Kind of in summary, the court said he commingled funds. That means he mixed client funds with his own funds. He failed to reconcile his trust account. He failed to pay money owed to his clients. He failed to maintain adequate records. The aggravating factor, big aggravating factor, is that he failed to attend that trust accounting course that he was told about 10 years ago. He failed to resolve his trust account problems after Kelly began auditing his client trust account. An audit occurred simultaneously with investigation of the complaint. He didn't cooperate with us, the OCDC, when we were asking for questions about his financial documents. He engaged in conduct resulting in a financial benefit to himself and a loss to his clients. The court found his conduct to be pervasive and to have impacted a large number of clients, and his engagement with the disciplinary proceedings impeded an efficient resolution. As a result, Mr. Hester was disbarred from the practice of law. This case is one of 2 or 3 cases now that have been released by the court about mishandling client funds. The next case, in Ray Pruitt, is a little bit of a different matter. Mr. Pruitt was Judge Pruitt in Macon County for about 7 years until 2018. Back in 2015, while he was a judge, the court actually represented Judge Pruitt for a number of things. First, for threatening involvement in a circuit clerk's candidate's campaign if she did not remove his opponent's sign from her yard. He made social media posts encouraging others to attend certain charitable events or make donations to certain charities. That's a no-no. He made another social media post criticizing other judges. That's never good. And he pressured a prosecutor to dispose of a case because he wanted the defendant to play football. I don't really know what that's all about. I'll have to reread the case again. But those were some of the things that were complained about. In 2020, the Chief Disciplinary Counsel sought to discipline Mr. Pruitt. He was no longer a judge anymore for his activities during the 2018 re-election campaign for Associate Circuit Judge. So we've got a judge/lawyer who's already been reprimanded for a number of things. Then in 2018, in his re-election campaign, he started to harass his opponent on the ballot. He threatened to file an ethics complaint if she ran against him, and indicated that he knew about her husband's infidelity. So his opponent in the campaign, he threatened to let the world know about her, the candidate's husband's infidelity. How did he know about that? Because he was a divorce attorney as well as a associate judge. He was the divorce attorney for one of the women with whom the other candidate's husband had an affair. And therefore, it was confidential information that he had with respect to his divorce representation, and he threatened to release that to the public if his candidate ran for office. Turns out that Mr. Pruitt, Judge Pruitt, lost the election, which I guess is a good thing, but the court was very upset for all of the harassment that he engaged in during the re-election campaign. They noted his prior reprimand, and they issued a suspension. I believe this one was for 18 months, either 1 year or for 18 months was the appropriate discipline as found by the court. Again, the reprimand was an aggravating factor. So if you're interested in the rules of judicial conduct and the rules of professional conduct with lawyers and how those two interact a bit, you can read that case. And again, just kind of a lot of drama. Speaking of drama, this case, and I've got a particular problem with it because I do try a lot of cases before the hearing panels and before the court. And this one involved sexual harassment and sexual advances of 6 very vulnerable clients. Mr. Purdy, who was admitted to practice law in 1966, so a little bit older. He had a number of clients, and there was video footage in one of the local jails that showed him pulling. In one case, his behavior included pulling the woman into his body, reaching underneath her jumpsuit and kissing her on the mouth. And this happened to a number of women he was representing, according to a video that was taken in the jail. In March of 2021, there was another video footage from a different courtroom showing Mr. Purdy touching his female client's buttocks. In September of 2021, there was another video that shows Mr. Purdy reaching across the seat, placing his hand inside his client's blouse and touching her inappropriately. As I was reading the case and getting more and more steamed and fully expecting there to be a disbarment, since I have handled a number of these types of cases, I was a little bit shocked to determine that we had a 4-3 decision here. The court doesn't often engage in 4-3 decisions in the world of ethics, but sometimes it does. And this one, it did. And the court did not disbar him. The court suspended him for 1 year. The majority spent a lot of time in the opinion talking about how difficult it is to get reinstated, but for some reason chose not to disbar Mr. Purdy. I think the story came out a little bit in the dissenting opinion, and I want to take the time to read it because it's quite insightful. This was Judge Fisher who wrote the opinion. Judge Wilson and Judge Powell concurred, but let's go through it. Judge Fisher says, "I must dissent. I, like the disciplinary hearing panel that heard the evidence in the case, am of the opinion that Dan Purdy should be disbarred. In light of the egregious and outrageous conduct perpetrated, I am deeply distressed that this court merely indefinitely suspends Mr. Purdy with no leave to apply for reinstatement for 1 year. Implicit in the principal's opinions analysis is that Mr. Purdy only needs to be indefinitely suspended with no leave to apply for reinstatement for 1 year because of his advanced age. In my view, neither the race, gender, ethnicity, nor age of an attorney should be taken into consideration to determine appropriate discipline. In my view, Mr. Purdy's conduct, which was clearly and explicitly depicted in the video evidence, warrants disbarment. The Missouri Bar has 17,000 lawyers. When I took my oath of admission in '88, as of 2023, we have 30,700 lawyers, approximately 1 lawyer for every 200. It is inconceivable that we will deprive the public of adequate legal representation by disbarring a few of those who prove themselves unqualified to represent the public because they attempt to seek sexual gratification from their clients. There may have been a time when a temporary suspension was an adequate punishment for sexually assaulting or harassing a client, vulnerable or otherwise, but in my view, that time is long gone. This court should disbar Mr. Purdy." That's what I thought, but and perhaps as the dissent is saying, there was consideration of Mr. Purdy's age. And again, the majority opinion spent a lot of time talking about how difficult it is to be reinstated and basically implying that Mr. Purdy's never going to get reinstated. So, don't worry about him being out there assaulting women. I don't know why the majority opinion was necessarily focused on his age, if they in fact were, but that's what Judge Fisher felt, as well as 2 of the other judges. Whenever I have a 4-3 opinion, I look at it very closely because there are lots of clues for me in the world of ethics, and there should be lots of clues for you in terms of how the court might think of your areas of practice. The latest 4-3 decisions in the world of ethics, again, the one we just talked about, Mr. Purdy. There was another one in 2019. I spoke about that back then, in re Scott Gardner. Scott Gardner was a case, it was a probate lawyer that decided to take his fee early. The court had entered an order denying Mr. Gardner the right to take his fee early, but he took it anyway. I thought for sure that was going to be a suspension case, but the majority in the court at that time, Judge Stiff, Judge Draper, Judge Russell, and Judge Breckenridge, they felt that Mr. Gardner needed education more than he needed discipline. They pointed out that he was entitled to that fee anyway, and even though it was wrong to take his fee early, and even though it was wrong to disregard the court's order, they were only going to reprimand him and basically saying he can be rehabilitated. You can see in these two cases that the group in dissent are the same judges: Judge Fisher, Judge Wilson, and Judge Powell. Why is that of interest to me? All you have to do is look at the Missouri Lawyers Weekly's analysis of the Supreme Court's voting record over the year that they gathered these statistics. This was back in October of 2022, so it doesn't include the Purdy case. But look at the three judges that vote the most like together: Judge Fisher, Judge Powell, and Judge Wilson. What does that mean to me as an ethics lawyer? I know that those judges are by the book judges, that things are pretty plain to them. Things are pretty black and white when it comes to lawyers engaging in misconduct. And I kind of know that if I've got a case, it becomes adversarial at that point when I'm in front of the court and I am seeking discipline. I'm talking to those three. Those three I usually have a good feeling about. The other group, that group's going to change pretty quickly. I know Judge Draper is aging out. I think Judge Breckenridge is the other judge that is aging out, all within the next year. And you are going to see two new appointments to the court. And I will be interested to see whether the court becomes more uniform in the world of ethics or remains kind of split down the line. Again, you can carry over this analysis and analyze it however you want. This is just me reading the tea leaves for what I do. You can try and read the tea leaves of what you do. I'm sure all lawyers try to do this. All circuit court judges try and do this to determine if they're going to be overruled, perhaps, if the case gets up to the Supreme Court. But my takeaway is that Judge Fisher, Judge Powell, and Judge Wilson read the rules pretty plainly with respect to the cases and take lawyer discipline and our profession, at least with respect to the sanction. I'm not going to say any more seriously than the other judges. They all take it very seriously, but these three, I think, feel that discipline rather than something less, or at least the level of discipline should be a little bit higher than the level of discipline perhaps that the other courts are considering, at least in certain areas. So there you go with respect to the three opinions, and then the big 4-3 split in Purdy, and how it all looks when you kind of look at all of the decisions by these various judges. All right, the final topic. Again, this is a public service announcement. This isn't just me talking to you. The whole profession has been trying to talk to all of us over the past few months. You all need to go to the MOBAR website, please, and take a look at their page on remote public access and redaction. They have a resource center. They have a CLE that I took it live back in April. It's recorded. You can sit through it. It talks about what's going on. And what is going on is that the public is now going to have much broader access over CaseNet than they've had before. And because the public is going to have access, we all need to take responsibility for redacting those items, those words, those individuals that need to be held in confidence and not be released to the public. Some easy examples are social security numbers, bank account records, right? Dates of birth, names of minors, maybe names of victims. There are various laws out there which tell you which types of information needs to be held in confidence and therefore needs to be redacted. And by going through this webinar, by reading your Missouri bar article on making redactions for the public good, it's called, by reading that and understanding it, and then making sure you have access to software that allows for easy redaction, that is going to be key starting July 1st, next month. Again, the reason for the court rule is the change in the court operating rule is because the court is very big on public access and transparency and is opening things up to the public. No longer will the clerk of the court or the clerk's staff be doing any redaction for you. It all is going to be the lawyer's responsibility. So, here's the basic rule. It says, unless otherwise ordered by the court, any counsel, any party, or other person offering a document for filing in any court shall redact information that is confidential pursuant to statute, court rule, or order, or other law. Such confidential information can include, but is not limited to, and as I've said before, social security numbers, driver's license, tax ID, financial institution account numbers, names, addresses, and contact information of informants, victims, witnesses, and persons protected under restraining or protection orders, dates of birth, names of individuals known to be minors, case numbers of confidential, expunged, or sealed records. Filers should also exercise caution when filing documents that include medical records, employment history, financial records, proprietary information, or trade secrets. There's a lot in there. I cut and pasted some slides that are part of the webinar on the Missouri Bar website. Says the same thing that I just read to you, just shows it in a different format. Here are the citations for 2 statutes which talk about the types of information that should be confidential, the types of court proceedings. You can guess, obviously, in the domestic realm, in the criminal realm, there's a lot of personal identifying information, a lot of requirements on redacting and maintaining confidentiality. Those 2 are just 2 of the statutes that talk about confidentiality. If you read the article in the Missouri law, in the Missouri Bar Journal, they talk through some other statutes that reference confidentiality. Again, you should read that and become familiar with it. By the way, the software that's out there is very easy to use. There's search functions that, search for particular names, search for particular types of numbers for exactly. They'll pull it up and give you the opportunity right then and there to make a redaction on each individual one, or to make a document-wide redaction. Kind of sounds harder than it really is once you do it, or once you have somebody trained in your office to do it. The key things is that it needs to be done. You're not going to get in trouble by the court if you don't do it. The court will not review. No, let me say that again. I'm sorry. The court's not going to review your documents for redaction. Okay, they're not going to review each case to ensure compliance, and they're not going to refuse to accept or file a document on that basis. Who you're going to get in trouble with is probably the party whose information you didn't redact. There might be a privacy violation or something provided by statute. Court business will go on, but the responsibility rests solely with the lawyer who is filing the document. Then, in addition to filing a redacted document, and how about this one? There evidently is going to be a button on CaseNet. We'll just have to wait to see how it works. You're still going to have to file your unredacted version. You're going to be filing two versions of your document, one redacted and one unredacted. And along with the unredacted document, you're going to be filing a certificate of compliance that you have, you're certifying that the redacted document is in compliance with the new law. Okay. It's going to be right. You got your certificate of service. You're going to have your certificate of compliance with the redaction requirements. How it's all going to work, how it's all going to look, again, it's going to be on us to go to the Missouri Bar website to read the articles that come out. Everybody's in the same boat here. In some respects, this is nothing new. The lawyers that practice in these areas who already know redaction likely redact their documents already. The only new part is you're going to be certifying that your document is redacted, and you're going to be filing a copy of the unredacted version. Okay. And again, here's a cut and paste from the webinar that I took. It says the same thing that I showed you in the prior slide. You got to certify compliance. It looks like there's going to be a checkbox form certification with a checkbox. There is no option available to submit the document for filing unless the certification box is checked. So there's going to be box checking, there's going to be submission of redacted and unredacted documents, and there is going to be your certification of compliance. I didn't make any of those slides up. I want to give credit where credit is due. The Missouri Bar website and the webinar that I took. Again, my public service announcement is get to that website before the end of the month, take the webinar, have your staff take the webinar or watch the recorded one so that you're familiar with these rules, so that on July 1, when CaseNet has the new features of box checking and filing certifications, that you will not be in trouble. That's what I got, Rob. I left 5 minutes for any questions, if there's any.
Folks, if you have any questions, you can either put it in the chat or unmute and ask away. Mark, I am not seeing any. If someone has one as a follow-up, would it be appropriate for them just to email you with? Is that okay with you? Absolutely. So my email is what I do. It's specialrep, SPECIALREP @gmail.com. If you have a question about the presentation, happy to get back with you. Again, if you have interest in being part of a disciplinary hearing committee, either in the city of St. Louis or the county, you can email me your resume with a cover letter of interest, and I'll get it to the right people. I'm here to answer any questions that you have about the procedure. Again, if you have any questions about, am I following the right ethics rule? That's a question from Melinda Bentley, our legal ethics counsel. And she has her own website. I think it's molegalethicscouncil.org. You can just Google that, and she's the one that gives the informal ethics opinions. Mark, thank you. This was chock full of great practical ideas, and as you mentioned, to have the three opinions is something we've never seen, and we appreciate all of your experience and giving you your time and sharing with us. Thank you so much. My pleasure. Okay, folks, we are going to folks, we are so fortunate to have Judge David Mason and Paul Venker. Many of you know them and know them well. Judge Mason, come August, will be, I think it's 32 years, Your Honor, on the circuit bench in the city of St. Louis. Paul Venker, 33, okay. Paul Venker, senior counselor with the Baker Sterchi firm, and just an outstanding member of our mediation team at USA&M. Paul, along with Judge Mason and others, Lynn Ann Vogel, and others, have organized about what's such an important topic to us in St. Louis and frankly across the country, to talk about these freedom suits. And to set the stage, Paul has forwarded a video that was part of a program shown on CBS's morning news show. Kelly will share her screen in just a minute and show that video that talks about this important topic, just to set the stage for this presentation. And there we go.
Today, they're marking this Juneteenth holiday by dedicating a memorial to an important and often forgotten chapter of American history. It involves Dred Scott, the key figure in an infamous Supreme Court case. Scott was an enslaved man who claimed that he and his family should be freed because they had lived for a time in a free state. He sued under a Missouri law, and he won, leading to an 11-year legal battle. In 1857, the Supreme Court threw out that verdict, a decision that helped put the North and South on a collision course towards civil war. Now, here's something I bet you didn't know. We certainly didn't. Scott was not the only person to file a freedom suit. Chris Van Cleve met a judge descended from slavery who fought for years to establish a memorial to them.
The sound of history being remembered. A story of freedom fighters being honored. Cast in more than 8,000 pounds of bronze and standing nearly 2 stories tall. This monument's installation in front of the St. Louis Civil Courts building is the emotional end to a story that began 2 centuries ago. Missouri law held if a person was once free, they were always free. It allowed slaves like Dred and Harriet Scott to sue for their freedom. The Scott story, spelled out in these handwritten affidavits, convinced an all-white jury to free them.
This was really based on family preservation.
Lynn Jackson is their great-great-granddaughter.
They were there to save their daughters. They hid them away for possibly up to 2 years just to keep them from being sold during this process.
For about 20 years, there was a sort of a golden age of slave freedom suits.
Historian Kenneth Wynn was the Missouri State Archivist when a court clerk made a startling discovery. The Scotts were not alone. Buried in old court records and lost to history until the late 1990s were at least 306 so-called freedom suits brought by slaves in St. Louis seeking their freedom. Wynn estimates more than 120 cases were successful.
It shows the collective effort of a people trying to be free, who did not rest and just accept their lot in slavery, but resisted it. It really speaks in some ways to people who believed in the integrity of the law.
Tucked inside this case file from 1821, the jury's findings, handwritten by its foreman, we, all the jurors, find that the plaintiff is free.
This is something that St. Louis should honor. You had to be pretty brave and courageous just to file the suit, because if you lost, the consequences could be dire.
Circuit Court Judge David Mason, a descendant of slaves, spent the last 14 years pushing for a freedom suit memorial. Its installation brought him to tears.
And when I'm reading these files and reading the affidavits of the slaves, I mean, I'm hearing them. I'm feeling them. I'm hearing my people. These were some of the strongest people over 500 years that have ever been produced in American society.
These freedom suits were hard-fought legal victories. Remember, it's the middle of the 1800s, so a slave walking into a St. Louis courtroom wasn't allowed to read or write, couldn't even testify in a court of law. The judge and jury consisted solely of white men, and Missouri was a slave state. Here's a time when the jury was likely biased against
Yes.
against the person suing for their freedom. The judge was likely biased in some ways against them, and that the system still worked.
Yes.
What does that say about justice?
That means that it can work. Truth is powerful. Facts are powerful. Having the strength to look falsehood in the eye and call it out for what it is powerful.
Funded by private donations, the towering sculpture entitled Freedom's Home is set to be officially unveiled as the nation celebrates Juneteenth. The names of all 330 known freedom suit plaintiffs will be added around its base.
What do you think Dred and Harriet would say?
They would be happy and they would be proud, but they would totally feel like they did not deserve all of this recognition.
A piece of American history once largely lost, well worth recognizing and remembering. For CBS Mornings, I'm Chris Van Cleve in St. Louis.
Nicely done, Chris Van Cleve. Talk about an uphill battle.
Yeah,
They persisted and persevered.
and the courage involved in that
Yes.
day and age, because if you lose, it's a real bad scene. It already is.
Yeah, you speak on the odds being stacked against you. You walk into a courtroom, you're not supposed to be able to read or write. A courtroom full of all white men in a slave state. But like you said, the truth is powerful.
Yeah, facts are powerful. Yeah. You're not even viewed as a human being back then.
Yeah. How about that?
Paul, that judge, that just set the stage. I'll let you take it over from here.
Well, I think, Judge, if I might, let me start with some basics, and I want to apologize for my voice. I had a bit of a procedure recently. I'm fine, but my laryngeal nerve is all a bit off. So hopefully it won't be too painful to listen to me. What I thought I would do is start off with some of the basics. You've heard a little bit of it, and then turn it over to Judge Mason. Again, I've been his helper in this project, and I feel fortunate to have that role. And we've done a great job as a team. But again, he's the guy, and I'm the helper, and I want to make that clear. So the material I've given you is some basic statutes and some basics in some of the authors of what they've said. So before Missouri was even a state, there was a territorial law in the Louisiana Territory that a person held in slavery could sue for their freedom. So it could be anybody. I can tell you, though, that over the years we're talking about, the vast majority of these freedom suits were filed by Blacks who were wrongfully brought here from Africa or wrongfully detained here in slavery, just by the sheer numbers. And if you look at the material I've given you, you can see the population of Blacks in America up to the Civil War was pretty significant. And so we don't hear much about Irish people filing for freedom under the freedom suits. It's just not synonymous with that. So here you have a plaintiff who has to have the courage to go to court and tell the judge in a petition that they filed that they're being wrongly held in slavery. The judge that is the gatekeeper. He then, and it's always a he in that time period, and it's always a white judge too, will look at that petition and make a decision. Is there enough here? Kind of like a probable cause finding. And if they find there is probable cause, then they could say, okay, I'm going to grant this petition and I'm going to appoint a lawyer, because they could file to be informal pauperis, which I know everyone on this call knows about. Obviously, this person is enslaved. They don't have any money. And so they need that. So the law did provide for that if they were wrongfully held and the judge so found. Now, the lawyer would be somebody in a small community of lawyers at the time. You'll see in some of the material that Tony Sestrick, a former BAMSL president, and many of you probably knew Tony, he wrote a book, 57 Years. And in there, he describes in the early 1800s, probably more than 20 or 30 lawyers in St. Louis. And so a lot of these lawyers were involved in these freedom suits. And not to get off on the complexity of that, but sometimes the lawyers represented both sides in different cases. Sometimes the slaveholder or the master, and sometimes the enslaved person. And so that's a little bit complicated for all of us. Let's not get sidetracked with that now. So the plaintiff would sue, and the lawyer would have the right to confer with them. And then the case would go to trial. And as you saw, obviously, it would be a white judge. It would be a white landowning jury at that time, be a white lawyer. Now, some of these lawyers were lawyers we know. They went on to serve on the Missouri Supreme Court. Edward Bates went on to serve in President Lincoln's cabinet. He was here then. But there's some really absurdities about this right that gets exercised. And I'll just talk about that a very little bit and then hand this off to Judge Mason. But so, for example, an enslaved person might be in danger of their master, because if you can imagine nowadays an employee suing their employer, what do you think it was like for an enslaved person to sue their master? And that enslaved person might have family, they might have children, they might have just family members that they are worried about. The law only provided for them to be protected during the time, the entire pendency of the suit, for example. So how do you think that happened? You think it was an FBI safe house? No, it was the city jail. And so for the entire pendency of an action, and there's a video out that we were involved in where Lucy Delaney was held for 17 months in the city jail. Now, what do you think the St. Louis City Jail was like in 1820? You think it had air conditioning? You think it had windows? I doubt it. That wasn't what they were about. There's all sorts of other absurdities that really get, once you get into the suits, show you that this is complicated, everybody. This is not a shiny beacon of freedom. It's not a magic wand where somebody gets tapped on the shoulders. All that's being accomplished is this person, if they're lucky enough, is to be found not the property of someone else. And that's why this material talks about, that I just gave you, talks about these people unwittingly probably being change agents. That is, they worked and they ended up changing how America thought about Black people. And yet, if you don't believe it, think about the US Supreme Court decision. My guess is Judge Mason's going to talk more about this. That body was so scared about Blacks being seen as human beings that they issued that horrible opinion in 1857. And the relative handful of freedom suits in America, there's 330 or more here. There were others around the country, but not a central location like St. Louis, other than maybe Washington, D.C. And I'm told from Professor Twitty, New Orleans, but that's civil law, not common law. Let's say it's 5,000. Okay, the population of America at that time is in the multiple millions, 30 million, 40 million. So this was something that the people who wanted to enforce slavery they were scared to death that this was going to succeed, and people were going to see Blacks held in bondage very differently, and they couldn't have that. And so I think that's really what I wanted to say now. Maybe I'll talk a little bit at the end, but Judge Mason, again, he's the man. He's the guy I'm here to help. So I'll turn it over to him.
First off, good morning. And I noticed a lot of my friends are in the audience, so I better do a good job. One of the things that I want to discuss with you in terms of looking at both the freedom suits and how it's wrapped around the Dred Scott decision that brought an end to freedom suits. A quick constitutional lesson: substantive due process, which, as you know, it's a concept in terms of appellate review, where a court is justified in bringing close scrutiny to bear on government action that might infringe upon certain individual rights, even if those rights are not specifically articulated in the Constitution. Now, it stems from the original Fifth Amendment: no person shall be deprived of life, liberty, or property without due process of law. That amendment was intended to apply only to the federal government, and that intent was based upon the need to protect the institution of slavery. Given the fact that the whole concept in Missouri law about once free, always free, which is the concept that if you have a slave in Missouri, you take them into a free state, and they're there long enough to establish basic residential requirements, then if you bring them back, they're still free. And that's what a lot of these freedom suits were about, people suing on the grounds of once free, always free. Well, when the Missouri Supreme Court shifted its politics and became very pro-slavery, and essentially throughout almost 57 years of Missouri law, in order to rule against the Dred and Harriet Scott, then you can understand why the lawyers said, well, let's try federal court. Argument being that since the Missouri Compromise was the legal foundation for once free, always free, then let's go into federal court, sue on the grounds that we're talking about a right granted federally that had been denied without due process of law. Problem is that the whole pro-slavery attitude began to infect the federal judiciary as well. So you get to the appellate court, and they make this very narrow decision that that Dred and Harriet Scott are not citizens, and therefore cannot sue. And that stems from a reading of, or an interpretation of the Constitution that says, well, look, slavery had been existing for several hundred years before the Constitution. It was existing at the time of the Constitution. And they didn't write anything into the Constitution bringing an end to this. Therefore, the only way to look at the Negro was as somebody who is a non-citizen. Now, that goes up to the Supreme Court on that narrow issue. Justice Roger Taney decided that he thought he and his pro-slavery colleagues could become heroes. At that time, the nation, as you can imagine, was divided. There's no level of division in the United States that can express the level of division in the United States at that time, where people had already been talking about maybe we should break off into two nations. That was a discussion that had been going on for quite some time, realistically asserted by any number of civic leaders and newspapers at the time. So this is how divided we were at that time. Now, you get into the Dred Scott case, what had been building up the judiciary was a number of lawyers, judges who felt that it should be solved as a matter of judicial fiat. However, the U.S. Supreme Court was not given an appeal that was that wrong. That didn't matter to Roger Taney. Taney did something that goes against all appellate jurisprudence, Supreme Court jurisprudence specifically. Number one, you're only supposed to make a decision based upon the facts developed below. Well, the facts developed below obviously did not satisfy Roger Taney. So he is Marc, if you read his opinion. And I recommend that you do. Make sure that you're ready to meditate or something after you read it, because it will stress you out. Decide to write an opinion where he was going to develop his own facts. The next thing is Justice Taney clearly made a decision that the narrow issue of simple citizenship wasn't enough. He had to write an opinion that went a little further and basically suggested that as a matter of constitutional interpretation, the Negro slave was intended to be property, is property, and must remain property. And of course, what was the law of the land at that time? In fact, even then, if you have property that you own and you bring it into another state, it is still your property. And if you go back to your home state, it is still your property. Property cannot be taken without due process of law. So automatic taking of property. So what happened in the Dred Scott decision was this long analysis to justify the conclusion that Black people are just property. And to justify this, Taney goes into, and if you can imagine, every wrong, horrible thing. The only thing he didn't say is that we had tails. But just short of saying we had tails, everything else, that we were designed essentially by God to be inferior to the white man in all circumstances. So inferior, in fact, that not only were we intended to be a subservient race of people in the United States, but it was a good thing for us. That in fact, this was probably a really great world for all of these Negroes who couldn't have the intellect to ever be anything, who were culturally incapable of participating in American society, and who, quite frankly, didn't deserve to have anything, even just basic citizenship, but even one step further, saying that the Negro has no right that the white man is bound to respect. How's that for sweeping judicial fiat? So having said that much, that's what created the firestorm that was, I guess you could say, if not the straw that broke the camel's back, it was right up on it. Abraham Lincoln criticized the decision in saying that he went to bed with Illinois being a free state and woke up with being a slave state, because Illinoisans could now go buy slaves in the South and bring them back and keep them as slaves in Illinois, because it was now a property rights issue, not a fellow citizen rights issue. And of course, you can imagine the concern across the entire rest of the country outside of the South, even moving out west. Abolitionists were, of course, about ready to fall out of their chairs over this. Taney thought that he had resolved the slavery issue by making this declaration, he and his colleagues, when in fact, all they did was make it a whole lot worse. Now, granted, some argue that had Taney not lit the match, there may have actually been some political compromises that would have preserved the existence of slavery in limited states under limited circumstances. That may be true. Nonetheless, obviously, I'm pretty happy with the result, and I have great respect for the men particularly, but men and women who lost their lives fighting for me, and their families who suffered greatly from the loss of fathers, sons, brothers in this horrific battle where 600,000 men on both sides died horrible, horrible deaths. And that's something for which, you know, I and my family has been and will forever be grateful. But that being said, despite the end of the Civil War, there was never a situation where the Supreme Court was asked to revisit the Dred Scott decision. And as you no doubt aware, at the time the Dred Scott decision came down, being a Supreme Court declaration, there was no way to reverse that except by way of a constitutional amendment. And of course, at that time, a constitutional amendment was been impossible to get passed. So everybody knew that this was going to be an area of serious conflict, and that's why war appeared to be imminent. And as you know, the southern states took the position where we're just going to get out of this debate by creating our own country. And they attacked it Fort Sumner, and here we are. But that being said, at the end of the Civil War, as you know, 13th Amendment was passed. Now that amendment undid the holding of the Dred Scott case, mainly that we Black people cannot be citizens. Said, okay, you're citizens, you're entitled to everything else. The 14th Amendment attached the entire Constitution to us and required states to give constitutional protection to everyone. So in a sense, it federalized that portion of the Constitution so that the states now had to respect the 5th Amendment directly, as well as all the other individual freedoms embodied in the Constitution at that time. So now you have this world. Now we get into, well, you know, what happened in America. One of the things that I've been researching a lot lately has been the cultural and political effect of the Dred Scott decision on the United States. And I can tell you that you think presidential politics causes a lot of people to put pen to paper. Pretty much every newspaper in the country had series of things, letters by editorials and letters by citizens, commentaries and speeches by politicians, editorials by the newspapers themselves, talking about this issue and talking about the effect. You can see from the newspapers, and like I say, this article is going to take me a while. You should see the power of research. But I can tell you that essentially all the newspapers in the South, there was belief that the Supreme Court got it right in terms of how, what the status of Black people ought to be. And a lot of people were a lot of whites in the South were extremely insulted over this concept that, you know, they can have Black people that can win elections and represent them in the Senate. In fact, there was a Black governor for a little while because, as you know, and as Paul pointed out, there were millions and millions of free slaves across the South who now had political power. Well, obviously, the first thought was, we can't let that political power stand. Therefore, you begin to develop all of these rules, regulations, and techniques to prevent voting. And I'm not talking about the political argument of voter suppression today. I'm talking about real suppression. White voter walks out and the poll person says, "How you doing, Paul? Here's your ballot. Go vote how you want to go." Black voter comes out and says, "Well, Mason, can you cite to me the 5th line of the 3rd Amendment to our Constitution?" They would say, "Well, no, I don't rightly know that." Say, "Well, then you don't have enough knowledge to know." Sorry. That's what was going on. The spelling was used as a test. Constitutional provisions were used as a test. Local laws were used as a test. And it was designed just basically to prevent Black people from voting. And then, of course, the pollsters will swear up and down that they tested everybody. Of course, there was no way to challenge what they had to say, as if anybody wanted to anyway. And then you had massive voter suppression. And of course, all these Black politicians who had won races during Reconstruction were, of course, swept out of office. Then you get into the whole question of, well, what does it mean to be fellow citizens? Well, you know, we know from the Dred Scott case and the rhetoric that the Supreme Court endorsed, Black people are not good enough. They're below whites. Therefore, it makes sense in their minds to segregate. So no, we don't want them near us. We don't want them in our churches, our schools, our water towers. We don't even sit next to them. If they want to come in and watch theater, they got to watch way up in the box somewhere. They're not near us. If you want to eat the food in the restaurant, they got to find themselves a place in the kitchen. Nowhere near us. They're not coming to our schools. Sorry, get your own. They're not coming to our churches. Sorry, get your own. They're not coming to our colleges and universities. Sorry, get your own. And that's what was going on in the United States. All of that is not quoting the Roger Taney in the Supreme Court in Dred Scott. If not quoting it, there was most assuredly what I would call a cultural DNA footprint, where the comments and edicts of the Supreme Court were clearly being continuously echoed throughout, particularly the South, to justify these segregation laws. And you see that same echo in the period of Jim Crow. And even when the nation went through the battle of trying to end just simple school desegregation. Some of you probably remember when that came down, it wasn't just a firestorm in the South. In Boston, they were turning over school buses. People were so angry at the concept of having to deal with actual segregation. Likewise in Wilmington, Delaware. You know, this whole concept of, okay, whites, you got to go to school with Blacks, drove a lot of people crazy. The whole concept. So all of the statements, edicts, I call it the racist manifesto of the U.S. Supreme Court. All of the things in the manifesto that we know as the Dred Scott decision continue to echo throughout our nation. going well into the 50s, 60s, and in fact, in 1971, when the schools in my hometown of Nashville, the courts put the hammer down and ordered desegregation by way of busing. And and as you know, that wasn't that long ago. And now, with the rise of neo-racism, and if you listen to some of the commentary that comes out of that segment of society, you can still find where people slip in what they say, echoes, or I call it cultural DNA, coming from the Dred Scott decision. Every now and then, the U.S. Supreme Court issues a decision that basically becomes extremely historical and can have a ripple effect through our culture, through our history, through our politics, through our lawmaking. People don't recognize that the Dred Scott decision is one such case. We feel that because of the Civil War and the constitutional amendment, we don't have to worry about Dred Scott. What we don't remember and understand is that Dred Scott told every person in America who felt that the black man or the Negro was an inferior creature. They now had a Supreme Court edict that said, yeah, you're right. And it is an edict that has never been undone. The Supreme Court could specifically have addressed and set aside every word in Roe in Plessy. Could have done it right there in Plessy-Ferguson. Instead, they kind of doubled down on the underlying cultural infection of Roe and said, well, you know, separate's okay. And of course, there you go. People say, yeah, right, it's great for us to be segregated. Separate is okay. The Supreme Court has now told us twice that these black people that we can go ahead and not associate with. Even in Brown, the U.S. Supreme Court, Brown versus Board of Education, had an opportunity that, given the premise of school segregation, that blacks and whites shouldn't be together, given that premise and the fact that Justice Taney had said essentially that that's an okay way to think of black people, given that premise, even then, the Supreme Court could have, if it chose to do so, written a great deal of its opinion, basically rebuking, if you will, washing its jurisprudential hands of everything that was said in the Dred Scott decision, but again, chose not to. And I think they would argue, you know, well, we chose to keep the ruling narrow. Okay, that's fine. I get that. So now I think in this country, are paying a little bit of a price of having allowed our Supreme Court to get away with telling the nation that racial prejudice, racial hatred is okay. That, in fact, when you think of black people as being inferior, you got the Supreme Court case that says, yeah, you're right. It's never been undone. One of the things that I'm working on is tracking this in an article with the hopes that brilliant lawyers like those who are within the sound of my voice would join in the movement to ask our U.S. Supreme Court, and they have, quite frankly, the common law authority to basically address a wrong decision. Not only set it aside, but eliminate it in what's called depublishing. Several states have done this already. Depublishing simply means that, say, for example, the next set of Westlaw books to come out, the next Supreme Court reporter, Roe against Wade isn't even there. It's literally put on the junk heap of history, and it's replaced by an opinion that says everything that was said was essentially a lie, made up, innuendo, falsehood, that came through into that decision to try to justify that horrific result. So anyway, that's my analysis and my research that is in progress that I'm bringing to myself on this whole thing of the cultural impact and legal impact and political impact of And I talk about this to you because as it relates to this being one of your diversity and inclusion hours, this I hope will help you better understand how we got here as a nation. And as your ears are always sensitive to the ringing of the bells run by the Dred Scott decision, you know, and how we as a nation have not directly sought to unring that veil. To not even really say as a nation, you know, it's set aside and to be held for naught. It sits there. If a lawyer wanted to quote something Taney said in that decision, they would not be improper to quote it. It's just the whole thing is no longer any good. And so, you know, there you have my intellectual take on the matter. And why I'm bringing this to you this particular way. Now, you know an awful lot about the freedom suits themselves. These individuals were incredibly courageous because, and when I say these individuals, I mean the plaintiffs. Everybody was courageous to a certain degree, even the judges who issued orders to protect these plaintiffs. But you can imagine what it meant to lose. And most of the slaves who filed suit lost. It wasn't just getting beat. It wasn't even just being killed off, because, you know, there's money here, so it wasn't like killing off. It was a wiser idea to sell off a slave who had the nerve to go to court. But you didn't just sell them anywhere. I mean, why sell them to a life that might even be better? You know, a so-called benevolent slave master. No, that wasn't what was done. They were instead sold to plantations in Mississippi and Louisiana, the two states that had the national, not international reputation for being the most horrible centers of slavery in terms of how slaves were treated. And they were sold essentially that was called down the river. You know, slaves were literally sold down the river into slavery down there. Slaves who filed lawsuits or were wanting to file lawsuits were often told, don't do that, masters sell you down the river. And that's kind of where that saying comes from. So, you know where it comes from if you're in your institution, if, you know, you're the one that has to take responsibility for some bad things that happened in your business or corporation, and you feel like, man, I got sold down the river. Well, now you know where that comes from. So that, I think, is, let's see, where am I? 11:43. We want to have time for a lot of questions because there's a lot of room for questions on this topic.
Right.
Did you have,
Judge, let me interject for a second.
To add, Paul.
Let me interject just a couple of things. Obviously, the judge is so right about the danger for these plaintiffs. But I think the important thing, or at least a very important thing about these suits, is to remember that, again, this was not a magic wand situation. There's a long and troubled history, obviously, for Blacks in America. After these suits, they were the starting point. It's probably the first time anyone told a Black person in America, you have a right to counsel. And so I think those are significant things. And these laws that I've included in the material, once free, always free, isn't in those statutes. That is a judicial doctrine. And so, as Judge said, back then the Missouri Supreme Court had 3 judges. It took 2 of the 3 to use that doctrine starting in about 1821 until the Dred and Harriet Scott case in 1852 was the golden age, as Ken Wynn mentioned in the video, of freedom suits in Missouri. So that was really just that golden age. It ended. Beyond this, the idea is to have us all think more about the struggle of Blacks in America. I'm going to show you a book. It's called Marked Stamped from the Beginning by Ibram Kendi. I would recommend to you for $20, buy this book, open it up anywhere you want and read 20 pages. You will change your thinking about Blacks in America. This talks about racism, how strong it is, and how we, not being Black, just don't think about it. We haven't been exposed to it. We haven't suffered through it. We've watched it oftentimes from a comfortable distance, and we've not been involved in it. Another book that is really hard to read because it's so powerful is The War Before the War. This is about the Fugitive Slave Act of 1850. This is kind of a redo on the Missouri Compromise of 1821. This is a powerful book about how the Southern slaveholders brought slavery to the doorstep of Northerners because they made them have to help them get their slaves who ran away back to this plantation. And it's one of the big factors in the ultimate Civil War, because it's one thing to think about slavery being in Mississippi or Louisiana or wherever, when runaway slaves who are seeking freedom come to the North and look for help. But there's a federal law that says you have to help slaveholders, give them back. That brought it front and center to those Northerners. It's a powerful book. It's hard to read very much at one time. I can tell you that it is, because I'm getting through it still. But again, you don't need to read the whole thing. The other one, and I've mentioned this in the material, this is a book actually about freedom suits. Professor Antwitty, she's on the foundation board that the judge and I have formed for the Freedom Suits Memorial Foundation, which is getting up and running. Great book. Again, a quick read, fascinating, disturbing information. There's goodness in here. There is. But as Preston Jackson, the sculptor of our sculpture, the Freedom's Home, says, slavery is ugly. It'll always be ugly. The only beauty here is that some people, white people, want to help Black people get out of it. And obviously the fight still continues. That's what we need to remember. It still continues. We just don't see it day to day. And we haven't been exposed to it as much. We need to get ourselves in that orbit, thinking about those things, as Judge Mason has been telling us. I reject one last thought for me. I recommend 2 movies to think about this more if you haven't seen them. One is called Glory. It's about the 54th Massachusetts Regiment who fought in the Civil War, the first Black regiment. Matthew Broderick, Morgan Freeman, Denzel Washington. Carrie Elwes, if you're a Princess Bride fan. Great movie. Watch it. And I'd recommend, if you haven't watched Lincoln with Daniel Day-Lewis, watch Lincoln and watch it more than once. Anyway, there's so much here. We can't cover it all. I'll pivot back to Judge Mason. Thank you for listening, and sorry about my voice.
I just want to say something very, very quick. I want you to indulge me with something very, very quickly before we go to questions. I'll be real quick. But people like me, having grown up as poor as I did, of being Black in America, and having faced the struggles of trying to get where I am, you can't get where I am without people making decisions, white persons in positions of power, making decisions that they're going to judge me by the content of my character and my intellect, rather than just dismissing me because of the color of my skin. One of the most important people in my life like that happens to be in the teaching group, Chip Robertson. And I want to thank you, Chip, right now for all of these people, because I don't know if I'll ever have another chance to thank you for taking the chance on me. And I really appreciate it.
Judge and Paul, I know you now have your foundation up and running, and I know part of the mission of that organization is, how do we pass along this tradition of our local legal community and the history of the judges in the city of St. Louis and Missouri Supreme Court, to pass that along to kids in school, as well as to those who have an interest, and to see the impact that the memorial has on folks. What can we do? Is it at a point, Paul, where the memorial will accept donations, or is it still being run through the BAMSA Law Foundation?
It's still right now through the St. Louis Bar Foundation. You can go to their website. There's a donation portal there. Very soon, very soon, the foundation will have its own website and its own donation portal. But donations, and thanks, Rob, for mentioning this. We still owe some construction debt. We've had some very generous donors. Some are on this call. We still need donations. First, to pay off the construction debt that we have, and still some more things to be done on the site. If you haven't been to it, you really should go. I can't encourage you enough. We also have the foundation going forward. So fortunate now to have board members who are scholars in freedom suits, and otherwise, we've been fortunate to have people that I think we can describe as social activists. Some are combination scholars, some not so much, but still activists. So the idea of the foundation is to take forward and reach out and show people what the freedom suit plaintiffs have done, but also what followed. Things like the amendments to the Constitution, things like the 25 Congressional Medal of Honor winners who were Black soldiers in the Civil War, even before slavery was outlawed by the 13th Amendment. They fought, some died. Things like the 1876 election, which was basically that trade-off to get rid of Reconstruction efforts in the South for political gain. People don't know that horrible story, but the foundation will help bring those stories, hopefully, to all of us. We have a lot of energetic people that want to do that. So anyway, sorry, I get going, but like I say, I'm really here to help Judge Mason, but it's easy for me to get ramped up about it. So I'll give that back.
Paul.
Now you know I call Paul my brother from another mother. So
I agree. Same for me.
Well, you all have been the torchbearers, and I know there are many of us that participated in helping to get this off the ground, and I fully support what you have done. Those of us who were there when the memorial was unveiled was an incredible experience. It's amazing to think that was just a year ago. On a very warm day, as I recall.
96.
But what struck me was it wasn't just a bunch of lawyers in the crowd. We had young students there to witness something to being unveiled. And all of us as members of the bar really should be proud of our local circuit. Our Supreme Court was a leader in this country. And I think it's incumbent on all of us to help participate and allow this torch to be passed to the next generation and the generation after that to learn about how important this was in the history of our nation. So thank you both so much. Paul, Judge, any last thought before we conclude? I don't see that there are any questions in the chat, but if there are, I would again ask if you folks have particular questions, you can reach Paul at his office at Baker Sterchi, and I'm sure that the judge would entertain particular questions.
So there is a Facebook page.
There's
a Facebook page to look and go find information. Go ahead, Judge.
There are a few questions up here. Attorney Bollinger asked, would reparations assist in mitigating past systemic wrongs? Well, like anybody, I'll take all the money I can get. But that aside, I'm going to say something controversial and say that everything depends on what reparations means. If it's just money, then the answer will be no. You're a lawyer, so you know what it means, for example, to settle a case. Once you've paid the money, your responsibility goes with it. Well, that's not good for America. That we can't do that. Instead, what we really ought to do is, instead of making, reparations, let's start making some preparations for moving this nation forward. And it involves taking not only a hard look generally at how our nation works, and this whole concept of systemic racism, kind of hard to really nail what that is because there's a lot of people involved in our nation's systems who don't really have even the subconscious racial motive for what they do. All right. So that's kind of a rhetorical commentary. I instead ask people to take a look at, if I'm talking to lawyers, take a look at how you can individually work to correct problems. So what I mean by that, the legal profession in the United States of America, the most powerful profession in the world, we impact every day. There are lawyers advising the president over how much arms to send to the Ukraine. We impact every day. Much of what is done, all these regulations, rules, all of them from lawyers advising clients. So if you can think of how you can use your power in terms of talking with clients about client policies developed, that can go an awful long way. And then there's what you do at an individual level. All of you may from time to time experience somebody like me who just needs somebody who has enough, has enough faith in them to just open the door and to assist and to suggest and to support. You'd be amazed what the results can be for you if you do that. Although I don't know if Chip's amazed at the results of his work. I hope that he is, but that can be extreme because you can imagine millions of lawyers across this country who are in power, like so many of you, were to take that upon themselves. Okay, I'm going to do something myself. It's like that old song from a TV thing. If everyone lit just one little candle, what a bright world it would be. If every last one of you, because even the younger of you have power, would make a decision, okay, I'm going to keep my eyes open and always be conscious of something I can do to help somebody Black in this country who needs a helping hand, who needs a friend, who needs a colleague, who needs a mentor. I'm going to go ahead and do it. That will do way more for us as a people in terms of having us advance so we can equalize with our white brothers and sisters, citizens in this country than really any just blanket reparations. That's really what's going to make a big difference. And it's made all the difference in my life and in the lives of many people. It's made a difference in the world of Barack Obama. You know, let him tell his story. I don't care who it is. That kind of thing makes a difference. And so if you can put that in your heart and in your head, then trust me, you will be doing your work on reparations.
Judge, thank you. Paul, thank you. Thank you both for presenting today, enlightening all of us, more importantly, for the work you have done, and hopefully the work that you will continue to do, and that all of us can have some involvement and be one of those little candles, Judge, make this place a better place. Thank you both. Folks, we are going to take a half-hour break, but Paul and Judge Mason, thank you again.
Thank you again. Thanks,
I'm very happy to do it. Thank you.
Great. We'll see you at 12:25. It's my pleasure to introduce Judge Mike Burton. Judge Burton was an associate circuit and circuit judge in St. Louis County. The pleasure of becoming the presiding judge just a week or two before COVID. And I'm thrilled to say he joined our group at U.S. Arbitration Mediation as a mediator and arbitrator and doing wonderful things, but also doing wonderful things within the community. Part of the mission of what we do at USA&M is to support important nonprofits, and Judge Burton's going to share a little bit about maybe one of the newest here in town that he's involved with. Mike?
Thank you, Rob. Thanks, USA&M, for allowing me to say a few words. We all know about the prevalence of domestic violence across the United States and here in the St. Louis area. I just wanted to touch briefly about, how things in the St. Louis area are not as good as they could be, and they're probably worse here in the St. Louis area than they are in many other areas throughout the country. I want to give you sort of an example as to how things are lacking. If you just look at the city and the county, which encompasses about 1.3 million people, right now, the number of beds that we have available in domestic violence shelters are 55 beds. And you often hear people comment that don't fully understand the situation. Why is it that you went back to the abuser? If it's that bad, why'd you go back? And just listening to the numbers that we're talking about, it's easy to see why someone goes back to an abuser. I was privileged to have the order protection dockets for a long time as I was a judge. I heard thousands of cases, and I noticed how few petitioners ever had any representation while they were in the order protection docket. Court Watch recently did a study and found that in the St. Louis City and St. Louis County, the number of petitioners that were unrepresented in these dockets hovered between 85 to 90%. And even though these proceedings are set up in such a way where they can be done in a pro se fashion, it does make a huge difference when attorneys get involved. It makes a difference in prevailing and getting your order, but it also makes a difference when we start talking about the length of an order protection. That involves some significant proof on the part of the plaintiff. When we also talk about issues pertaining to other kinds of relief, such as just dealing with visitation and custody. So many people that are in an order protection docket have children in common. And oftentimes judges have no choice but just to say, stay away, no communication, but don't address issues about visitation, don't address issues about support. And often that puts a petitioner in a horrible spot where they are looking at having to go back to the abuser. Another thing I noticed as a judge was that the number of cases that I had to dismiss because the petitioners failed to appear. It's about 80%. And the bottom line being that when we look at the statistics in this country, and we know that when someone actually has the courage to come forward, oftentimes things occur that prevent someone from doing anything further in the system. A lot of it is because of intimidation and threats. People just don't come to court. And because of that, I decided with a few other folks to put together a group called St. Louis Support, St. Louis Survivors Legal Support. I'm going to give you the information in the chat in just a second. And what we're doing is partnering with police departments, partnering with different domestic violence agencies, because we believe that when someone connects with either the police or with other agencies, and they're told that someone's going to be waiting for them in court to help them fill out an order protection petition, they're going to show up. When we see that someone knows that they have an attorney at the hearing, they're going to show up. And when we see that attorneys get involved, folks are going to get the relief that they need. So right now, we started on April the 3rd. We're partnering at this point with many agencies in the area. And at this point, I've got about 110 lawyers that have signed up, but the work is huge. The numbers are huge. And so far in the past 2 months, we've got about 50 to 60 clients. I don't want to brag or anything, but I had my first trial in 24 years and I won. Now, of course, my wife pointed out, who's an attorney, that and she had to explain to my daughter what a default was, that I didn't have anyone on the other side that could put up a defense. But hey, you put that win in the column. One of the things that we've seen is every single client that we've represented has come back to court. We've had one person that didn't the first time, but they did return. And that's something that we're proud of. So if you're interested at all or you know someone that could volunteer, please let me know. I'll give you my contact information in the chat in just a bit, but we're really looking for a lot of folks to help out. The appeal to representing folks in this situation is that the bottom line is that maybe you're talking about 2 different court dates for a case. Once you have that hearing, you're done. And it's a very short hearing. These hearings usually last maybe 30 minutes on average. The preparation is something that, we'll be there to support you. I'm there at all of the dockets. We're covering all 5 dockets in St. Louis County, and we're there to help. We're training folks. We've already had 1 training. We're having a second training on June the 30th, just in time for the CLE requirements. It's 8.2 CLE hours. And if you're only getting your CLE from this seminar today, you're going to need a few more hours, and we're glad to help. But I really appreciate it, and thank you very much. I'm going to give my contact information on the chat in just a second. Thanks.
Judge, thank you so much. And I know you had a great turnout at your first training, and to have more than 100 lawyers agree to volunteer it is terrific. So this group, St. Louis Survivor Legal Support, that you've organized is doing important work. Even though it's in its infancy, we can do things to support. That's one of the groups that our dollars from this program are going to. Legal Services of Eastern Missouri, Land of Lincoln Legal Services, and the Corn Bloom Food Pantry. So we wish you all the best, and hopefully some of the folks here can be assisting you.
Thanks so much, Rob.
Okay, next on our program, we're going to, if you have the agenda in front of you, we're going to flip-flop the next 2 items. So the civil law update will occur with Joan Lockwood at 1:25, and Morry Cole is going to jump in next. Morry's a partner at Ritter Graham, a tremendous plaintiff's practice, former member and president of the Missouri Bar, and a lawyer's lawyer. And he and I chatted some months ago about, we're past the crux of COVID, but we're still utilizing various video processes within our practices. And he agreed to do a program talking about various remote proceedings. And Morry, thanks for presenting today and being with us.
You bet, Rob. Can you hear me okay?
I can.
Well, we're transitioning from historical and philosophical presentations, aspirational presentation by Judge Burton, and now let's talk about practical. Post-COVID, during COVID, and even before COVID, we had seen and are seeing a transition from everything being live, everyone traveling extensively for depositions all over the country, to people making more of a judgment call. Do I want to spend the 2 days traveling? Do I want to spend and incur the expense of traveling? Do I have to? Do I need to? What is the best practice? And the truth is, it's evolving. We have been doing video depositions of primarily opposing experts for probably 7 or 8 years now, and it used to be much more cumbersome than it is today. It was very much more expensive than just having a Zoom subscription and clicking in and watching. But still, back then, it was much easier in many circumstances than traveling. And there's been some growing pains, and I'm gonna start working through a screen share here too, and the growing pains come as we all learn how to operate our new technologies, and we'll get spooled right up here.
Morry, the good thing is we're not cats.
That's right. Well, it's funny that you mentioned that, because I guess you've given me control of who enters the room now too. Well, I'll enter everyone.
Well, and we'll take care of that while you're speaking.
Yeah, that's okay. Wendy Wolf's coming in now. All right, Rob mentions the cat filter, and that's a place I'm going to start. We've all probably seen the video of a lawyer who his child left a cat filter on his Zoom. He was stranded in the cat filter, did not know how to turn off the cat filter, and it went viral because his embarrassing moment was a learning experience for all of us. I want to talk about the idea of taking testimony primarily remotely. We'll talk about court hearings as well. But one of the things that we were reminded as Zoom exploded and as the courts adopted more video conferencing and more remote proceedings is that we can do this best if we get along while we're doing it. And so one of the ways to that we have to think through, how are we going to use this? And if we take some testimony remotely, or we want to present a witness remotely, the easiest way to do it is by agreement. So we've seen these read-ins by court reporters, and they seek to get us committed to that agreement on the record. And this is what they look like if you haven't been doing them. They say, hey, I'm a certified court reporter. The deposition's being taken remotely. And they generally will say who is where. Counsel generally acknowledge their understanding that the court reporter won't be physically present. There is a Missouri Supreme Court case that's now decades old that does hold that court reporters don't have to be physically present at the deposition. But it's always easier to do these things by agreement. Even though it's easier to do them by agreement, they aren't, we're not always in agreement. So if you have a heads up by your other side, or at the beginning of a proceeding, they attempt to make a record being critical of some aspect of the proceeding, you should not be flat-footed at that time. Check with your other side and make sure they're agreeable. I have not had someone disagreeable to a remote proceeding in quite some time, but it's always something that you need to check with, because you don't want to be at the moment of the hearing and go on the record and have someone express their objection at that time. And the things that we need to do in advance. First of all, check with the other side. Just because the other side is agreeable doesn't mean the judge is going to be. So check your local rules, check your judge's rules. If there's ambiguity, check with, or no answer to be found there, check with the court clerk in that particular division, and see if the judge has a position on it. If not, and if the other side's not going to be agreeable, and if you're concerned that the judge may not be agreeable, file a motion seeking to preserve testimony remotely, present a witness remotely, whatever it is that you're wanting to do. And of course, present the judge with your desired order so that their life is easier and all they have to do is autograph it. Now, I said we'd talk about the practical, and I do want to talk about the practical. There's do's and don'ts for any lawyer who is appearing remotely. What to wear? Well, you're in court, you're in a court proceeding, you're in a deposition. You need to dress as you would if you were in that setting normally, if you were live in court. So what to wear? I say if it's a deposition, you're going to be on camera. It's has a chance of being played back in court. You need to wear the uniform for court. If it's a deposition that you will not be appearing on the camera, you've got it set so that just the witness will appear, then business casual is probably appropriate. But When in doubt, default to being dressed for court. Consider your background. Whether it's for court or for a CLE presentation like this, a meeting with a client, whatever, you need to think through what your background is going to be. I thought through it. My background today is an office setting background. I considered having a conference room background or an out the window background. This is where I am today. This is where many of you are today. We're sitting in our offices, and let's have a meeting and talk through our material. Something that you have to think about well in advance is how you're going to handle evidence and a proposed order if you're in a court hearing. If you have evidence that you need to offer, you can do it like we're doing with our PowerPoint today and screen share, but that doesn't give the court a copy to look at after the hearing if they're not ready to rule. So how are we going to deal with that? Plan ahead, just like almost everything we do. We have to plan ahead and plan ahead well. How I deal with it is to either mail, FedEx, or otherwise deliver it to chambers or wherever the judge would like it delivered in advance. That includes the proposed order. Many times I will have copies for the judge, not original evidence, but if there's original evidence that has to be dealt with, then you need to figure out how you're going to do that in advance and coordinate it with the clerk. Don'ts for a lawyer appearing remotely. No driving. If you're going to be on a remote proceeding, whether it's WebEx or Zoom or otherwise, you should not be driving a motor vehicle. I noticed someone log into this just a few minutes ago. I'm not going to call you by name, but I noticed that you logged in and set your cell phone in the passenger seat and then reached over and turned the camera off. That's good. At least we're not filming you and you're not watching us. But really, you shouldn't be driving while on a video conference. Why? Well, I can tell you why. I have two cases going right now where I'm suing a defendant who was on a video conference at the time of a very serious collision. One of them, a gruesome wrongful death collision. So there's the practicality of don't be that distracted when you're driving. And then there is the image that you want to portray to whoever's on the other side, which is the most important thing going on in my world right now is this video conference, this deposition, this court appearance, this client meeting, not the crosstown jaunt that I'm taking. Also, a don't on your background. Have a professional background of some sort, right? No beach scenes, no vacation scenes, nothing that makes everybody else who's participating in the video conference jealous of your existence because they know in a mere 40 minutes you'll be back under the palm tree that's waving outside of your window. And again, I guess this should say don't dress inappropriately, but I frequently see, and in fact, last week was on a Jefferson County WebEx where I saw one of the attendees in a t-shirt. We're in court. We don't need to be dressed as though we just rolled out of bed or just got done working out. Pretty practical, seems common sense, but every time I'm on a law day WebEx, I see one or two or three people out of 30 that are violating these very simple things. What they are doing is not a best practice. What I am suggesting is a best practice. Much easier to control ourselves than it is to control our witnesses. However, again, preparation in advance will help a witness be the most effective witness for themselves or for your case that they can be. All of these things need to be talked about and discussed with a witness in advance. And just like we want to prepare our own clients for testimony, for depositions, 6, 7, 10 days in advance so that they have time for the concepts and the practical advice that we give them to sink in. You want to prepare your witnesses well in advance. Trying to tell them what to do a half hour before a court appearance, a half hour before a deposition, or a half hour before a meeting is not going to do anything except make them a worse witness and a more tense and stressed out witness. Tell them what to wear. Don't be bashful about this. It serves two purposes. One, it aids in their appearance. And two, it bolsters their belief that you are a counselor that is guiding them through a process effectively. So tell them what to wear. Tell them what not to wear. Help them consider their own background. They too need to have a good background in the video conference. You need to explain to them the idea of swearing in before we get into the hearing so that they are prepared for it and they know what's coming. And then again, handling evidence and proposed orders. If you have a witness appearing remotely, how are you going to handle evidence? A pretty good way is to have the witness have a copy, the judge to have a copy, you and opposing counsel to have a copy. And then you can screen share if you want. If there is a failure, you've got a plan and a backup plan. Your plan could be the screen share, your backup plan could be the binders. Don'ts for a witness appearing remotely. They have to have control of the environment that they are in. You can't have pets. I've had a cat jump up on the table during a Zoom. We don't want that. I've heard people with their dogs barking and running around on a Zoom. We don't want that. We don't want other people walking around, peeking in at the Zoom. Every once in a while, you'll be on a Zoom and you'll see someone's head kind of peek in from the side to try to see what's going on. If a witness is appearing remotely in a legal proceeding, they need to have a quiet place with a neutral or appropriate background, free from distractions, free from pets, free from people. They are a participant in a court proceeding, and they need to be the participant in the court proceeding. All right, if we're going to have a hearing before a judge, the pre-hearing coordination is absolutely key. This is not a criticism of Judge Mason or of our courts, but there was a little bit of a learning experience for us as we watched his presentation. I was able to hear nearly all of it, but not quite all of it. And some of what I heard was a little bit garbled. And so when I say we need to confirm adequate bandwidth, we really do. We really do. And we need to test it. We had a trial not that long ago where we had a witness appearing remotely, and we gave it a good hearty test well in advance to make sure that the bandwidth in the courtroom was going to allow a witness who was stuck in another country and unable to get here in time to testify projected up on a big screen in the court with adequate ability for us to hear them and see them, and for them to see what was going on in the courtroom and hear us. So test it. Practice with your witness or your technology. One of the things that I'm sure many of us do, because I looked at the cast of characters that's attending today, and there's a whole lot of heavyweight lawyers. One of the things that many of you are used to doing is taking your client to the courthouse, taking them there well before their trial or their hearing, walking them around the courthouse, taking them in the courtroom at a time when the court's not in session, letting them sit in and test out the witness stand and the chair, see where the jurors or the judge, court reporter and clerk, deputy, everyone's going to be, and practice hearing how far their voice will carry and what the acoustics are like in the room, all designed to make sure your witness is a better witness for themselves. Those same things that you do and that you have done for so long in trying cases live or holding hearings live need to be done and tended to beforehand with your witness who's going to appear remotely. We tend to forget from time to time that as video conferencing becomes more and more normal for us, it's not necessarily normal for our witnesses. Just like we spend lots and lots of time in conference rooms and courtrooms and they don't, they can have significant unease and stress with the idea of trying to get logged in and participate in a video conference. If that is the situation, and there's no way around it, you're simply going to have to take them by the hand and either go to where they are and help them, or have someone on your behalf go to where they are and help them. So practice with the witness and the technology well in advance. And another thing that we need to think about if we're having a hearing in front of a judge is to check with the judge's display. What type of judge or what type of display does the judge have? If you're going to be trying to use exhibits that have small print, for example, or that have subtleties to them that are potentially difficult to see, then it's going to be very important for you to know when you do your screen share, is the judge going to be looking at it on their iPhone somewhere where they can't read any of it? Is the judge going to be able to put it up on the big screen in their courtroom or in their office? What's the setup for the judge? Because just like when you practice with your witness or technology, you need to know what the judge is looking at. I'm going to give you an example from so long ago. It was when Judge Titleman was on the Court of Appeals before he went to the Supreme Court. I watched someone argue a case on appeal before Judge Titleman and two other Eastern District judges, and the lawyer used some hardboards during their argument with small print on them. Judge Titleman certainly couldn't see any of it. And in fact, the other judges couldn't either. If you're going to be persuasive in your hearing and you need exhibits to be persuasive, then have exhibits that are not just usable for you, but are visible for the judges. All right, depositions. Same themes apply here, right? Pre-deposition coordination is absolutely key. You need to confirm your adequate bandwidth on both ends, and also where the defense lawyer or plaintiff's lawyer on the other side is going to be, and you need to test it. Practice with your witness and your technology and make a decision of if you're going to record it or not and how you're going to record it. If you are going to record it, you'll need to advise the people or persons who are assisting you with that what views that you want. Do you want both the attorney who's speaking and the witness? Do you want just the witness? What do you want? How do you want to handle screen shares? What do you want to do with exhibits and so forth? Here, again, practically speaking, we want to have a plan and a backup plan. Sometimes I call it a belt and suspenders. You've heard that. We want to have a plan and a backup plan with how we're going to handle our exhibits. Before we had the ability to screen share, the way I handled exhibits was I would get them all together. I would get them all marked. I would get them in the order that I was going to use them. And I would FedEx them to, if it was an out-of-town witness, I would FedEx the exhibits a couple days ahead to the court reporting service that's covering the deposition. And I would instruct them to take them to the deposition, not open them until we were on the record in the deposition, and then hand them to the witness as we went. That makes sure that the other side doesn't get your exhibits and a chance to woodshed their witness for days in advance, but the exhibits are there. If it is a critical witness and it's critical that they have the exhibits, I would suggest that you have that belt and suspenders. FedEx your exhibits out in advance or otherwise provide them. If you're not seeking to have some element of surprise, just provide them to opposing counsel to take with them. And we do that routinely. If you're going to record it or not, you need to decide how you want to record it. Do you want to have a videographer in the room with the witness recording it, or do you simply want to use the record function of the video conference service that you are using. While we're at this point, I thought it might make some sense for us to look at, for those of us who haven't used the screen share function with witnesses to display exhibits and talk to witnesses about them, I thought we might just tinker with that a little bit. And what I'm going to do is pull up some exhibits that I have actually used in depositions with witnesses and see how they work. I just need one volunteer to tell me, are you seeing this fractured cam gear from the internal components of an aircraft engine that failed?
Yes.
All right, Mr. Litz, if you were a witness I wanted to use this with, I would presume that you were a witness very familiar with using dye penetrant to determine where there are cracks in a gear made of high alloy metal. And you know, when we pull this up, we can just say to a witness who knows, Mr. Litz, are you seeing exhibit number 26 that appears on the screen before all of us?
Yes.
Can you tell from that that this appears to be a cam gear from a Continental Motors TSIO 520 aircraft engine?
Of course.
And you also, from your vast background in metallurgy, can tell that this has been sprayed with a dye penetrant and is being looked at the time of this photographic exposure through blue light.
I can.
And to an expert such as yourself, there is a clear indication of a fracture, and I'm showing it with my cursor here, that extends from the area where the gear teeth failed towards the center of this gear, does it not?
It does.
All right, so it's very easy to have this dialogue about an exhibit when we put it up in front of everybody. And you know, sometimes and I generally try to coordinate this well in advance. We have this marked as exhibit 26. Everybody has exhibit 26. We put it up on the screen. We have a meaningful conversation about it. We put on the record at the end that everyone will retain their own copies of the exhibits and move on. That certainly is easier than flying to Seattle to ask those questions. It's easier than flying to Pensacola, where those questions were actually asked. We can just do it right here. If that didn't work, my screen share function didn't work, it didn't come up on the other side. The witness was having difficulty seeing the crack. The witness was having difficulty with whatever it is. Generally speaking, I would go from the belt to the suspenders and say, that's okay if it's difficult for you to see. I have a high resolution print of that photograph under tab 26 in the binder that the court reporter has. Could you please take a moment and get that in front of you, sir? And then they do, and then we move on. You know, chain of custody of exhibits and those types of things are always things that we as lawyers can choose to get along about or not get along about. And, you know, if somebody's going to make a best evidence argument, somebody's going to say, gosh, how do I know this exhibit 26 is the one that you used in that deposition? All right, first of all, don't be that lawyer. Second of all, plan for that in advance and just ask the question. If it's not somebody you're used to dealing with, if you don't know what their position is going to be on it, just say, hey, Rob, are we going to have any problems when I go to replay this deposition about exhibit 26? Do I need to lay more foundation or are we good? And if Rob says we're good, I know we're good. Other people, if you have a suspicion it may be a problem, then you better lay your foundation. You better have your protocol in place that everybody can get along with, or you better get it in front of the judge before you preserve the testimony. All right, I'm gonna do another screen share for you here to show you how we used This was an exhibit that was used in the heart of the pandemic. This was when we were all totally locked down. We were preparing for wrongful death trial that actually did occur during the pandemic. We all wore masks the whole time. And just to give you a tiny bit of background, this was a motor vehicle collision that happened, and a contributing factor was smoke. So, Mr. Litz, I'm sharing my screen with you. Do you see a split screen with a dash cam video of someone inside a police car at the bottom and dash cam video looking outside at the top?
I do.
All right, and what I did with this was I played this for the witness.
By the time I seen him, I was already very slow down.
And Mr. Witness, would it be a fair statement that your statement at the scene was by the time you seen them, they were barely past the nose of your truck? And he'd say yes, and in fact did say yes. And I'd say, and that is consistent with what you indicated at the scene while you were sitting in the police car. Yes, it was. And then we can also go ahead and ask this witness, the smoke that we see up here between the truck that you were driving and the 65-mile-an-hour speed limit sign, that smoke was blowing as you drove from right to left across the highway. Yes, it was. And that was the smoke that obscured your vision so that you weren't able to see the motor vehicles that were within that smoke as you traveled at highway speeds. That's right. Sir, I'm going to play this video for you again, and I want you to watch the movement of the smoke. Could you do that for me, please?
By the time I seen him, I couldn't see how. Yeah, I was already very slow down.
Now, I realize, sir, that this video was taken some minutes after the fatality collision that you were involved in. But generally speaking, does the movement of that smoke show the movement of the smoke as you approach the scene of the crash? Yes, it does, right? It's just screen share. That's how we can use some of these exhibits. Now, what if I hit play and the video doesn't play? Belt and suspenders, right? We always have a plan. We always have a backup plan. If I hit play and the video doesn't play, the only thing that I'm not going to be able to establish at this time with this witness is the movement of the smoke, because I have a backup plan, which is right here, a PDF taken, a screenshot from that same video, and I can ask him all of the same questions. If my video just totally conked out on me and didn't play, I can ask him questions about the smoke, about the location of the crash, about whatever is depicted on here. So I tend to use a variety of different media during video depositions. A lot of times I will have things set up so that I can pull them up as a PDF, set up so I can pull them up in a PowerPoint sequentially, or just have images on my desktop that I can click to and click through quickly. I like to have them in more than one place, as well as a hard copy with the witness, because I just had things fail too many times. If your plan doesn't work and your backup plan doesn't work, in the end, what we're left with is our own ability to describe things and ask questions as lawyers. And sometimes that's all we have left. Be ready for it. It's going to happen at some point in time. I've had the big lead up in trial where I built up the video deposition that I was going to play. And as I turned around to gesture to the screen, kicked the plug out of the wall that had the power strip that had everything plugged into it. And we just have to adapt while it all reboots. It's a fact of our life. I'm going to work our way back to our PowerPoint. And while I'm doing that, I want to point out that when these things are going on, so today it's the Zoom CLE, when things are going on where we're moving from one type of media to another, there will be some delay. You know, I can't click from one thing to the next without there being some delay. In a deposition, or in a deposition, I usually just sit quietly while I'm doing that. If you sit quietly, don't say anything, take your time, and as you're clicking through, gather your thoughts for the next series of questions. That creates a couple of things. One, for the person who ultimately has to edit that video, a longer pause without speaking is much easier to edit out than a very short pause without speaking. So if it's a video deposition that you are recording, you're better off kind of taking your time, leaving a nice, 10, 15, 18-second gap that whoever edits your video can clip out of there. Then you are talking along as you go. Oh gosh, I'm now switching from the video player to the PowerPoint, and the court reporter is going to take all of that down, and it's going to be more difficult for you and your staff to edit out later. So just sit quietly, and as you click your way through, and that'll be a nice, easy thing to edit out. Let's talk about trials. You're seeing some recurrent themes here. And the reason you're seeing recurrent themes is the best practices for all of these things are very similar. If it's a hearing, if it's a trial, if it's a deposition, our best practices are going to be largely similar, if not the same. Again, coordination is absolutely key. Confirm your adequate bandwidth and test it. Practice with the witness and the technology, and evaluate the effectiveness of the judges and jury's display, right? That's the only thing different here from a hearing with the judge. Now we've looped in the jury and the effectiveness of their display as the people deciding the case, the effectiveness of their ability to see and receive that evidence is paramount, right? So if we think about our building blocks of persuasion, getting attention is always the first, right? And it's pretty easy when the judge turns to you and says, Mr. Cole, right? I've got their attention there. But the next thing we have to do is hold their attention. And we have to hold their attention by taking various steps to be interesting, right? So get attention, hold attention. If you're holding their attention, then we can communicate. And if we're communicating effectively, then we can be credible. And if we've built all four of those and our credibility is good, then we can persuade, and only if we persuade can we win. Well, a key to that with the jury is what they're looking at. I like to move around like a lot of you do. I like to move around in the courtroom where we can. That's the most challenging thing about federal court or a judge that requires you to remain at the lectern. It's hard to hold people's attention if you're totally predictable. The more unpredictable you are, the easier it is to hold people's attention. And I don't mean crazy unpredictable, but I do mean like for those of us in the St. Louis area that go to the Muni, you know what it's like when a child walks across the stage, or one of the participants in the presentation is an animal, a dog or a monkey or something else. If it's a little bit more unpredictable, the crowd is captivated. Well, here we're going to think through, what do we have tools available for us for perhaps a longer deposition to be something that the jury will actually pay attention to. And their display of evidence is absolutely 100% a key to those building blocks of persuasion. Has to be something they can see. So how can we build on this? Well, one is make sure there is a display that everyone in the jury can see. If that means you have to have multiple big screens, bring them in and put them in front of the jury. The person in the back left has to be able to see it just as well as the person in the front left, front right, back right, and everybody in the middle. Evaluate the effectiveness of their display. Then think through how you can use other things to mix it up, switch it up, and hold their attention. I will oftentimes, during a deposition, if we were going to use the photo of the gear under black light with the dye penetrant on it. If I'm going to put that up on the video screen, and on the video screen it's going to be rather small, I might also put the hardboard up that is king sized or big screen sized on an easel in the courtroom. Talk to the other side about it, talk to the judge about it. Everyone should be willing to have the jury able to view the evidence. If it's admissible, it should be observable. If it's admissible, it should be observable. And the job is on us to follow the best practices to make sure that they can do it. How can we do it? Well, we put it up great big on a screen. We put it up great big on a wall. We put it up great big on a hardboard. We have multiple binders of key exhibits that we pass out to the 12 jurors or federal court 7 or whatever you get, plus alternates. Make sure everybody has the ability to see the evidence when you're presenting it through someone appearing remotely. All right, in all proceedings, here are things that we have to do. These are true best practices for all proceedings and certainly remote proceedings. So in a remote proceeding, we have to speak slowly and clearly. Judge Mason was very good at that. And when his technology was lagging just a little bit, for the most part, we were able to follow him. If he was speaking like an auctioneer or one of the people that court reporters can't stand to transcribe because they talk way too fast, people are going to lose content. When you have jurors in a situation, you have a judge in a situation where they cannot supplement what they're hearing by reading lips very well because I'm only 2 inches tall in the corner of their screen. Speaking slowly and clearly is going to make the court reporter able to take down the proceeding accurately and make sure that people who are hearing it can absorb it. That's pretty straightforward. The next two are less straightforward, depending on who you're dealing with. All right, speak one at a time. We need to be even more forgiving of each other when we're trying to do things remotely. So the third one here, allowing counsel to make a fair and clear record. It's important that we work together to do this. And I'll tell you right now that I almost never have any problems with anybody on these. If you have an objection you want to make, I'm going to let you do it. If somebody else has an objection that they want to make, you're going to have to let them do it. All of us have times where we get in a rhythm with a witness. We're making points with a witness. We've got a witness going the way that we want. We're on a roll, and we don't want to be interrupted. The other side oftentimes figures that out and wants nothing more than to interrupt us. The bottom line is it's not going to work as well for us to stay in that rhythm if we're going to allow our opponent to make a full and fair record, but it's not going to work as well for them either if they'll abide by these. What goes around comes around. We've got to work together. Getting along and making a clear record is almost never going to alter the claims in chief or the defense. It really isn't. So be easy on everybody, but by doing these things, you will also be easy on the court reporter. And being easy on the court reporter makes sure we all have that clear record that we want. If someone makes an objection right on top of your question, on top of the answer, and you've got a garbled situation, you can simply slow down and say, I believe the court reporter has your record, and I'm going to re-ask the question subject to your previously stated objection so that we can get the witness's answer without more than one person speaking at once. Totally appropriate. You should allow that, and everyone that you're working against should allow that too. That is a best practice. Another way to do it is to say, subject to the objection, I'm going to have the court reporter read the question back so that the witness may answer without two people speaking at once. Judges will be forgiving on this. You and your opposing counsel should be forgiving of each other on this. Breaks and coaching. One of the biggest things that I hear people say as objections to remote proceedings is, well, I don't know what the other side is going to be doing off to the side of the camera. I don't know what they're going to be signaling to the witness. I have to be there. I have to be there. And I will tell you, first of all, that doesn't work very well. Coaching someone during a deposition, it really doesn't work very well. If they are not in a position to give answers that are helpful to the case, you're going to be able to figure it out. And I don't think at this point, I don't think that folks who have done a lot of remote proceedings and depositions are really losing much by the concept of someone off camera trying to provide some coaching, trying to steer somebody in one direction or not. But if you're going to coach a witness, there are times where that's appropriate. And I coach witnesses on almost every break. Almost the only thing I ever say to them is, listen to the question and make sure you're answering that question. Be sure to speak one at a time. That's most of what I cover with a witness. If your witness isn't prepared by the time of the deposition, you're kind of too late. So what are we needing to remind them on breaks? Remind them for a remote proceeding that, hey, I realize you're getting into a conversational pattern with this other lawyer, and that's normal, but we are remote, and even if you know what the end of their question is going to be, you need to let them finish, think about their answer for a moment, and then answer the question. So how to coach? The proper way is on a break, and why to do it. The why to do it is to help the proceeding. Help the proceeding. The witness prep should have been done long ago, and you should not be one of those lawyers that attempts to influence the testimony by hiding off camera and giving some kind of signal to a witness. The witness will come off looking shifty on a video. They'll be looking off to the side like I am now. A good lawyer is going to be able to expose that. And if it's something that you're really worried about and is known to happen with your opposing counsel, or you suspect it will, well, then maybe this isn't one that you should do remotely. But the vast majority of people whose names I've seen on this, attending this CLE, are going to behave appropriately. I say the best thing to do when coaching a witness for remote things is just make sure that they are helping with the integrity of the proceeding itself. All right. Best laid plans, right? Something almost always goes wrong. And I will confess that through much of the morning, I had a lingering thought in the back of my head. Gosh, there's going to be nearly 130 people on this presentation today, and it's going to be remote. And worse than that, I'm going to be talking about best practices for doing things remotely. And what am I going to do if it all goes south? Well, the good news is I've put a big dent in my time allotment, and it hadn't gone south yet. So if it goes south now, we'll just call it a restroom break, and you can listen to Joan in another 10 minutes. But it hadn't gone south. I have had it go south before. I've intended to conduct a deposition by video conference and had to, due to technological problems, revert to taking that deposition by teleconference. Just put me on the speakerphone. It'll be more cumbersome. I won't be able to see the witness. They won't be able to see me, but we're going to get through this. If that's what you end up with, go with it. If that doesn't work, reschedule. If it can't be rescheduled, then you better have a backup plan for that, right? You need to, if it can't be rescheduled, maybe it's just can't be done remotely. If it's that important and you're that short on time. If it can't be rescheduled, I tend to try to put it in the can, as we say around here, pre-record something weeks or months in advance. Now, I'll tell you, we called a witness, the witness I was thinking of earlier, remotely in trial. The witness was in Costa Rica. We tested it 3 days in a row. We had adequate bandwidth on both sides. We tested it after hours in the actual courtroom. We had the witness attend the day of trial, the whole day by Zoom, to see if we had any inkling that there was going to be a hiccup. And they were just fine the whole time, all morning long. We called them right after lunch, tested it again over lunch. We put them up on a big screen so that their head was about 5 feet by 5 feet in the courtroom. The sound was good, and we played it. Many of us are playing experts now by Zoom, live in the courtroom. But if your case in chief or your defense relies heavily on that expert's testimony, you probably should take a deposition establishing your key points before trial, because if it all goes south during trial, it's going to be up to the judge what kind of relief they give you, and you don't want to be that flat-footed. So that's my fallbacks. Video conference, if it doesn't work, I'm ready for a teleconference. The exhibits are with the witness. If the teleconference doesn't work, then we're going to try to reschedule it. If it can't be rescheduled, then I'm probably not going to paint myself into that corner without it having been pre-recorded and pre-scheduled. So we kind of end largely where we started. We have to have a plan, we have to have a backup plan, and we have to be ready to execute on any of those. As far as conclusions, I think that this is here to stay, and it's only going to become technologically more easy and more ubiquitous. I think that we're already seeing many of our more rural judges being very forgiving of a lawyer from St. Louis that needs to appear in a county 5 counties away from here, just appearing by WebEx. We see situations where criminal proceedings are big time video now. And I think the routine appearances are going to continue to be more and more remote. So practice with your technology. A Zoom subscription is very inexpensive. It can be used for conference calls too. And you can double dip there, reducing office expense. I hope that this has been somewhat instructive. And Mr. Litz, I'll field any questions that we have here before I turn this over to your next distinguished speaker, Ms. Lockwood.
I see none at this point, Morry. This is a great refresher and important practical information for all of us. I know you covered depots and hearings and appearances at trial. These processes have worked with experts, for example, in arbitrations, where I heard one and we had the experts all by Zoom live, and it worked just fabulously. We didn't have people having to come into St. Louis from New York and Texas, et cetera. The other thing I think is important to know is, these remote proceedings happen in mediations every single day. And the one thing I would say as a practical matter is, if the client can be with the lawyer in the same room, we're better off. I find there's issues where you have a client at home because you may get the dog or the cat or someone's coming in an afternoon from school. And I think that's always helpful to try to have them in the same place. But Morry, thank you as always, and great things to think through as we go forward.
All right. Thanks, Rob.
Very good. Folks, we're going to take just 2 minutes, and Joan will join us and we'll get started. Joan, are you there? Ladies and gentlemen, we're thrilled to have Joan Lockwood. Joan is a director at Gray Ritter Graham, civil trial lawyer, and as many of you who have attended our best practice programs over the years, Steve Ringkamp has been the torchbearer for the civil law update. And in his words, he says, "I've passed the torch to Joan." And we are so thankful, Joan, that you've taken this on. Many of you know, many of the folks attending know you. And I think it's important that the context of your involvement with MAI and on the committee and as a reporter brings you to this date. We will go until 2:20. I'm sorry, 2:20, and then we'll take another break after that. But Joan, please go forward. Thank you so much.
Thanks, Rob. Hopefully everybody can hear and see the screen okay. Steve Ringkamp's shoes are not ones that I can purport to fill, but we're going to do our best here today. And I am going to skip through the first several slides of the PowerPoint because I know that Marc covered a lot of the expanded remote access to CaseNet issues, which is so important for all of us to consider those technical, practical, and even ethical considerations that go along with the redaction requirements that, of course, become effective July 1st of this year of 2023. I do have a slide that talks about approved forms that are available on the judiciary website. And that's slide 8 of our PowerPoint. So I think those are kind of important. That's a somewhat new availability on the court's website, but something to just consider. Before we turn to the civil law update, one thing that I'm sure Steve always does as a member and prior chair of the MAI committee is go over new instructions. And as opposed to going over the new CaseNet redaction requirements, which are effective July 1, 2023, I'll talk about some instructions that are effective July 1, 2023. So most of you probably are aware that we are in our 8th edition now, which is kind of this maroon backed book. And there was a March of 2023 pocket part that you should have received. And in that pocket part, it contains all of the instructions that were approved in March of 2021 with an effective date of July 21. So what I often tell people, and most are aware of this if you do civil jury instructions, even when we have an approved date from the Missouri Supreme Court, you can use those instructions, but they're not mandatory yet. Once that date becomes effective, which is 6 months after the approval date, the use does become mandatory. Probably the most significant instruction that it's going to affect civil trial lawyers is a change to 2.01. And we changed subparagraph 8 to that instruction, which has to do with juror communication. Really important topic. We instruct against that in 2.00A. The court instructs against it in its admonition at every break. And of course, 2.01 also instructs jurors against doing or conducting outside research. So that's an instruction, as everybody knows, that you use in every single case, but it's changed. So starting July 1, you've got to use our new instruction. It's just slightly tweaked. You'll see other changes to some of the committee comments to the Missouri Human Rights Act instructions in Chapter 38. You'll see some changes to the instructions that went into effect even last July. So I just remind everybody to look at that pocket part. And if people are using the ProView, which is a West product, it requires you to update it. You should get an email notification to update it, but if you don't update it, you don't get the new instructions. And I had kind of an interesting thing occur when I was in trial in October. The defense attorney who was from out of state used an incorrect prior version of an instruction, and I was trying to figure out where she got it from. And it was from Westlaw, that where West had not updated the instruction. So, you know, kind of be cognizant of that as well. We don't control West. I do. Anytime I've got a new order from the Supreme Court, I forward it to them, but kind of check and double check that you're using the correct most recent instruction. So getting now into the civil law update for 2023, let me tell you what is covered in our separate handout. It's a 63-page handout, so it's pretty voluminous. We cover multiple different topics by category. Some cases are put into more than one topic. And we really just try to cover the key holding in that handout. The handout is something that I put together, but I've recognized the others who assist in that process on the cover page. It's something that we present at the Missouri Trial Attorney Convention next week. The cases in the handout only cover final decisions from May 1 of 2022 through May 1 of 2023. I don't include any workers' compensation case unless they deal with a civil tort law issue, including something that might be jurisdictional. So I'm going to endeavor to cover some of those key cases today. I've got about 20 included, but if anybody has questions either during the presentation or about a case that that they've got a question about that's in the handout, but that I'm not covering on the PowerPoint, you can send it to me via the chat or email me separately. My contact information is on the cover page of the PowerPoint. So the Brockington versus New Horizons case is a Missouri Supreme Court case that involves a grant of summary judgment. And the Missouri Supreme Court reversed that grant of summary judgment, which essentially found that a prevailing wage act didn't apply. Now, you know, the facts deal with an asbestos remediation contract, and the issue was whether the private contractors were entitled to prevailing wages under the Prevailing Wage Act, or if the act did not apply to workers who were hired by the general contractor. None of that is really important. But I think what is important, the key takeaway, is that the Missouri Supreme Court here reversed a grant of summary judgment because there were reasonable inferences which existed both that plaintiffs were and were not entitled to prevailing wages. And so the court reversed the grant of summary judgment and remanded the case for further discovery. There have been some important summary judgment decisions that have been decided, I'd say, in the last 2 years, really since 2021. The Hootsell case, which was a Missouri Supreme Court case handed down in 2021, is one that I turn to, but there are others as well that have really changed the way that we respond to and file summary judgment motions. So I want to talk a little bit about that, since I've deleted some of my topic on the remote access. When you're faced with a motion for summary judgment, one, you've got to timely respond. We all know that. But we've got cases from the Eastern District, particularly, where they're really no longer being followed. And the important thing is that appellate courts are not going to go outside the Rule 7404C paragraphs and responses. That's not the rule of thumb anymore. If a reversal or an affirmance hinges on certain facts, those facts must be in the paragraphs and responses, and they must be properly authenticated. Today, we'll talk about authentication, and we'll talk about what's proper in Missouri to respond based on some other cases that are in the handout. But kind of the important thing on summary judgment responses, you've got to put your facts in your response in those paragraphs, because the court is not going to look outside the record as it sometimes did. The material facts cited have to be actual facts, not just something the witness said. And that's kind of something we initially saw with Hutzel, but we've seen that law in the summary judgment context really develop over the years. So you shouldn't proceed a fact with witness X said, unless for some reason the mere existence of testimony is itself material to your motion, which often it's not. So the lesson really in the summary judgment context from these recent court decisions is that deposition itself isn't forbidden, but if a corporate rep, for instance, admits in his depo that the company's product is defective, the fact is the product is defective. The source for that fact is the deposition. But you don't want to say Mr. Corporate Rep testified that the product is defective. That's what the court has instructed us not to do in that Hutzel case. You know, one thing that has not changed with the summary judgment is the standard of review, both at the trial court level and at the appellate level. The record is viewed in the light most favorable to the non-movement, granting that party all favorable inferences. And I think that this Brockington case supports just that position. And also, again, the key takeaway that if you've got reasonable inferences in favor of both parties, summary judgment isn't appropriate. So it's a good reminder of that. But I just caution people, when you're doing a summary judgment motion, don't just read the rule. There's just a lot of case law handed down since 2021, and this Brockington case will get you to those cases that that really change the way some of us have responded or have moved for summary judgment. The next kind of case that I think is super interesting is a Southern District case, Gilmore versus Missouri Department of Social Services. And this is a case that's instructive for really two issues. One, how and when to apply the sovereign immunity cap when you've got comparative fault at issue in the case. And then secondly, which I'm going to spend some time talking about it because I find it fascinating, is the use of an adverse inference at trial subject to a spoliation order. So in this particular case, the facts are a rocking chair malfunction during a supervised visit at the Missouri Department of Social Services. A grandfather was there, and the members of DSS were kind of watching what was occurring through a mirrored window. The plaintiff, who sat on a rocking chair, suffered injuries when the arm of the rocking chair came off. And a few days later, a state risk management specialist directed the local DSS employees to throw out that rocking chair. After discovery, the plaintiff moved for application of the spoliation doctrine, saying that the division's disposal of the chair deprived the plaintiff of the best and only physical evidence to support the claim. And the division, in response, argued that the spoliation request was not proper unless the court found that there was intentional destruction of evidence indicating fraud or some sort of evidence that they were desiring to suppress the truth. The DSS had put into the record, we disposed of the chair due to safety concerns. So they argued that spoliation did not apply. At the trial court level, trial court grants the plaintiff spoliation motion, and during the trial allowed the plaintiff to read the following statement to the jury. And I'm going to quote it for you. Quote, defendant admits that an examination of the chair, which was discarded, would have resulted in evidence unfavorable to its position that the chair was not dangerous. And that was the end of the statement that the plaintiff's lawyer read to the jury. There's a verdict for the plaintiff, and it was affirmed. The spoliation order was not an abuse of discretion. So let's look at the standard that appellate court is reviewing it on, abuse of discretion. But the court, Southern District, says the spoliation order was not an abuse of discretion, and a party's failure to adequately explain the destruction of evidence can give rise to an adverse inference if the party shows that the alleged spoliator had a duty or should have recognized a duty to preserve the evidence. Here, this particular DSS employee who directed destruction of the rocking chair had been in a pretty high up position, a risk management position with DSS for over 20 years, and they held that the spoliation order was appropriate. The spoliation inference, which was read as an admission, not as a jury instruction, was appropriate, again, giving the high experience of that state official, despite and knowing, having direct knowledge that the chair caused the plaintiff's injuries. The court said, you know, it can be shown that the spoliator had a duty or should have recognized a duty to preserve that evidence. I want to talk a little bit about the use of an adverse inference by way of reading a statement to the jury versus submitting an actual written instruction. And there is a distinction. So we go back to an Eastern District case back in 2015. It was a Pisoni versus Steak and Shake case. And the court considered there whether a restaurant's spoliation of video evidence entitled the plaintiff to a not in MAI adverse inference instruction. And the court said that the Pisoni court said that spoliation, when established, can result in different remedies allowed by the trial court, including things like an adverse inference argument, an adverse inference statement, preclusion of the evidence as to what the missing evidence may have shown, and admission against the offending party. But that Pisoni Eastern District Court said a jury instruction on spoliation has not been approved under current Missouri case law. And there's been some back and forth with that, including the Hill case, all of which are cited in your handout or even in the MAI book. But in the absence of further appellate guidance or guidance from the Missouri Supreme Court, the MAI committee continues to adhere to the principle or the view expressed by that Pisoni court in 2015. But again, notes that even though there may not be a written jury instruction that's been approved for use yet, other remedies may properly be fashioned by the trial court under circumstances different from those in reported Missouri decisions. Even if we look to the Missouri decisions, including this Gilmore case, you can see where an adverse inference was read for finding of spoliation and an order to that effect. Important takeaway, though, is that the Missouri Supreme Court has not definitively addressed these issues, nor has it addressed the use of a written instruction. If you've got this issue, look at the general comment to MAI 1.00, that's on prohibited instructions. We revised that general comment in 2021, I believe. And there we say, we don't want to preclude appellate analysis and development of the law on this subject as to when, how, or whether a jury should be given an adverse inference instruction. We as a committee are just waiting for guidance from the Missouri Supreme Court or our appellate courts as to the giving of such an instruction. I think it's going to be interesting to see how the law on spoliation remedies, including the use of jury instructions, develops in Missouri. But this Gilmore case will kind of lead you to those prior decisions, really starting with Pisoni and ending with Gilmore on spoliation orders and remedies to utilize when you have that situation in a case. Now, with respect to damages, which is probably interesting to some people as well, here, the court held that a plaintiff's damage award is reduced by comparative fault first, and then if the amount is still greater than here, the sovereign immunity cap, the award is reduced to comply with the sovereign immunity cap on damages. And believe it or not, before Gilmore, that was not a decided issue. So this is a matter of first impression. And again, this was a sovereign immunity case because it was against the Department of Social Services. And they got an award, a jury award that exceeded the cap. And DSS says, well, we should apply that cap. There was a dispute as to whether the cap should apply before the comparative fault was, the verdict was reduced by the comparative fault. So Gilmore tells us the answer to that. The appropriate calculation in a sovereign immunity case involving comparative fault is to first reduce the damage award by the comparative fault assessed by the jury. And then if that amount is still greater than the applicable cap, you've got the court will further reduce it to comply with the sovereign immunity cap. I think it's instructive, not just in sovereign immunity cases, but in cases involving other statutory caps on damages, such as medical negligence cases, when those involve a submission of comparative fault. Let's turn next to this next case, JW versus St. Louis Public Schools. Here, the circuit court entered judgment on the pleadings in favor of the school district and a teacher on a minor's amended petition for sexual discrimination and retaliation, and the student appealed. And the reason I included this case is not really for the underlying holding of the case or what I guess the parties hope the holding might be or issue might be, but here the appeal was dismissed for lack of adequate record and for failure of appellant's counsel to prepare the adequate record on appeal, including the amended petition. The Eastern District had ordered that the lawyer correct the omission and supplement the record, and there was a failure to do so. So just a reminder that Rule 8112 requires all records, proceedings, and evidence, including pleadings on which the action was tried and the judgment and order that was appealed from, have got to be submitted. And if there's a material omission, the rule permits the court to direct the parties to correct the omission or to file a supplemental record. Here, the Eastern District reiterated the timeline of the appeal, the failure to file that record on appeal, and the failure to include that first amended petition, which again was what the dismissal was based on. So just remember, 8112, you've got an ability to correct it, but the obligation is on the lawyer to make sure that record on appeal is correct and inclusive of anything that was determined and at issue in the appellate courts. Why do I include, this somewhat innocuous case in our handout? The reason is because we've sort of seen renewed emphasis in our appellate courts on adhering to the rules. And we'll talk about the Hicks case later on, but that's really, we've seen an uptick in dismissals for failure to follow Rule 8404, which are our points relied on and briefing requirements in our appellate courts. But that's why I thought this was interesting that we're now seeing, we're just seeing a renewed emphasis by our appellate courts on, hey, you better adhere to and read the rules that apply. The Bridgecrest Acceptance Corp case is really an important case for anybody who does arbitrations or consumer arbitrations. So here, this was a unanimous Missouri Supreme Court opinion involving the enforceability of a consumer arbitration agreement. And the court held that when a contract and an arbitration agreement formed a single integrated contract, the courts evaluate that contract as a whole to determine whether the consideration is adequate, rather than looking solely at the consideration that's given to the agreement to arbitrate. If the consideration for the contract is adequate, then it can support that separate arbitration agreement. So a footnote of the opinion calls into question the Eastern District case of Caldwell versus Uniforced Corp., which is a case that people often cited to say, well, we need separate consideration for the arbitration agreement. Bridgecrest pretty much says that Caldwell, for that purpose, should no longer be followed. So real important case if you are doing consumer arbitration agreements and you've got a motion to enforce arbitration. But you'll kind of see, and this is probably something that Steve has pointed out, having done this for so many years and having done the annual update on the law for many, many, many decades, we've really seen an uptick in the ADR category. I remember when I first started speaking at the Lake on the civil law update, we maybe had one or two cases under alternative dispute resolution, and now it's one of our heaviest categories, likely because of the amount of consumer arbitration clauses in consumer contracts. So I think we'll continue to see that both at the federal level and our state Supreme Court as well. The Brown versus Chipotle Services case, it is another arbitration case, but here the denial of the motion to compel arbitration was affirmed by the Western District. I don't necessarily think it's as important from the arbitration standpoint as it is to what occurred at the court below. So in support of its motion to compel arbitration, Chipotle attached two unnotarized declarations, and each of them was submitted under penalty of perjury as exhibits. Oftentimes that's what's done in federal court. But here the Western District reminds us that not in state court. That's not what we use in state court. We do not use an unnotarized declaration. Instead, we use an affidavit. And an affidavit is a written declaration on oath sworn to by a person before somebody who's authorized to administer an oath, like a notary public. So the practice tip is in state court, adhere to the use of an affidavit signed before a notary public, not a declaration under penalty of perjury. Here, that was enough for the Western District to say this motion has to fail. So an affidavit that doesn't include that notary statement it's just an unsworn statement. It doesn't constitute competent evidence supporting the factual allegations contained in a motion, and you can't use it. Also, the affidavit, remember, has to allege firsthand knowledge of the allegations. So just another important thing to include in your affidavit is that, you know, they've got firsthand knowledge of what they're talking about. The Zerpa case, this is an auto crash wrongful death case, and the Western District reversed and granted a new trial due to an improper affirmative converse instruction. Affirmative converse instructions, in my experience, are really rarely used by defendants. They are described in MAI 33.01 and MAI 33.04. My advice when I speak on instructions is a true converse is a safer submission than an affirmative converse. And I think if you talk to a lot of defense attorneys, including Rob Adams, who's on the committee, and he was the chair before I became the chair of the committee, he says, I just don't use them. I don't use affirmative converses. I use true converses. If you decide that you want to submit an affirmative converse, first, read the Zerpa case. Second, read the Hires versus Lemley case. The cite to that is 834 Southwest 2nd 729. It was a 1992 Missouri Supreme Court case, and I've got that cite memorized because I get a lot of questions on this. You have got to have independent evidence to support an affirmative converse. Also, if you're using it, the verdict director has to contain an affirmative defense tail, which refers the jury directly from the verdict director to the affirmative converse. So that's really different than a true converse where you're not using a tail and you don't need independent evidence to support it. If you've got really a situation with converse instructions in general, just look at chapter 33. That's where converses are contained. And we've got a general comment that kind of goes over the distinction between true converses and affirmative converses, and use of converses when you've got multiple defendants, or use of converses when you have comparative fault. There are also some illustrations in chapter 35, none of which I don't believe contain an affirmative converse, but you'll see converse instructions throughout the illustrations. The Swoboda case versus the Missouri Commission on Human Rights. This is a Missouri Supreme Court opinion. Pretty interesting case, really. A Kansas City sergeant alleged that the Kansas City Board of Police Commissioners retaliated against him for testifying in support of another officer's discrimination claim, and further said that the board's law firm aided and abetted the discrimination by warning him during those deposition proceedings to, think about your career, consider how your testimony could hurt the board. And he essentially said, the sergeant, that, not only did the KC Board of Police Commissioners retaliate against me, but also the law firm aided and abetted in that discrimination. The Missouri Commission on Human Rights dismissed the charge, saying there was a lack of jurisdiction because there was no employer and employee relationship between the law firm and the sergeant. Sergeant could only sue the KC Board of Police Commissioners or get a right to sue letter. The case went up to the Missouri Supreme Court, and really the novel issue here is the ability of an employee to sue his employer's attorneys under the Missouri Human Rights Act for allegedly aiding and abetting discrimination. The Missouri Supreme Court framed the issue differently than the trial court in the Western District did. And the Supreme Court really focused on the procedural posture of the case, which was a writ proceeding. Since the case involved a proceeding in mandamus, the court focused on whether under Missouri law, the sergeant had a clear and established right to sue an employer that never employed him. And framed in that manner, the majority concluded he did not. So the court held the right to sue the law firm, an entity that never employed the sergeant, for discrimination was not clearly established, so he wasn't entitled to that writ of mandamus being granted. I included a second slide on this case because there was a 23-page dissent filed by Chief Justice Wilson, and he disagreed with majority on both the nature and the scope of mandamus review and the interpretation of the Missouri Human Rights Act. If you've got a kind of an issue involving judicial review of administrative decisions in a non-contested case, this is a must read, both the majority opinion and the dissenting opinion by Judge Wilson. So it's super interesting from the standpoint of the underlying claim that one can have, but I think perhaps more importantly is the way that the Missouri Supreme Court framed this issue, which was focusing on the procedural posture of it. And so it's got an even broader application for those who do writs or who have issues involving administrative review of administrative decisions. Let's turn next to the Zane case versus City of St. Charles. And there was a lengthy opinion out of the Eastern District, super interesting on issues, and then the Supreme Court granted transfer. And this is just a really interesting case involving notice to a city when you have a personal injury or an injury on city property. So here the trial court dismissed the bicyclist's action against the City of St. Charles for damages that the plaintiff sustained in a fall on an open graded bridge. And the reason for the dismissal by the trial court was the plaintiff's failure to give notice of the dangerous condition to the city mayor within 90 days of the injury, as was required by a St. Charles city charter. So St. Charles is a constitutional charter city with a population of fewer than 100,000 inhabitants. So it derives its charter power from the Missouri Constitution. I would point out that St. Louis County is also a charter city. So for those of us who do plaintiffs' PI work, and we sometimes find ourselves doing a premises action against St. Charles or even St. Louis County, you better look and pull the city charter. So here the Supreme Court affirmed the dismissal and held that a constitutional charter city can enact its own notice requirements that are applicable for waiver of sovereign immunity. So under 537-600, they can enact their own requirements for waiver of sovereign immunity. The statutory notice statutes that I'm sure every plaintiff's lawyer is familiar with are in section 82-210, but that does not apply to constitutional charter cities with populations of less than 100,000 inhabitants. The statute does not create a statutory notice requirement for the city, and it does not prohibit the city from enacting its own notice requirement. So here, St. Charles again enacted its own notice requirement by way of its charter that required notice to the mayor. So, notice requirements exist for different classes of cities in Missouri by state statute. You've got 77.600 that's applicable to third class cities, 79.480 applicable to fourth class cities, 81.060 applicable to special charter cities with population of 5,000 to 3,000 inhabitants, and then 82.210 is the one applicable to constitutional charter cities, but only of certain populations. And again, the court said that doesn't prevent that charter city from enacting its separate notice statute. So there is no state notice of claim statute that's applicable to the City of St. Charles or any other constitutional charter city with a population under 100,000. About 15% of Missouri cities are not covered by a notice of claim statute enacted by the state legislature. But again, those cities may have charter provisions that require notice of claims. And they may require notice in more instances than the state notice of claim statutes, and they may differ in their notice requirements, such as who to direct the notice to. Like in St. Louis County, it's I should say, the city administrator. I haven't actually checked that in probably 18 months or so, so I'm not sure if that was changed. But it may direct the notice statute to go to the mayor, the city administrator. You just got to check check to see if it's covered by a state notice claim statute, or does it have its own charter where the state notice requirement is not applicable. There are about 38 charter cities not covered by the state notice statute. You just need to check to see if that city or municipality has a charter that sets out a notice provision and adhere to it. The Hicks case, this is the case I referenced a little bit earlier. This was a recent opinion by the Western District Court of Appeals. And there were several predecessor opinions to Hicks, and they are a lesson and a reminder to practitioners to strictly adhere to the Missouri Rules of Appellate Procedure. So in the Hicks case, the appellant failed to conform to the requirements of Rule 8404, and the court did not reach the merits and dismiss the appeal. And the lesson from the decision is to read, reread, and meticulously follow Rule 8404 every time you file an appellate brief. So Hicks was an appeal filed following a grant of summary judgment on claims of work comp retaliation under the Missouri Workers' Compensation Law and hostile work environment under the Missouri Human Rights Act. And here, because the briefing failed to substantially comply with the briefing requirements of 8404, they dismissed the appeal outright following oral argument. So the case went all the way through that briefing stage in the Western District and all the way through the oral argument stage prior to the court not reaching the merits and dismissing the appeal outright. The Western District explained at the outset of its opinion that although Missouri courts prefer to reach the merits of a case where there are deficiency in briefs and briefs fail to clearly identify the issues presented for review, it puts the court in the untenable position of becoming an advocate by speculating on the facts, speculating on the arguments, and speculating on the issues of appeal. And that's why the court says there are times when there's such a violation of the rules where the court must dismiss. It's an interesting opinion because it explains the rationale of adhering to the briefing requirements by really looking to that Lexow versus Boeing Company decision, which was a 2022 Missouri Supreme Court case. I'm going to give you the cite to that also, because I don't think I included that, but it's 643 Southwest 3rd, 501, Missouri Supreme Court, 2022. And in that Lexow case, a lot of people will remember it. Missouri Supreme Court held unanimously that dismissal was appropriate again after oral argument for failure to comply with the 8404 requirements, and specifically the rule with respect to points relied on. The materials, that 60 plus page handout that I gave, I cited to just some of the many decisions handed down in the past year where the courts have dismissed an appeal in part or in full for failure to comply. And I was really pretty surprised by it. It's not just pro se briefs. It is really across the gamut. Sometimes they're dismissing an appeal in part. Sometimes it's the entire appeal. Sometimes it's prior to oral argument. Sometimes it's after. So it's just really something to be aware of. And I talked to some appellate lawyers who do exclusively appellate work, and they said they're finding themselves spending just as much time preparing a point relied on as they are preparing the argument under that point relied on, just because of this kind of renewed emphasis on Rule 8404 and appellate briefing requirements. For those who've been practicing since the 90s, we used to always cite to the Thummel versus King case. The standard really hasn't changed. So we saw after the Thummel case was decided in the 90s, all right, got to follow the rules. And then we after this Lexow case in 2022, there's just been an increased uptick, particularly by the Western and Eastern District with respect to adhering to the briefing requirements. So if you got something, maybe look at other briefs that have been filed, obviously that have not been dismissed. Talk to lawyers about how to frame your point relied on. The Hicks case in particular pointed out that there was a failure to cite to the factual record on appeal. And I believe that, I'm doing this off of memory, but I believe they said they'd only cited to the record on appeal 9 times or something like that. Remember that everything in your brief has to be supported by a citation to the record on appeal. All of that's contained in 8404. And the Hicks case really does a nice job of kind of going through the rules and the purpose of each subpart of those rules. This case, Complete Construction versus Frog Eyes, is a Western District 2022 case. And really it is just a lesson to us about what is a final judgment or order that can be appealed. I think we've seen a real uptick in these types of cases as well, where we've got our appellate courts looking at this issue where you might have a circuit court or a trial court certification of a judgment as final. But if the judgment fails to resolve all claims and establish all rights and liabilities within what's termed a judicial unit, it may not be proper, a proper certification of the judgment. So here, the construction company sued the defendant's business for breach of contract, enforcement of mechanics liens, various other claims related to a construction project. And the defendant filed 5 counterclaims. Several subcontractors also became involved in the underlying case. And the parties agreed to bifurcate the matter by trying the claims between the plaintiff and the defendant first and saving the subcontractors' claims for a later date. The jury returned a verdict in favor of the defendant on plaintiff's claims and on 2 of the defendant's counterclaims. The circuit court granted the defendant's motion for entry of final judgment despite the plaintiff's objection that there was no final judgment that had been rendered. And the circuit court entered judgment and certified it as final under Rule 7401B. The case was dismissed by the Western District for lack of jurisdiction, finding that the trial court erred in certifying the judgment as final because it can only be certified as final under Rule 7401B if it disposes of a judicial unit of claims, meaning it disposes of all claims by or against at least one party, or it disposes of 1 or more claims that are sufficiently distinct from the claims that remain pending in the circuit court. Here, the judgment satisfied neither prong. 2 theories of the defendant's counterclaim were not disposed of, and both the remaining and outstanding claims arose from the same construction project. So the appeal was dismissed for lack of jurisdiction. I cite in the, at least in the PowerPoint, to the Wilson versus City of St. Louis case. That site is 600 Southwest 3rd 763. This was an unanimous Missouri Supreme Court opinion, I believe unanimous, written by Judge Breckenridge. And it is, I think, a really good case handed down in 2020 about what is a final judgment from which an appeal can be taken. So if you got that issue, read the Wilson case. This next case out of the Eastern District involves issues of personal jurisdiction and the res judicata effect of a dismissal with prejudice. So we're a little heavy, I feel like, as I'm talking on civil procedure matters and appellate procedure matters, but an important case because here the plaintiff brought, then voluntarily dismissed, an action in federal court against a wheel manufacturer and other defendants. I think the underlying case involved allegations of both negligence and strict liability. Essentially claims to recover for injuries that the plaintiff sustained when he was inflating a tire. The plaintiff then filed the same lawsuit in Iowa, which was voluntarily dismissed. And then the plaintiff brought this case in Missouri Circuit Court. The court denied the manufacturer's motion to dismiss for lack of personal jurisdiction and also denied its motion for summary judgment on the basis of res judicata, specifically the dismissal of the Iowa lawsuit. And the manufacturer petitioned for writ of prohibition to require the court to dismiss the claims for lack of personal jurisdiction. The Eastern District granted the writ and ordered dismissal of the claims. Importantly, the Eastern District said, although there was personal jurisdiction because the manufacturer's actions created sufficient minimum contacts, citing to the Ford Motor Company versus Montana US Supreme Court case handed down in 2021, here the res judicata barred the Missouri action. So under Iowa law, a judgment's preclusive effect, if any, is determined by the laws of the jurisdiction where it was rendered. And under Iowa law, the dismissal in Iowa was a preclusive judgment on the merits. So that case was, so this case was dismissed based on res judicata. If you've got a minimum contact jurisdiction issue, you can read this case, but it's going to point you to that Ford Motor Company versus Montana 2021 US Supreme Court case. But if you've got a res judicata case, this one's pretty interesting. The Loomis versus Bowers case is a case against, oh gosh, it's 2:15. We're running out of time. This is a 2022 case against two security guards who ejected Loomis for public intoxication and essentially ignored his explanation that he suffered from a brain injury that affected the use of one side of his body. And he sued the casino under the MHRA for discrimination, and then later sued the individual security guards, asserting common law claims of negligence and negligent infliction of emotional distress. It was held that the 2017 changes to the Missouri Human Rights Act did not eliminate individual liability for discrimination in public accommodation cases. So the MHRA preempted those common law claims, and the only remedy or suit that the plaintiff had was under the MHRA. The common law claims were properly dismissed. Only thing I want to say about Morlock is that here, this was a summary judgment case involving an MHRA claim. The key takeaway: statute of limitations and failure to exhaust administrative remedies are affirmative defenses that can be waived if not raised. So here the defendants did not raise the affirmative defenses of statute of limitations and failure to exhaust administrative remedies. So summary judgment for the defendants was reversed and held to be improper. Rule 55.27A sets out the 11 defenses that can be raised by motion. Statute of limitations, failure to exhaust administrative remedies are not included in that list of 11 under Rule 55.27. So those must be raised as an affirmative defense or they're waived. So that's important for that purpose. Only thing I'm going to say about Garrison is that the Missouri interpleader statute was amended in 2018. This is a case that interprets those amendments. There's a couple of other ones in the larger handout as well. Let's see. Only thing on right is if you've got a challenge involving it against the weight of the evidence and what's required by Missouri law. I thought this case had a really good discussion of that standard in the opinion. So if you've got just an against the weight of the evidence challenge, this is a good case to read on how to interpret that. We've got about 2 more minutes. This is a medical malpractice action alleging a hospital and psychiatrist failed to arrange an appropriate level of psychiatric care for a patient at discharge, and the plaintiff attempted suicide by coating herself with hairspray, setting herself on fire, and she suffered 3rd-degree burns to over 42% of her body. Jury verdict for the plaintiff for just over $800,000, and the defendants moved for remittitor under 538.210, which is the cap on non-economic damages in medical malpractice cases in Missouri, saying that the larger catastrophic injury cap did not apply, which is the $700,000 cap, and rather the $400,000 cap did apply. As most people know who do malpractice work, there's 2 caps for non-economic damages, and the statute was recently amended And here, this is, I believe, the only case that has discussed kind of the meaning of some of the subparts of what is a catastrophic personal injury that entitles you to the larger cap. It was the application of the larger cap was upheld in this Western District case. Let's see, we got 1 minute to talk about Hill versus Wallach. I think this could be a separate CLE in and of itself. It is a case that talks about what constitutes work product and whether there was waiver of that. It's also an interesting case that talks about when and whether the affirmative defense of reduction is allowed. And I think that some lawyers are citing this case to say that the discovery of a prior settlement can be found out during the discovery phase before a judgment, but that's really, if you read Hill the way I do, which is I read it pretty narrowly, that was not held in that case. So I don't think that it really changes the procedure or the law with respect to when the timing of when one can discover the amount of a prior settlement, particularly when it is a confidential prior settlement. With that, Rob, I'm going to turn it back to you, but there's just a lot of super interesting cases handed down. If you've got a police light sirens official immunity case, Barron versus Beeger, which is Missouri Supreme Court case, is one that's important to read.
Joan, fabulous presentation, and I highly recommend everyone look at the materials. They are detailed, they are thorough. You made a comment at the very beginning about that Bridgecrest case by the Missouri Supreme Court. I just read an article that the ABA published about arbitration cases and how many there are. And they mentioned that in this current term of the US Supreme Court, they were going to have oral argument in between 70 and 80 cases. And there were oral argument granted in 6 arbitration cases out of that group from the US Supreme Court. So we see a fair amount every single year now by the Missouri Courts of Appeal. And for some reason, we have more than our share in Missouri on the arbitration side. But Joan, thank you. That was absolutely terrific.
You're welcome. Thanks for having me.
Great to have you. Folks, we're going to take 5 minutes, and then we will have our next segment, our first program in the Legal Legend series, and we'll be right back. So our next segment, I want to give credit where credit is due. Debbie Champion came up with the idea to have a Legal Legend series as part of our best practice programs. It was probably a month or two ago, and she and I had just settled a case that we were mediating, and she said, I want to interview your dad, just out of the blue. And from that, we came up with an idea to have, as part of our programs, periodically a Legal Legend series. And she said, I want to start with your dad. So all of you 117 who are on this Zoom right now, who graduated from law school within the last 30 years, probably never heard of my father, who was a circuit judge in Division 5 before Judge Zellweger, before Judge Hardin Tammons, before Judge Thea Sherry, and before Judge Kintz. And Debbie had this idea, and we recorded this just the end of last week, and we're going to play that for you now. As many of you know, Debbie is a partner at the Rynearson, Suess, Schnurbusch, and Champion firm, and I give her all the credit for this. I know they had a blast recording it, and if there are questions, she has agreed to answer emails about them. So with that, I'm going to ask Kelly to share the screen, and we will play this for you. except we don't have audio.
You have been in the practice of law for 76 years.
Right.
That is fantastic. So I wanted to talk to you today and share with everybody else some of the things that you've seen and done, and just talk about the fun life you've had. Are you ready to get started?
Right.
I do have to tell them one thing. You've got a bow tie on with pink, and I have a pink jacket. We didn't talk about this before we showed it.
That's true.
But that shows how together we are, doesn't it? So let's talk about you. Where'd you grow up? Where were you born, and what happened?
Born in New York City.
Okay.
Moved to St. Louis, and when I was 16, during the Depression, when my dad got a job here.
Yeah.
And went to finish high school here at University City High School. University. 2 degrees. Bachelor's degree in history and a master's degree in history.
Wow.
So that,
All right, well, let's go back to before you graduated. I guess where your age fits, World War II was happening when you were in college.
correct.
Okay, and so they took 18-year-olds. You were a little too above that, or because you were in college, you didn't get?
A little older.
Okay.
It didn't take me because I had very poor eyesight.
Yeah.
But mainly because I had a hearing problem.
Is that right?
And when I went for my physical, the head of the otolaryngology department at WashU checked me out and tested my hearing. This is long before they had hearing.
Right.
Said, son, if the Army took you, the first day the cavalry will go near you. You become totally deaf.
Oh.
The last thing we could take care of that. We don't use the Army. He said, by the time you go to college, I suggested, you can go home and finish your college, do something, make something of yourself. Three cards.
Uh-huh. Yeah. I bet. She did. She was. So he told you to go to college and finish that up and make something of yourself.
Right.
You took that to heart.
Yeah.
Let's talk about that. So you were at WashU and you graduated and went to Harvard for law school. All right. So tell me, I guess you remember some about New York when you went there.
A little.
But back then it had to be pretty hard, not as easy as it is now, to get to Boston to go to Harvard.
Went primarily by train.
Is that it?
Airlines were just getting started.
Yeah.
During the war, almost non-existent.
Yeah.
And the second train from St. Louis to Boston took about 20 hours.
Wow.
And that's life you never thought about.
That's it neat. Well, the fact that you went to Harvard in 1944 is pretty cool. Tell me this. What was it like? Were the classes pretty good size, or how many people?
No, we were the last small class.
You were.
A lot of times the guy went to the sermon.
Yeah.
No women.
No women.
Women were not admitted until about 9 years after I got through.
Okay. You did. Okay, that's good. and came here to go to Harvard Law School. How many people were in your class? Was it 100 or less than that?
I officially started with about 132.
Okay.
Of which 62,
Wow.
finished.
Wow. So they would weed them out back at that time.
They said about a third would drop out. Normally their class is about 500 or so.
Oh, wow.
And, project method, Harvard many law school did. I never knew what that happened.
You just answered the question.
We had classmates from all over the country, all over the world.
Yeah, yeah.
One of my good friends was from Nigeria. Greek.
Wow.
We couldn't figure out what the heck was going on.
Yeah.
There's some guys that taught us. So, for example,
Oh, is that right? Roscoe Pound was one of your professors.
one of my professors.
That's incredible.
Being the dean of
Yeah.
the year,
Yeah.
he had this big background. Came from Nebraska. And, morning. What put him on it, Nebraska Supreme Court. 30.
Yeah.
Yeah.
I did not know that. I mean, I don't know that any of us would know.
Yeah.
Uh-huh. Incredible.
He had a phenomenal memory for the story is told about 230. From the boats to England. He's there for the summer. His brother stayed here for the turn in there.
Uh-huh. Yeah. And it would all be hand graded.
485. He moved back. Come on, he missed by 4.
Oh, my goodness. Wow.
Well,
Almost, yeah, that is a number. That would help you be an expert in both botany and law. Who else did you meet at Harvard?
Austin Westman Scott taught trust. He wrote a treatise called Scott I Trust.
Okay.
Stan Willison.
Yeah.
That's our contract.
Yeah, yeah.
Who was there, but was not teaching when I was there. Archie Cox.
Archibald Cox. Yeah.
Who later became one of the participants in the Saturday Night Massacre during the Watergate. And he was there with a couple of my classmates, Elliot Richardson, Jim St. Clair, Stevie Venker and Sterchi was an expert on the Fourth Amendment. Full-Day law. Larkin, who was practicing in 1938. End of the year.
Yeah.
So during the year, each professor supposed to tell one joke,
Okay,
but welcome.
they were given one.
Lockwood would tell the story about the American. The fox hunting in England.
Uh-huh.
Or the goal is said to it. What I want to do is like see the fox. Very simple, young man. Let's get a county hole, and we'll come and fence the fox. Well, the writing, you'll see the fox, the American. You get so flustered, you can remember what to say, and said, there goes the son of a bitch. On the last day of class, the professor is ready to walk on the lecture hall. The condition, all the students stood up and applauded. And they did that for Rockman. And as he passed by me, somebody yelled out, tally ho.
That's hilarious. That's good. That's funny. I understand you graduated with Sumner Redstone too.
Sumner Redstone was not very distinguished.
I was gonna ask. That's funny.
He became a multi-billionaire.
Yeah.
And every year, our law school and most schools do try to raise money from the alumni. And one year, not too long ago, he said passed away, but my class, if there's very few of us left in that. $5,010,000.
Oh my goodness.
Redstone donated $5 million.
Okay.
Made it 10,000. I gave them.
Well, all you really need to tell people is, Redstone and this other guy and I, we funded that $5 million gift. Because that's true. It's true.
Right.
Okay, so then you graduated in 47?
Correct.
Did you go to graduation? What happened? How was graduation?
Well, I missed the law school graduation, so I hadn't been home in almost a year. Speaking speaker was General Marshall. of Criminal Correction, we call it the 3Cs, located at 12th and Clark, across from the city hall and the police department.
Okay, right in that
They
area.
had two judges, right on the party label, you're nothing but misdemeanors.
Okay,
And then on 12th Street, the federal, in the criminal court building, you also had the sitting court. We used to call them the police court to hear ordinance violations.
okay,
So lawyers in those days had to do a lot of walking.
yeah,
If you had an office in downtown St. Louis, you walked to the civil court building, to the federal court building,
yeah,
to 14th Street, to the 3C. Very rarely did anybody have any litigation in St. Louis County. It was like a rural county in those days.
wow,
They had their own bar, maybe a couple of dozen lawyers in Clayton, and all had 4 circuit judges, all Republican, all ran on the party label.
really?
And before 1979, when the judicial article was adopted, magistrates, who are now called associate
Yeah,
circuit
yeah,
judges, were elected on party label all over.
okay,
The city, they were quartered in the civil court building. In the county, they were all over the county in rental quarters. North County, Central County, South County, and so forth.
okay.
Right.
So spread out kind of evenly.
Spread out, right. They had 2 in the Clayton in rented quarters. And trials were very rudimentary. When you were trying a civil case in St. Louis or anywhere in Missouri in those
Yeah.
days, no MAI.
Oh, I guess that's right.
You had to make up your own instructions.
Wow.
At one time, I was requested by the Bar Association with another lawyer to check something. In those days, we had the St. Louis Court of Appeals, which is now the Eastern District. We found that civil cases on appeal, 40% were reversed because of faulty instructions.
Really?
So it was shooting crap
Yeah, just
to get a one that would be approved by the court. Missouri had in those days what they called the rule of uniformity. Supreme Court had a rule that no civil judgment would be approved unless it was in line with the rule of previous cases.
okay. So there had to be some sort of precedent. Or it wouldn't be approved. Okay.
If you had a case, for example, in the wrongful death statute, when I started practice was only 5,000. Then it went to 10,000.
Really?
Then it went to 50,000.
Yeah, I didn't know that.
And if you had a judgment, say, for 10,000 for wrongful death,
Right.
and you got a verdict of, say, 15,000, they would cut it to 10 under the rule of uniformity. Crazy,
Wow.
crazy.
When did they do away with the cap? Because we've never had a cap since I started, and I started practicing in '88.
Yeah, they took the cap away, I think, in the late 60s.
That makes sense. Yeah, that makes sense.
And it came about because there was a lawyer that worked for Thompson Mitchell, who became general counsel of McDonnell Aircraft.
Oh, yeah, yeah.
And he was driving along Lindbergh one day, and they didn't have any barrier, and someone came across the hidden lane and killed him.
Oh.
And his wrongful death case, his life was only worth in those days 50,000. And that was the impetus for the General Assembly to wipe out the cap.
Yes, that makes sense. Because of him. That makes sense.
In those days, if you tried a case, civil case, you got one figure. It includes your medical, your lost wages,
Yeah.
everything, all in one figure. We never broke it down. We had contributory fault.
Yeah, that's right.
Or contributory negligence.
Right.
So, the trials didn't take long. Some lawyers tried 2 and 3 cases a week.
That's what I've heard. How could they do that? Why were they so much shorter?
You pick a jury, maybe an hour.
Oh, didn't go through all the detail we do now.
You'd have the plaintiff, 1 or 2 witnesses testify, medical maybe. It would go to the jury either that afternoon or the next day. You didn't worry about instruction. And the arguments were 20 minutes, a half hour.
Got it.
In rare exceptions, maybe an hour.
Yeah.
Very few. The one thing about the law practice in those days, lawyers almost never lied to one another.
I was going to ask you about how people got along.
The ones that did were you count on one hand and word would get around. The lawyers' word was in bond. If you and I met on the street and I said, hey, we've got this case coming up next week. What do you think we settle it? And we would settle it right there on the street corner.
Right.
And nothing in writing.
Right.
And never had a problem.
What changed, Judge? What do you think? Do you look back and think, this is when that I guess the opinions of lawyers went down? Was it Watergate?
What changed? I'm not sure. Of course, a lot more lawyers came on the scene.
That's true. A lot of competition.
Right. And with very little experience. And by the way, in those days, we would communicate by telephone or red letters.
Right.
I remember I once had a case with Morry Venker.
Yeah, sure.
A giant criminal lawyer.
Yeah.
But
Well
I defended
renowned.
the case and agreed to pay his client a certain amount of money. And I got a letter from him. Morris was noted for brevity in letters. He wrote, "Dear sir, enclosed fine executed release, period. Then check, period."
And you sent the check, and that was the end of that. Isn't that funny? Judge, you mentioned you had a
take a deposition. You call the other lawyer and say, "How about next Thursday at 1 o'clock?"
Yeah.
And that was it.
You didn't have to call 7 people, get it set up. Then you just
Right. And depositions were fairly short.
Yeah.
Doctors would often testify live in court, which is a lot different.
Totally different now. Technology has changed that.
Right. And the technology was rudimentary.
Oh, sure.
No DNA, no MRI, no CAT scan. Matter of fact, when I was on the bench, I had the first CAT scan case.
You did.
The manufacturer, I think from Belgium, manufactured something called CT scan. And I didn't know what that was. They told me it's a fancy x-ray. Okay. And Barnes Jewish was being sued for not paying the bill, about $600,000. And their defense was it was faulty. And we tried it in front of a jury. And in the second day of trial, I settled it. And that's how we found out there was such a thing as a CAT
That's
scan.
how you found out. That is so funny.
Right.
Tell me, what was the year you went on the bench?
I went on the bench in 1975 and I retired in 1983.
Okay, before we get to the bench, let me ask you this. Looking back from 75 to 47, how through the first decades that you practiced in, 40s, 50s, 60s, 70s, how could you see the law, not the law, but the legal practice changing?
It was slow changing. The technical advances complicated the trial. The Supreme Court of Missouri, which handled direct appeal more than they do today.
Yeah.
We had the St. Louis Court of Appeal. It did most of the work, and very few appeals went to the Supreme Court.
Right.
But
that's a big change.
That was a big change. Lawyers on appeal had to write briefs and had to be published. Went to a publishing company to print your brief. The Supreme Court had two divisions, 1 and 2, and they heard a lot of cases, not on paper, but direct. The technology advanced.
That was a big change.
That was a
wasn't
big
it?
change.
Big change.
And then when they changed the judicial article, for example, in domestic relations cases, up until 1979, judges had nothing to do with property.
What?
You're on your own if you want to divide the property.
Well, okay, so let's say we were married and we were getting a divorce. Who kept the house?
Right.
You figured it out on your own?
The court only provided for whether there was a divorce, child custody, maintenance,
yeah,
attorney's fees. That was it.
Maybe child support.
That was it.
Was support paid or not?
Right. Support.
Yeah. Okay. That's
And,
it.
The court had nothing to do with property, so divorce cases took almost no time.
That's
So a lot of
crazy.
non-contested divorces.
How do you get the divided property? You just figure it out.
You're on your own.
Oh, that is hilarious.
Sometimes equity suits were filed,
Yeah. Yeah, I bet. Yeah. I can see that.
or there's self-help.
Wow, that is it. That is amazing. All right. So you did everything. You did probate, criminal, family, civil, all sorts of
Right.
cases.
All
It-
kinds of matters that you never heard of today. For example,
I bet. Equity, all sorts of money.
I had a case involving dower right.
I've heard of that, but I can't remember what it is.
Support of a widow.
Like a dowry.
Died without a will.
Okay.
And how much money went to the wife. This was 19th century.
Oh, 19th
After
century
they had
law.
one.
I'll be doggone.
As I said, instructions were rudimentary.
Yeah.
They weren't
If
complicated.
you had to start over today you were entering the practice, knowing what you do about those areas, criminal and probate and civil and family, what would you have picked if you were going to specialize?
Well, there were very few specialists in those days.
Yeah.
You handled a case.
You did it all.
You did it all. Whatever
I
came in.
like that. I like that notion of doing it all.
Right, and the thing that really developed it was taxation.
Oh,
They get
gosh.
Experts in taxation. Patent law started to come in. The paralegals started to come in.
Yeah.
Give you an example. People didn't have iPhones. If you tried a case and the jury came in, you'd want to call their office and tell them what happened, right? You'd run out in the hall and look for a payphone.
I guess that's right. That's right.
Right.
You didn't have an iPhone. You
Right,
couldn't text people.
Right. And when I was presiding judge, I got the Bar Association to sponsor a lounge in my conference room and put up 2 telephones for use in the bar.
Oh, that's fantastic.
And lawyers would
That
go
was
and
brilliant.
come running in and use that.
Well, let's move to you being a judge. Did you run or were you appointed?
I was appointed.
You were. So by that time,
It was nonpartisan.
nonpartisan. Okay. So let's talk about that. So you served from 75 to 90, what? 95, 93?
93.
That's crazy. That's a long, I mean, and you had a good full career
Yeah.
before you got on the bench.
Yeah.
So
right.
that's good. So tell me, as you look back as a judge, what do you think your greatest accomplishment was? Getting those phones for those attorneys, I'm sure it was a practical one.
Well, I never thought I did anything spectacular.
Well, you did.
Uh,
Whether you thought it or not, you did a lot of spectacular things.
as a judge, I handled almost everything. From murder.
You did.
I actually had one murder that was executed. I tried a murder case under a death threat. Civil cases, I had almost any kind you could think of.
Everything.
Everything. We had in the St. Louis County, 1 week would be in civil jury trial, 1 week in criminal jury trial, 1 week in equity.
Okay.
And 1 week in domestic relations.
Okay. Wow.
And so you handle a whole coterie of it, almost anything.
Yeah.
You name it, I think I've tried it.
You knew it. I like that. That made the best judges, didn't it? Those made good judges.
And by and large, trial lawyers, before they were known as litigators,
Yeah.
we call them trial
Trial
lawyers.
lawyers.
We had quite a good group of lawyers. The average lawyer was expected to try his own case. And I'm talking about, you get a fender bender case. But if you had a real big one, they would hire someone that had the expertise.
Yeah. Yeah.
Which I guess they still do.
I guess so. Yeah.
But,
Depending on what the area is.
Yeah. The average lawyer had office practice, a lot of corporate work,
Yeah.
probate work. And incidentally, we had separate probate judges, one in the county, one in the city.
You did.
And they had hearings, handled all the technical aspect of trying to portioning out the probate work.
Yeah.
And the average lawyer had their own probate practice.
Huh.
Nothing was real complicated in those days.
Yeah.
Very few trusts set up.
So, Judge, there really weren't trusts back then, were there? I mean,
Right.
you didn't know about. Judge, would you say, as a lawyer and as a judge, most of your friends were lawyers?
Yes,
You like lawyers?
lawyers and judges.
I do too. I like lawyers. So they're my friends too. Some people don't like working with, or they'll fine with working with lawyers, but they don't like being friends with lawyers. I find lawyers are good friends.
Right.
So how was it when you transferred from the practice to a judge? You kept the same friends.
Well, as I said the day I was sworn in, I'm like an umpire in a baseball game.
That's right.
I'm a ball player one day, the next day I'm behind the plate, calling balls and strikes. You had to be even-handed, so forth. And the judge is dependent on your experience, your training, your outlook. Try to give call it as you see it, like an umpire does. A lot of lawyers became experts in the cases they handled.
Right.
I remember one time I had a case involving severe eye injury. And I took a deposition of an eye doctor, an expert. And during he said, young man, that last question you asked me, you know more about that part than I do.
Did he really?
Yeah. Because
that's a compliment.
Lawyers became experts in the cases they had.
You do. You may lose it later, but
Right.
you got to know it then.
Right, right.
What was the hardest as a trial judge? What was the hardest thing or some of the most significant challenges you personally faced?
Well, and most judges will tell you, I dislike hearing domestic relations cases.
Yeah.
And the hardest thing I had to do was decide child custody.
Hard.
I recall I had one case that really bothered me. young couple had nothing except the most beautiful 3-year-old daughter I've ever seen. Could have been a movie star. Blonde girl, beautiful, like Shirley Temple.
Right, that's what I was thinking.
And they both wanted custody. The problem was mother was a convicted prostitute.
Oh, no.
And father was a convicted drug dealer. And what do you do with the kid?
You can't give them to somebody else. That's what you want to do.
The easiest thing to do is give it to foster care. And it bothered me so. A few days later, while I was taking a shower, I remember testimony of the wife testifying. She got along with her mother-in-law better than her own mother, who was an alcoholic. And she was babysit for the baby. I contacted the lawyer, got the father's mother come into court, subject herself to the jurisdiction of the court.
Right.
And after checking up on him, I gave the baby to the grandmother with the right to the mother and father to see the child at regular time and so forth. And I monitored that for a year and it worked out.
Really? That's wonderful. It worked out for the baby.
Right.
That's the main
Had a
thing.
family.
That's exactly right. It had both parents in its life.
Right, right.
That's wonderful. In her life.
Yeah. One thing, as a judge, you had to keep you cool when something untoward happened. Usually during criminal cases,
I'm not good
people
at
would
that.
act up in court and so forth and so on.
Yeah. Hollering and yelling and
Yeah. But the usual routine of cases, you came to know the lawyer and what their proclivities were. And so
right,
forth.
right.
Very few times that I ever had a problem with the lawyer.
That's good.
I never held a lawyer in contempt. I came close once for lying to the court.
Well, that's a problem.
Yeah. But the lawyers knew what their boundaries were and so forth and so on.
That shows though, Judge, you kept a good court.
Right.
You know, you kept a rule on things.
When I started practice, jurors were summoned and sat all week. So if you had a case that very seldom would go out to trial on a Wednesday, usually Monday and Tuesday.
Yeah.
And if you had something on a Wednesday, you got the rejects from the rest of the week. The juror pool wasn't all that good. So the court appointed me in 1976, after we got a grant from Uncle Sam, to study the jury system throughout the country. In those days, one day, one trial system had started in Texas. And I traveled around and looked at the jury system throughout the country. And we decided to go to the 2-day one trial system, which still exists. If a juror was not sent out on a trial on a Tuesday, they were let go. On Wednesday, we got a new panel. So after we had a first pool, I remember one week I tried 3 jury trials in a week. 2 rape cases and a medical malpractice starting from Monday through Saturday.
Yeah, yeah.
I had no compunction of having a jury sit well into the night.
Well, I'm tickled because you said you had a trial on Saturday. You and I may be the only two I know that had a trial on Saturday. We had a trial that started Thursday. It was weird. Thursday, Friday, Saturday, Monday.
Right.
But
the jury
didn't care. They wanted to come back.
Usually in the criminal case, locked up.
Yeah.
We let them go out on a Friday night and bring them in for a Saturday. incidentally, I found out I once had a murder case, and we got through trying it all week, including Saturday. And I got a note from the jury saying, it's now 9 o'clock on a Saturday. Can we come back tomorrow? And the lawyer said, sure, that's no problem. I said, wait a minute. In the back of my mind, I recall an old law in Missouri. You cannot hold court on a Sunday.
I didn't know that.
So I asked the lawyer to see if they could find the law. Well, they woke up the prosecuting attorney. They checked it. Anyway, Saturday they came back and said, we can't find anything. I said, do you look at the digest under Sunday?
Come on.
No. And I pulled it, there it was. You can't hold court on a Sunday because you receive a verdict.
Oh, perfect. No evidence on a Sunday.
Right.
I did.
So-
Is that still the law?
So this one case, I had the jury come back Sunday morning. They came in within an hour with the verdict.
Wow.
Yeah.
They thought about it
As
overnight.
far as I know, it's still a law.
That is so much fun. All right. I want to ask you one more question about back then, and then I want to come to what you're doing now. How was your experience working with judges when you were a judge?
I had no problem.
Good. You had a good group at the
We
time.
had those all kinds of personalities. Where some judges were lazy. Some would hear cases and not be able to make their minds up.
Yeah.
Supreme Court removed several of them.
Oh, is that right?
Yeah. We had one judge, Paul Corning, in the 70s. Good guy, good lawyer, good judge. They couldn't decide anything.
Yeah.
He'd have cases under submission for up to 2 years.
Wow.
And the Supreme Court finally removed him.
You know, it's one thing to be a lawyer and not be able to make your mind up because you see both sides and you have to be an advocate so you can put that hat on. But to be a judge, you got to be able to be decisive.
Right.
Yeah, that's right. Well, tell us about now. So I know that you are still writing and reading and publishing. So tell me about what you've been doing for the St. Louis Bar Journal for the last several years.
57th year.
Is it your 57th?
Writing book reviews. for
That is
Bar Journal.
incredible. So tell me what you do. So St. Louis Bar Journal, which is the Bamsville publication,
Right.
you write a book review
Right.
and put that in, what is it, once a month?
No, it comes out 4 times a year.
Quarterly. I couldn't remember.
And they let me review any kind of book I want.
I was just going to ask, is it just legal
I didn't
related?
do real technical stuff you see in a bar review.
Yeah.
Mostly novels.
Yeah.
Books about the law, about courts, about the Supreme Court and
Yeah.
so forth and so on. In fact, I did one not long ago about the trial of Jack Ruby.
Oh, sure.
Jack Ruby was the killer who killed the killer of the president of the United
That's
States.
right. That's right.
And he was tried in Dallas County, Texas. And the case was tried by the prosecuting attorney of Dallas named Henry Wade.
Henry Wade. And didn't Jack Ruby shoot Lee Harvey Oswald through some sort of underground passageway? I remember seeing the detail, but I can't remember. Okay. So a lot of witnesses.
Well, let me just say there, I mentioned Henry Wade specifically.
Tell me about Henry Wade. Yeah.
Because Henry Wade later on became famous in a federal case called Roe versus Wade.
Are you kidding?
The same guy.
That's fascinating.
Yeah.
So the guy who prosecuted Jack Ruby is the Wade from Roe versus
Right.
Wade. Wow, that's interesting. I did not know that.
Yeah. During the Jack Ruby case, they tried in the courthouse in Dallas, and like the 15th floor. I
Yeah,
think,
yeah.
where they had the court. And above that was the county jail. There was a break where the prisoner broke out of jail. And I Peter Ruth, one of them took a bar of soap with shoe polish on it, make it look like a pistol. And they held it, and about 6 of them walked out of jail. Instead of taking an elevator, they walked down the steps, walked through the hall where the Ruby case was being held, and walked out of the courthouse. They were captured. When they walked through the hall where the trial was being held, the wife of Ruby's lawyer, who Melvin Belli,
Oh, I know Melvin Belli, sure.
his wife was in the hall interviewing a witness, and they walked right by him. No police were there at the time.
Yeah.
And I did one not too long ago about the trial of the state of Alabama versus Dr. Martin Luther King Jr. He was a young preacher who moved to Alabama, practically unknown, but helped put on a strike against the bus company. And that put him in a national notoriety.
Yeah.
And speaking of him, I once met his father,
Tell me about that.
Dr. Martin Luther King
Senior, I didn't, yeah,
The most
I assumed there
amazing
was.
man I ever met.
Are you kidding? Tell me about him. How did, first, who is he? I mean, and what, I mean, I know.
He was like his son, he was taller,
He
had a
was.
deeper voice. I belonged to a group of lawyers throughout the country. Was organized by Judge Tom Clark in the Supreme Court years ago, who realized that judges in large cities had problems that they didn't have in rural communities. And I was on a conference seminar in Atlanta, and a lawyer in Atlanta got Dr. King Sr., who then retired,
Yeah.
come and do the invocation. And we got through, I, like several others, got in line to meet him. And I thought I'd shake hands and leave. Shook hands with him. He said, "Young man, don't run off. Tell me about yourself."
Did he really?
He said, "Do you have a family?" I said, "Yes." This is my wife, introduced my wife. "You have children? You're a lawyer, aren't you? Where are you from, sir?" I said, "St. Louis." "You know, I've been in St. Louis." It went on and on and on. And just as warm and friendly as you can.
I'll be doggone.
I'm probably one of the few people west of the Mississippi that ever met him.
Yeah.
They called him Daddy King.
Daddy King. I love that.
Yeah.
Very charismatic, it sounds like.
Right.
And who else can you think of through the years that you've met that were interesting?
Yeah. I met President Truman on 2 occasions.
You did.
Truman was out of office.
Okay.
Didn't like to fly. And when he lived in Kansas City, he'd take a train, go either in Washington or New York, see his grandkids. And there'd always be a stopover in St. Louis. And several hours delay. And we would have lunch at the old Sadler Hotel. They had a great restaurant called the Red Room, Cafe Room. And senior partner of the firm I was with occasionally would take me to lunch there. And one time we're having lunch, all of a sudden I hear a buzz of people. And we turn around. There in the back of the table was President Truman and Mrs. Truman.
Doggone.
And a Secret Service man. And people would come over to him.
Yeah.
"Mr. President, would you sign it?" Finally, he started to walk out. He walked by our table. Senior head of our firm, Chapman at the time, knew him when he was senator in Missouri.
I'll be doggone.
When you address somebody that had notoriety, you address them by the highest office they ever had.
Right.
When Truman came by, he said hello. Chapman stood up and said, "Hello, Senator."
Instead of Mr. President.
Mr. President. He said, "All right, we'll go back a long way. I want you to meet my young associate, Arthur Litz." And I stood up. He said, "How are you, young man?" I said, "Fine." Anyway, about a year later, the same thing happened. He's back. This time he came over, grabbed my arm, and he said, "Young man, is he taking good care of you?"
Is that what
I
he said?
"Yes, sir, Mr. President, thank you."
That is neat. That's funny.
Just the way you picture him in a picture, in movie and so forth. No breath of grace,
Yeah.
5 foot stuff.
Do you have his hat on?
Just as friendly as he could be.
That's good. You told me earlier before we started today that you got a letter recently from President Biden.
Correct.
Congratulating you. It was a nice letter on what a difference you've made in this world and your generation has made. Have you met any Supreme Court members?
Yes. Matter of fact, I'm probably one to see trial judges that had a future Supreme Court judge try a case before you.
Really?
Clarence Thomas.
Oh, sure. That makes sense.
Well, at that time, the Assistant Attorney General of Missouri just graduated from law school. And Jack Danforth, who was the Attorney General, hired him.
Yeah.
And I had a case involving the assessment of real estate in St. Louis County, and he represented the state tax commission. And as a result of that case, got to know him fairly well. I would like him, the young lawyer. And there's an incident a few years after the case was over. He called me one day. And he said, "I'm coming into St. Louis. I'd like to talk to you about a personal matter." I said, "Fine, Clarence, come on in." Came in, I took him to lunch. He said, "I've got an offer to go with to be a lawyer in Monsanto." His forte was taxes.
Okay.
And I wanted I don't know many people, your opinion if I should take the job. I said, "Clarence, before I answer that, I'm going to ask you one question. You want to spend the rest of your career in Jefferson City?" He said, "Thank you, I know what the answer is." He said, "By the way, if I move to St. Louis, where's a good place to live?" I said, "Clayton." He bought a house in Clayton.
Did he really?
A good school district, sent the kids to the Clayton school.
Yeah.
And anyway, he took this job at the Monsanto. Next thing I know, he's in Washington, the EEOC. And when Thurgood Marshall, incidentally, I met Thurgood Marshall.
Oh, you did? Oh, I love
Yeah.
Thurgood Marshall.
This is 1955, a year after Brown versus the Board of Education.
Sure. Wow.
I was a young lawyer. I was in New York for one day on business. And that night, I went, of course, by myself to a steak restaurant in Manhattan. And I look around, and about 10 feet away from me, and there was Thurgood Marshall with his wife and mother having dinner. And being a brash young lawyer from St. Louis, I walked up to him. I said, "Mr. Marshall, I don't want to interrupt you. Please excuse me, but I want to come and congratulate you on the Brown case." He was very nice of you, young man. Thank you. This is my mother and my wife.
He introduced you.
Yes. He's very charming. Anyway, when he was on the bench and he passed away, there was an opening on the bench. And President Bush the first to make the appointment. And I wrote a letter to him recommending Clarence, thinking that would be a black sheep.
Right.
And anyway, I didn't think much of it. And when Thomas was nominated and had the Senate hearing, I got a phone call from the White House. Young lawyer said, "I want your permission to show your letter to the president, the members of the Senate." I said, "By the way, how do things look?" And he said, "We're cautiously optimistic."
That's a good way to put
And we
it.
know the rest of it.
Right, right. We know the rest of the story.
I also met Justice Cowden, who at the time I met her, she was the dean of the Harvard Law School. I went back there for a reunion. A very charming lady.
All right, Judge, we're getting the wind up time, but let me just tell you this. We spent some time talking about people that I don't know whether I'm going to call them influential people or important people, but I got to tell you, you're at the top of that list. And it has been a pleasure to follow, not really follow in your footsteps, because I haven't had any of the success you have, but at least I get to read your book reviews. I at least get to still learn from you every time I see a BAMSL publication. And I have had a blast today. I would like to keep you going 3 hours, but it's only a 1 hour CLE. So I'll just thank you very much for being here and say, if there's anything else that we didn't get to cover today that you would like the listeners to know, whether that is about the guiding principle in your life or anything you think a judge has to have, let's end on that. You tell them that or tell me that, and then we'll end our session today.
Well, I was happy to serve with my clients when I was a lawyer on the bench. I tried to do the best I could, give everyone a fair trial. I would treat lawyers and litigants alike fairly. I was happy to see that blacks and women that come into the profession went on the bench. And many fine women lawyers today that we didn't have in my day, which I was happy to see. I hope that lawyers today become more civil to one another, use their knowledge and training, serve, after all, we're serving the public. And
that's a good point.
And you do the best you can, and you'll have a good life. And I was so happy, and I was happy to be here today.
Well, thank
so
you
much.
very much. Thank you.
Thank you.
Folks, that was our first of our Legal Legend series, and the thing I'm reaching out to you is to come up with additional names for folks to be interviewed in the future. This was Debbie Champion's a terrific idea, and I know she had a blast with the interview. I hope you enjoyed this initial program. We're going to take just about 3 minutes, and then we will have the next part of our agenda talking about cybersecurity and how that involves us as lawyers in protecting confidential information that we have and that of our clients. We'll be back in just a couple of minutes. So our next program is focused on our practice as lawyers in protecting information that we have and that of our clients in terms of cybersecurity. Our presenter is Edward Wilson. He's a principal in a local firm called ArchTech. His bio is at the back end of our materials, but they have more than 1,000 lawyers who they help manage their IT, as well as folks in around 50 plus offices. That includes ours here at USA&M. I sat in on a cybersecurity program at the last MOBAR meeting, scared the heck out of me, and thought this would be something that I thought all of us could learn about. So Kelly, why don't you go ahead and play this, and we'll go forward. And having working on the audio, so give us just a second, folks. Give us just a minute and we will try to restart this.
I suggest that what we could use here is an IT person.
Edward, are you there and are you on?
I am here, as a matter of fact.
Okay, so for whatever reason, my fallback was the same copy from the same folder. It would not open for me. And for Kelly, I could not see from her machine where to share audio within the share screen function.
I happen to be sitting here with a copy of the PowerPoint presentation, as it turns out.
I'll tell you what I'm going to do. I will make you a co-host and just let you play it.
Fantastic.
Oh, thank you.
We're not guaranteeing this is going to be any better whatsoever, but
well, I can tell you so.
All right, let's see if I can get my screen to share the way we want it to. And I'm going to share. Now, cross my fingers.
Yep.
Everyone is about able to see the presentation. And does it look okay? There's no menu bars or anything in the way?
No, it's
all
good.
right. Very good. Well, everybody, it's nice to meet you today. I'm glad I had an opportunity to attend remotely. We weren't sure that was going to work out, and I was really pleased to record the session for you, but it's always nice to be able to give it live as well. This is actually a presentation that we developed in the nonprofit legal aid space called Wake Up Call: Understanding Security and Compliance Frameworks. And just again, the intro, my name is Edward Wilson. I'm one of the senior architects here at ArchTech. And we developed this because in addition to managing a variety of law practices, private practices, we do work in both the nonprofit and public sector as well. We also do technical assessments for organizations. And in 2021 and 2022, 75% of the organizations that we performed a technical and security assessment for were compromised at the time of assessment and didn't know it. And so we put together this presentation. Now, keep in mind, please, that when we're talking about this presentation, I am not a lawyer. I'm an IT person. But originally, I put this together with Ellen Samuel, who is an attorney. And Ellen took care of the next several slides for us. She teaches ethics and technology to lawyers as an adjunct professor. And she's also the director of consulting at a company called JustTech that works exclusively in the nonprofit legal aid space. And if I get anything wrong, then I apologize to Ellen in advance. And if you have any questions, I'd love to refer you to an attorney for more information. We're going to be talking about security and privacy in the context of IT operations. We're going to talk about the top 10 things you should be doing in your firm right now. That's going to be good for business owners, stakeholders, and people who are concerned about the security of their clients. I'm going to warn you in advance, it does get just a little bit techie on the way. And we know that you're not going to learn or absorb or be able to do all of the things that we're talking about today. But I'm hoping you're going to be able to use the slides as a checklist and take those to your IT provider or your IT team and ask them, are we doing all of these things? And at the end of the process, we're going to talk about security standards. Whose best practices should you be following and why? And then what to do if you're breached. But the first piece has to do with security and privacy in the context of IT operations. In 2021, the ABA released a survey that they had done, in which 25% of firms surveyed indicated that they had been the victim of a data breach, a cyber attack that took client information or encrypted it so they didn't have access to it anymore. Keep in mind that when we say 25%, that's 1 in 4, and I believe we have more than 4 law firms currently represented on this call. We're talking about the subset of people who A, knew that they had been breached, and B, were willing to tell the ABA about it in a survey. The actual numbers are much higher and support that 75% of organizations that we assessed, where we saw that there was a breach at the time of assessment that the organization wasn't aware of. The ABA, if I understand this correctly, defines some principles of IT security and confidentiality directly through their rules and their opinions. In addition to the rules on the screen, which you should review at your leisure some other time because I don't know them as well as you do, I'm sure, we have a variety of ethics opinions that are released by the ABA. Particularly, Ellen would like us to note that we have ABA Formal Opinion 477R, Securing Communication of Protected Client Information, 483, Lawyers' Obligations After an Electronic Data Breach or Cyber Attack, and 498 on Virtual Practice. In addition to that, each state will have its own rules, opinions, et cetera, bolstering and talking about ethical responsibilities. And I'm just guessing that Illinois and Missouri are a little bit different. Now, I do want to say this, all lawyer jokes aside, we really appreciate when we work with our attorneys. They're never talking to us about the consequences of a data breach from the standpoint of, you know, their cyber insurance premiums, the penalties that they're going to have to pay, the disciplinary actions, or any of those things that might happen. What they're really worried about are the clients and making sure that they protect the client's information. You all are entrusted with some of the most sensitive material your clients will ever disclose to anyone. You hold the keys of the kingdom. A breach of your data is a breach of their data. And lawyers understand that pain point, and they're focused on the ethics of trying to make things good for their clients. And I really appreciate working with you all and your focus on that. And that's pretty impressive. All right. This is 2,000 reported breaches for a company that collects these, an organization. It's a nonprofit. You can see them down at the bottom in the link, the ID Theft Center. They publish an annual report of people who are telling them about breaches. Again, this is only the reported breaches. And we want to note here that these are some large companies. In fact, Twitter made the list twice. Number one is their December 22 breach. And we don't know a lot about the December 22 breach because they didn't have a PR department at the time. Security and incident response was a little bit weak. And that's all I'm going to say about Twitter today. But one of the things that we want to note here is these are not just breaches that they're collecting in this survey of usernames and passwords. These are breaches where folks are losing their name, full social security number, their date of birth, current home address, driver's license, protected health information, financial data like their bank account numbers. These are serious items. And the number to the right is not the number of records that you see down there. Right in here. Let's see if you can see my mouse there. That's not the number of records. This is the number of records. Oops, let's go back one slide here. This is the number of records, 422 million victims in these data breaches. That's a lot of people, and it's not unique. It's not just that giant Twitter hit up there. The year before, we've got 1,862 compromises, 300 million victims, 12 billion total records exposed. And at this point in time, you may be thinking to yourself, well, gosh, this is such a huge problem. Everybody's been pwned multiple times. Why are we even paying attention anymore? All our information's already out there. But those aren't the rules and ethics that we want to pay attention to. And that's not what our clients are expecting us to do. So we want to try and protect things a little bit better. By the way, if you're getting scared now and you're like, that's a lot of records, Edward, I'm worried I might be on the list. You can go to this website, haveibeenpwned.com. That's haveibeen.pwned.com. And you can enter in your personal email address and your business email address. And it will tell you if you've been in breaches and what those breaches were and what information got stolen. Odds are, if everybody on here enters in their personal email address at this site, hopefully none of the business addresses, but their personal email at the site, you're going to find that you've been the victim, unfortunately, of a number of breaches in the past. And 12 billion records, enough to worry anybody. And it turns out that IT departments at most companies aren't doing the job the way they should be. 2/3 of data breaches are reported by external third parties, whether it's law enforcement or it's folks bragging online. And of the ones that are discovered internally, about half of those come from the employees noticing something suspicious and reporting it to IT. So IT's batting like, 1 in 10, give or take, that they're noticing with the monitoring and alerting that they're putting forward. So this is an area where everybody needs to step up to the next level so that we can understand security in our environment. And we're going to start getting a little bit more on the technical side. Those of you who are technically inclined are going to enjoy this. If at any point in time you're starting to feel lost, just think to yourself, hey, I've got these slides. There's some notes on that. Take any notes that occur to you along the way, and I'll try and point out some individual pieces as we go. And then take that again back to your IT provider, your IT department, and see if you can get them interested in implementing that. This is a discussion on zero trust, which is a big buzzword in our cybersecurity industry these days. That means that people may be accessing our information from any device, anywhere, at any time. And so we're going to automatically distrust everything. When you're accessing information, we want to make sure that you're accessing as an approved and authorized user, and that you're accessing in a secure way. So your device is secure. The location that you're logging in from is one that we recognize and that we've seen before. And if it isn't, we're going to prompt you for more information and so on. And so that's what we want to do. We want to try and limit the number of people who have access to resources to only those folks who need access. Consequences of breach. there's a list the ABA put out about this, but we changed it. We started to use our own list based on what we've seen when people have been breached. There's, of course, the loss of client information. That's a tough one. Negative headlines or just loss of trust, because if you are breached, you're going to have to go back and notify all those folks. There are requirements on notification that you let them know that their data was placed at risk, and that can result in a loss of trust. The hours of creative work, the systems that have gone into place, and that kind of thing. Ransomware attacks that encrypt data can cost thousands and thousands of hours of progress that a firm has made towards systemizing things or having things in place that they need, casework that's going to be essential for their records and so on. So hopefully those backups are working when that happens. And just the significant time, effort, and money to mitigate these. If you are ever the victim of a cyber breach, that's going to start at $10,000 for a small breach of an email account, and it's going to go up from there. And that's after your, insurance deductible, your initial forensic investigation, and some of those things. And again, that reporting requirement that you've got in. Everybody here should have cybersecurity insurance. If you don't have cybersecurity insurance, it's something that you'll need to check out. And loss of confidence, again, one of those things that we're concerned about. So now that we've established the obligation and the importance of this cybersecurity effort, and we have noted that cybersecurity is very important and cybersecurity problems are widespread and affect all of us, let's talk about some things that we can do. Number one, we're going to identify all information systems. This is our top 10 list that we've got here, and I've got a slide dealing with each one. Most people on this phone call tend to think that I'm going to talk about multi-factor authentication. Like, everybody needs to have multi-factor authentication. That's actually number two. Number one is that we need to identify all of our information systems, and I'll show you why here in just a moment. I'm going to use two vocabulary words here: protected information and sensitive information. Protected information is information that is protected by law or regulation. Things like your client's birth dates, financial information, and definitely their social security numbers. The second is sensitive information. That's information that may not be protected by law or regulation, but it's not something you necessarily want to publish on the World Wide Web, like employee pay scales. It's important to identify information systems because we're storing information in more places typically than we think we are. We tend to think in terms of that email account in Google Enterprise or Microsoft 365, or maybe we think about our on-premises server. But we've actually got protected and sensitive information in a lot more places than that. Sometimes, for instance, clients call us and they leave us the private details of their life in a voicemail that goes on for an extended period of time as they disclose everything about their case and some tangential items that may be unrelated to their case. Where's that voicemail stored? You picked it up, you listened to it. Where's it stored? Who's recording that? Is it recorded in your case management system? Is it also recorded somewhere else at the phone providers? How about faxes? Are we using an eFax provider? Okay, we put the fax into the case. Now, where's the fax stored at? Is it stored at the fax providers? We'll talk about that a little bit more, but you're probably storing more than you know in more places than you know. And that brings up the interesting question, how protected is that vendor? And we want to take a look at that and we want to assess the risk on it. We also want to be careful about something called out-of-band or shadow IT. Now, I know that this won't apply to anybody on the phone because you all love your IT teams and your IT departments, and you do all the things they tell you to do. For instance, you only do sharing through the enterprise Google Drive that you have, or you only do external sharing through the specific external sharing SharePoint site that has been constructed for you by the IT team. But every now and then, at some firms, employees are frustrated with IT. It's not doing what they want in the way they want, or it's doing it with unfamiliar tools that aren't quite the ones that they're used to. And so they may go out and try and set something up on their own. Maybe they're going to open up a Dropbox account, share it with a few members of their team. Everybody's got the username and password. We put our stuff in there. It's easy to share from Dropbox. It's intuitive. It's the thing I used in school, and it's really working for me right now. And I hate this other thing over here. And that's how we get out of band and shadow IT. So we have to be careful, because even after we've assessed all the places we know should contain protected and sensitive information, there's another layer on that that we have to worry about. My favorite is grandma's computer on Thanksgiving, where we're downloading company documents onto the computer. For everyone here who said, well, I can't do that on grandma's computer at Thanksgiving because our system won't let me download documents to an external device that hasn't been approved, congratulations, your IT team is on top of it. For everybody else, this may be part of your wake-up call. When we do assessments, we assemble something like this. This is a spreadsheet, and I'm going to highlight a couple of items over here. You may see me from time to time. Let me see if I can swing the screen around just a little bit. That way I'm not completely looking to the side. Hopefully that's my good side anyway. I'm just kidding. In here, I want to take a look at this. So this was somebody who, this is an amalgamation of several assessments that we did. Somebody was running best case. It was a local installation, right? Just on a computer, 2 people used it, and it didn't have a backup. We're going to assess 2 things when we look at risk. One is the risk of loss. What if we don't have it anymore? And the other is the risk of compromise. What happens if the threat actors get hold of it? This had no backup. It was a local install on the land. 2 people had their own credentials to the computer. The risk of compromise was pretty low, but the risk of loss was high because if anything happened to that hard drive, all of that information was going to be gone. The next one that I like to talk about here is CrashPlan. CrashPlan is backup software. Backups are phenomenal. We love backups. But guess what happens when we create a backup of an information system that contains protected or sensitive information? We have just created a new information system that now we have to protect. So imagine, because we do work for first responders and in the government space and for DoD contractors, imagine right now that you're a DoD contractor holding some sensitive information, maybe related to Ukraine and the effort that's going on there. Not something that you want other people to have and something that you need to protect. So in order to protect that information, you make sure that all of your senior people have their computers backed up into CrashPlan. And you're going to back up all of your files, all of your accounting information, everything that you need to protect to make sure it isn't lost goes into CrashPlan. But does CrashPlan have MFA protection in place? Are they blocking people from outside the United States from being able to log into that information? Are they enforcing lengthy, complex passwords? All of these are questions that weren't necessarily answered in this case, and it highlights why we need to be concerned about our vendors and the security that they're putting in place. And if that story made you a little nervous, it should. Farther down the page, we've got Ease, an HR benefits website. All of these are actual case studies. An HR administrator had access to all the HR payroll and benefits information that had been entered into Ease. Multi-factor authentication was not required. The HR administrator, to their credit, used their most secure password. It was the same password that they were using for all of their personal financial transactions. Everywhere that they entered their credit card information or their banking information at any of their shopping sites or financial sites, they used this secure password, and then they also used it to protect their company HR information. What probably happened was they got compromised on a site somewhere, a shopping site, and someone took that username and password and used their software to go log in to a bunch of different places. Last one on here is the voicemail down at the bottom. This particular firm that we did this was a law firm occupying about half a state. They had a local voice vendor, kind of an old school phone system, and it took the voicemails and it recorded them and then it emailed them to the law firm. And that's great. It's in our email. That's a protected system, right? The question was about the vendor's system. That email had all the voicemails that had been stored there, like 7 years worth or something like that. It was not protected. It was on an old Exchange server that wasn't updated. There was no multi-factor authentication. It was accessible online. And now we've lost a lot of voicemails potentially. And so these are the ways that we need to be concerned about our vendors and how they're securing information. From an individual standpoint, if you're not the technician at your firm, if you're not the business owner who's taking all the notes and that kind of thing, you'll want to ask yourself, where am I storing information? Am I creating out-of-band or shadow IT information systems that are not well protected? Is our firm's information backed up, and do we have a plan for that? Okay, next up, now that we've said there's a lot of information, we're ready to talk about MFA, multi-factor authentication. Multi-factor authentication should be mandatory on every information system you have that is storing, processing, collecting, transmitting protected or sensitive information. Multi-factor authentication is like when you're at your bank, right? You want to log into your bank account on your phone or your computer, and they send a code to your phone, and you enter in the 6-digit code. Or maybe it's a prompt that pops up on your phone, and you have to re-authenticate with your fingerprint or thumbprint or something along those lines. Multi-factor authentication is the #1 easy and effective thing that is free in almost every system now, where you can help protect your clients. So as an individual, I want you thinking about anywhere that you are accessing information that could be protected or sensitive, where you're not running into multi-factor authentication. And I'm sorry if one of those is the courthouse. That happens in a lot of our jurisdictions that we see. Microsoft says that 99.9% of fraudulent logins are blocked by MFA alone. If you don't have MFA, 7 out of 100 accounts are estimated to be compromised. I'm guessing that we have people on this call who belong to firms representing hundreds of attorneys and email addresses. And I'm hoping every single one of you has multi-factor authentication enabled. If not, that is a critical priority need at your law firm, and there is a very good possibility that you are already compromised. Frankly, this is particularly true if you're in Microsoft 365 versus Google. I think Google's better out of the box. Google notes that MFA blocks 100% of automated bots, 99% of bulk phishing attacks, and 76% of targeted spear phishing attacks. Those are really good numbers. Free, easy, quick. And now we're moving into much better security. The problem with that is that we then have to think about MFA on all the information systems we just talked about. And that's where single sign-on comes in. Single sign-on is a technology that lets me use Microsoft or Google as my IDP or identity provider. If a system is integrated with single sign-on, like my case management system, right? Maybe I'm using Clio, and Clio, my login there is going to authenticate to Microsoft 365. So what happens when I try and log into Clio is it takes me away from that login screen, and I see instead a login screen from Microsoft that looks just like what I would use to log into my email account with. And in fact, that's what's happening. Clio redirects my login when this is set up to Azure and Microsoft 365. Microsoft 365 approves the login, runs it through all those criteria that we talked about before. Are you logging in on a device we recognize, from a place we recognize, and so on? And it approves that login and sends it back to Clio. And Clio and Microsoft in the background, your tech team has built a trust relationship between those entities so that Clio knows for your organization, hey, I can go to Microsoft. Microsoft will tell me the login's okay. You don't have to have a username, password, and multi-factor authentication with Clio. You can just have it with Microsoft. And this is a win-win for everyone, for the IT team and the end users when we set this up. Because you only have to remember your email login. And the IT team doesn't have to track 20 different MFA logins across 20 different products. They can just use that identity authentication in Microsoft, and they can really build it out and make it very secure. So single sign-on. If you're thinking to yourself, I've got MFA on my email account and I use Windows Hello when I'm logging into my computer and I'm told that's pretty secure, but I don't have MFA for some of my other sources, and I'm certainly not logging in with my email address, nice and easy, to all of those sources, then maybe there's something you can take a look at there. 3, separate user and administrator accounts. Now, I know where this conversation is going to go because I've talked to many of you on the sidelines from time to time. We want to make sure that end users are not administrators. When you go back with your top 10 list to your IT provider or IT team, please don't leave this one off the list. It's actually important. Being an administrator is wonderful. You can install all the programs yourself that you need in order to make things happen. The problem is that if you are ever compromised, you click a bad link, you get a bad download, somebody puts a keystroke logger on there while you're logged in. If I'm an attacker and I can get access to your machine while you're logged in as the admin, I get to be the admin on your machine and you won't know I'm there, but I have full administrative access to everything on that machine. And I can cause a lot of problems at that point in time. And that brings us to today's haiku. Most of your CLE doesn't include a haiku portion, just a free gift we've got here. When a threat actor gains access as an admin, they are the admin. And of course, we've got the bonus XKCD comic on this slide as well. He says, if someone's, I hope everybody here likes XKCD. If not, xkcd.com. I enjoy the comic series. If someone steals my laptop while I'm logged in, they can read my email, take my money, and impersonate me to my friends. But at least they can't install drivers without my permission. And yeah, that's actually kind of true. If somebody's able to access and you're running as admin, it's going to be a problem. IT admins are the worst about this, we found. Their regular everyday use account is the super powerful admin account for the organization. If they're ever compromised, hopefully they know what they're doing, but if they ever make an error, it could allow an attacker access to all facets of the organization. So even though I'm an admin on my personal computer, I've got 2 sets of credentials. One's going to be my regular Edward Wilson credential, which is a regular user. I log in, my computer's set up, and I do my thing. But if I ever need a separate admin credential, I get that little Windows pop-up that says enter your username and your administrator username and password. I have a separate account, and I will enter my username and password for that UAC prompt. That way, if I'm ever compromised, somebody can't own everything about my system, right? That would be super bad. So don't run as admin. You want to make sure you're not an admin. If you are an admin on your machine, ask, and you need to keep it, ask your IT provider to provide you that second set of credentials so that you're not running as admin in your regular day-to-day. Update your infrastructure. This is a great quote from 2022. For those not paying attention, 2022 was last year. It said, by 2022, Gartner said, 70% of organizations that do not have a firmware upgrade plan in place will be breached due to a firmware vulnerability. 70% of organizations that don't have an update plan in place. Operating system patching. For the tech folks, when you're talking to your IT team, this can be done through group policy. Uh-oh, man.
Have to waist it up. You have to grab it here.
I think somebody's doesn't have their mute on. I'm going to throw that out there real quick as a warning. Operating system patching. This can be done with a variety of tools. Our group policy, Intune if you're in Microsoft 365, Google Enterprise will do this for you, particularly with Chromebooks, but they can also manage Windows devices. Third-party RMM tools, there are a variety of ways to accomplish this. But making sure that your operating systems are patching. So firmware, just to make sure everybody understands that first line, firmware is like the BIOS underlying your computer, the drivers for the chipset and the memory and all of these things. Those are the firmwares that we're talking about, the thing that makes your webcam run, all of that. So we want to pay attention to the firmware and the underlying piece. The operating system is the next layer. And don't forget third-party patch management. You need to have all three of those. And you want to check with your IT team to make sure that those items are being implemented. Maybe you've gone down to Windows and you've clicked that gear icon to check for updates, and you notice that you haven't had any updates in 18 months. That's an indicator that you've got a problem with IT at your law firm. So that's how you individually can be responsible in checking up on that. It's very important to make sure your systems are patched. If you're running well-patched systems, you're not going to suffer a lot of hack attacks that are based on vulnerability. All right, next up, changing default credentials. This is one of my favorite ways into an organization when we do assessment. We've got our routers, our cameras, right, including those security cameras, that Amazon Ring system that you got back in the day for the pandemic. So you had video doorbell capability to let people in. The phone handsets, your multifunction printers. My super favorite is multifunction printers. If I'm in an office, like almost all multifunction printers are using the default credentials. The printing companies are the worst for this. They're the problem. They want to set up your printer. They want to do all the cool configuration, and they want to leave the default admin credentials in place. So all I need to know is the IP address of a printer, which takes about 30 seconds on an IP scan of the environment to figure out. And then I just type that IP address in a web browser. I'm about to tell you all how to hack your firm. So, remember, this is all white hat stuff. Never use your powers for evil. With great power comes great responsibility. Pretend we had that whole speech. I pop in the IP address and it takes me into the printer console. I spend another 5 seconds looking up online the default administrator username and password for that Xerox copier. I enter it. And 9 times out of 10, if not 19 out of 20 or 99 out of 100, it will work. Well, now I'm in as the admin. Hopefully, they haven't been storing documents. So I can't just download all the scanned documents, but that happens sometimes. But I've got access to the settings. And they've been using this Xerox copier to scan to email in the cloud. And in the back end, not to get too technical, but in the back end, what happens is the scanner itself has an email address, something like scanner@myorg.com. And that scanner email is sending all of those scans to email or Google Drive or to OneDrive or whatever it is, using that email address, that set of credentials that's on the machine. And since I'm the admin, I can do all kinds of cool things with that. For instance, right now it's set up to be an encrypted session that transfers credentials covertly, right? It hides the credentials and encrypts those when it's doing its authentication. And it's set up to authenticate only to Microsoft365.com, right? The Outlook website up there. That's nice. I'm the admin, I'm gonna change it. So scanner, instead of authenticating to Microsoft365.com, I'd like you to authenticate to my setup in advance attack server.com. And I see here that you're trying to really, be encrypted and careful and secure with those credentials that you have. You don't need to do that. You can just send me your email credentials in clear text. It's fine. And now I've got the scanner email and password. We found one firm with 14 different offices who was using the exact same scanner address on every single multifunction that they had throughout the entire enterprise, which was super convenient for administration in some ways. We got that information, the email account information, and now I can log into the email account, and everything they had sent that they had scanned from the admin down to the staff attorneys for the last 3 years, tens of thousands of documents, was available for me to download and peruse. Now, when we do assessments, we don't download anything. We don't want any of the client's information on our systems, right? We want it to stay on their system. But we were able to take screenshots and show them that we could have executed the hack. Again, this is technical, and as an individual, if you're not a business owner or an IT-leaning person, you may not have this, but it's something that you want to mention to folks. Number 6, using your firewall. Nobody who doesn't mess with firewalls is going to grab this. I'm just going to mention the 4 brief bullet points here. We see a lot of firewalls that are not set up correctly. They don't have intrusion detection and prevention turned on. Keep in mind, I'm not selling you anything today. we're not going to do these projects for you, not because we don't like you, but we only do these with our in-house clients. We don't do outside project securing organization. So we want to implement the security and then monitor and manage it as the in-house IT department over a period of years. That's where we live. I'm just giving you this so that you can take it back home and hopefully get these items done. They are all free and easy. IDS and IPS are a couple of buttons that need to be clicked in the firewall. But if you don't click them, you don't have that protection. Geo-blocking, making sure that we just eliminate on our systems. We want to eliminate all traffic outside the United States. No inbound or outbound traffic. We can put little machines on the outside of people's firewalls, leave them there for a month and come back and say, why are you sending millions of packets to China, Russia, and North Korea? That's common, because people don't have geo-blocking turned in. And of course, they have no business reason that they're doing that, right? You want to stop the bad guys as early and often as possible. So geo-blocking should be set up on every single firewall. Free, cheap, easy. By the way, #1 hacking country in the world is China. #2 is the United States. But, we have to allow some US traffic, as it turns out. We're less concerned about some of the other things that people talk about. Things that keep me up at night, again, are grandma's computer at Thanksgiving, USB drives running around. People are like, I need to use my firewall to block Facebook. We're a little bit less worried about that. We just want to make sure you don't visit any malicious sites along the way. So firewall, just a couple of quick buttons there that make them very secure. You don't have to buy an expensive firewall to get these features. It's better to have a cheap firewall correctly configured every day than a super expensive firewall that hasn't been configured. #7, we are trucking right along here. Harden systems and devices. Make sure every device storing protected and sensitive information is encrypted. Every device that's going to have information on it is running antivirus, malware, exploit, ransomware kinds of things. Require a current OS and password for people before they're able to access protected or sensitive information. Again, the gold standard is that you're trying to log in there on grandma's computer at Thanksgiving. It's not an authorized device, and you're not able to access that information. Remember, we were talking earlier about MFA blocks 99.9% of attacks that are bulk phishing attacks, or 76% of target attacks. The problem that we run into is the threat actor is sitting on their device and they connect to your email account. And at that point in time, they are going to sync all of that information so fast over that nice, beautiful fiber connection that they're exploiting. And then they're going to walk off with it offline and do whatever they want with it. And that's what we're trying to prevent. So when you can only connect via an authorized device, you prevent that. The hacker just had your username and password. It's been published on the dark web for a while now, and they managed to get an MFA token. Maybe you clicked a bad link and went to an attacker site, and it popped up your email username and password. And you're like, okay, yeah, this looks legit. And it was legitimate. It popped up a legitimate Microsoft login, and the attacker stole that credential. And now they've got MFA access to your account. All your information that you had access to is sitting on their personal device that is now offline and gone in the wind, cannot be recovered. The device authorization blocks that, and that's part of that zero trust model that we were talking about earlier. Data encrypted, running antivirus, approved devices that meet appropriate security requirements, dispose of end-of-life hardware, that 20-year-old computer that's running XP in the background because it's your postage meter machine and nobody wants to touch it. It's time for it to go. That Windows 7 server that's got that one program that we never wanted to upgrade, we got to get rid of it. That's just how it works. Re-image computers during uses, and there we go. Completely off-board users. I'm going to spend a couple seconds on this one real quick. From all systems that have access, right? We have shared court logins. We see this a lot with lawyers. Somebody leaves, nobody changes the password. It hasn't been changed in 10 years. 752 people have that password and username and can access it at any point in time, and we just cross our fingers and hope that they aren't. A lot of organizations, your users are storing their passwords in their browser. The browser pops up that nice little thing. If you're logged in on your personal Gmail account, and you're storing company passwords in your browser, it's storing those in your personal Gmail account, along with all your personal passwords. And by the way, when you turn that computer in, and I've changed your Windows password because I'm the IT admin, and I log in as you, and I pop up Chrome, what happens? It pops open your email and all the other things you would log into. And then I just need to see your passwords, and Chrome is super secure. It says, yes, but do you know the Windows password in order to view all these passwords I've saved? Well, I just changed your password and now I can access it. We do that as a scare tactic sometimes for people who don't like to reimage their computers between users. Use an enterprise password manager, not LastPass. They've had like 3 hacks in the last 18 months. It's ridiculous. We like Keeper Security Enterprise, and we offer it free to all our clients. Each of you should be doing security awareness training once per month. It's a 5 to 10 minute video that you're getting from Ningio, KnowBe4, something like that. If you're not, your firm needs to buy it for everyone. The users are the weakest link in this chain, and we've got to train ourselves. And some of these are very vicious testing scenarios. You should be getting fish tested on a regular basis as an employee. That's just part of the work environment these days. And you should be taking your security awareness training. And make sure that your backup is running. That's very important. Now, this originally was part of a longer presentation, but with the audio trouble and me talking a little bit too much about some things, you've got the top 10 list now. Make sure all those information systems are backed up. I'm going to leave this slide. The rest of this was to talk about security standards and all the security standards that are involved. We wanted to talk about this because we see people selling you folks things you don't need. I'm going to give 2 very brief examples. One, anytime somebody's selling you compliance with the NIST cybersecurity framework, run away, and I'll show you why. I'm going to pause on that slide in a couple of heartbeats. Another was somebody who was selling HIPAA compliance at $3,000 a year. They gave you a bunch of policies that were mad libs. You just filled in the blanks, and theoretically you're compliant with HIPAA. Not true. All right. We don't have time for this XKCD comic. Remember, it's not where you're strong, it's where you're weak that an attacker is looking for. Some folks were paying huge money for Sentinel-1 and some fancy tools, but they left the back door unlocked on a couple of other things, and we were able to get in. All right, I'm going to skip all of this. It was really great. It's absolutely fabulous. I'm going to pause on this slide so that I can note one thing. This is from page 1 of the NIST cybersecurity framework. It is not a standard. It was developed to be the Christmas tree for reporting compliance to the federal government for critical infrastructure. And somehow people have decided they want to sell this package for NIST CSF compliance. From page 1 of the NIST CSF, there's sometimes this discussion about compliance with the framework, and the framework has utility as a structure and language for organizing and expressing compliance. But phrases like compliance with the framework can be confusing and mean something very different to various stakeholders. It is not a checklist of actions to perform. So be worried about that if that's what somebody's selling you. This was my great Christmas tree metaphor. This was the liquid natural gas industry's implementation. You don't really need to know about that, but we have to stop here. So last thing I'm going to tell you as we end our presentation today is that the #1 place I will send you after you've looked at the top 10, if you're an IT person or a business owner in particular, there's a free document out there called the HICP Volume 1. The HIPAA law says that we're supposed to do a lot of things. And some folks got together, very knowledgeable folks in industry, and they wrote the HICP Volume 1. It is a 29-page PDF. It is very easy to read, very accessible. It is designed for organizations that have less than 10 physicians. Small mom and pop shops to be able to implement it. And Congress gave it a safe harbor designation. If you're somebody, and I'm not saying anyone on here has signed a BAA or is subject to HIPAA, you know, as I'm throwing around protected health information, if you think you may be subject to it, please see a lawyer. But you can, Congress said they won't fine you for HIPAA violations if you're trying to follow a recognized standard like the HICP. It is the simplest and easiest standard to follow. It is a checklist of things to do, and it's absolutely fantastic. It says things like avoid freer consumer email systems like sbcglobal.net, deploy MFA. It's an easy checklist. It's got that triple miracle. It's things that matter, it's highly accessible, and it's got government recognition as a safe harbor. The link is in the presentation. And that's just me complaining about the CSF again. Last piece here, just as healthcare professionals must wash their hands before caring for patients, healthcare organizations and your law firm must practice good cyber hygiene in today's digital world by including cybersecurity as an everyday universal precaution. just like hand washing, and this is so true, you all, so true, and it's why we wanted to put the presentation together today. Cyber awareness does not have to be complicated or expensive. It really doesn't. You just have to check off the boxes and not leave the vulnerabilities. Even if you weren't a technical person, I hope this presentation was useful for you. By the way, if you're breached, contact your insurance company. The forensics team will walk you through things. You can read the slide for some other pro tips later. My information is here at the end. Thank you so much for listening to me today. And I hope this helps you. I hope it helps your firm, and I hope it raises that bar of awareness. And if everybody's sweating right now, because I said 75% of organizations we assessed were compromised and didn't know it, then we've probably done a good thing in that regard as well. Thank you.
Edward, thank you. All of you who are attending realize that we had no technical glitches until Morry Cole earlier in the day talked about needing belt and suspenders. And Edward, you were our suspenders for this. And thank you for participating.
No worries.
Very good. Okay, folks, give me about just 1 second to share my screen, and we're going to start into the next segment. So our last segment of the day is covering embracing diversity and inclusion, a foundation for better law practice. We were fortunate last year to hear from Cardina Johnson. Cardina is on the panel of mediators here at USA&M. She also has a day job with the Illinois National Education Association as an associate general counsel. She was unavailable, but pre-recorded this, and some great ideas for us in our law practices, and how embracing diversity and inclusion can really assist us in the practice of law. This is going to be right at 1 hour, and then I will come back at the very end with a couple of final things. But in the meantime, folks, you have the evals. Kelly will send another copy through email. And I want to thank everyone for participating. Let me start this and we will get.
Well, hi, I am Cardina Johnson, and I'm here to talk about diversity. Specifically, we're here for the CLE, Embracing Diversity and Inclusion, a Foundation to a Better Practice CLE. I'll be with you for about an hour. So first, we will cover what diversity is with its 2 dimensions and overall benefits. Then we will discuss generational and global differences, including ethnocentrism. We will also consider personal, cultural, and implicit bias. The second portion of the presentation will explore how marketing can expand your business from a multicultural perspective. So let's get started. So what comes to mind when you hear the acronym EEOC? Well, we as the attorneys know it stands for the Equal Employment Opportunity Commission, which is, of course, responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or an employee. Perhaps some of you who practice corporate defense law may think of it from a compliance standpoint and may ask, are my clients in compliance with all the notices and filing requirements they have for their employees, et cetera? But today I'd like for you to think, why do we have the EEOC and the laws it enforces, like the FMLA, the ADA, and Title VII? Who is being protected and why? I encourage us to celebrate why we have these laws in the first place. essentially the EEOC is a step towards enforcement of the respect that we have for our differences in America. Consider this list and how it creates a narrative as to how different we are. And these are some of the factors that make us all unique individuals. So to me, diversity means to consider all people as unique and then recognize, understand, and appreciate their individual differences. In the US, diversity is often associated with race and ethnicity. And you'll see that I have some clips that kind of reflect that. But for now, we are a diverse group in a wide variety of ways and have a multi-dimensional layer of diversity in America. Diversity dimensions can be split into two tiers: primary dimensions and secondary dimensions. Primary dimensions are those qualities of self that cannot be changed, such as race, ethnicity, or age. Secondary dimensions include those aspects of self that are more fluid and where some personal choice is involved, such as, marital status, educational background, religious affiliation, and, like occupation. Embracing diversity means to accept without judgment all these aspects of an individual on both a primary as well as a secondary dimensional level. There are so many different perspectives and talents we collectively bring to the table. So the takeaway is to have a very broad view of what diversity means. So you want to ask yourself, what are the benefits to embracing diversity? Well, why change? If it doesn't feel broken, why make an effort to change things? Well, on a workplace level, it will result in a variety of different perspectives. This in turn will certainly give you, faster problem solving, higher innovation, and it probably will increase your productivity and creativity. As a whole, the group will be the whole group will be better at decision making. So because of the high levels of success, the employees will be more engaged, less likely to leave, and therefore hiring is just improved overall. Just looking at the overall picture, these things can lead to a better company reputation and increased profits. So rather than using a workplace example to illustrate how this works, let's also consider something different. Let's consider trivia night, where my husband and I, we really enjoy going to trivia nights. And I happen to notice that we really do a lot better when we have a diverse group of people on our team. I do notice that there's a significant correlation between us doing well and having like different ages of people, different backgrounds, different religion that come and join us. So for example, consider who might know the answer to the following questions. What year did the TV show Little House on the Prairie first air? Consider who would be more likely to know that answer was 1974. Would you assume that maybe someone who's school-aged or older in the 1960s might know? Or what is the name of the rapper Lil Baby's debut album? Who might have a tendency to know the answer is Harder Than Ever? Would it be a person who's a big fan of rap music, a young person, or at least one who follows current pop culture? What year was the first World Series played? Who might tend to know that answer? Someone, a sports enthusiast, a big baseball fan, someone from Boston where it was played. So that answer, by the way, is 1903. So if you have all different kind of people on your team, the more likely it is that the group will be successful in their efforts. A diverse group will use their diverse perspectives towards faster problem solving. When the group is doing well, the more likely those participants are engaged. They get bragging rights as their table becomes, the one to beat. for the next trivia round, and their reputation is heightened, and you just might get some profit. You know, you might get cash or gift certificate if you come in first or second place. So the point is, when there is a common goal, a variety of different perspectives can have a significant impact on the positive attributes and things that occur. So another thing that we want to consider is we'd like to consider the benefit to embracing diversity is it aligns with the fundamental principles and values that America was based upon. For example, in a democracy, collectively, every voice should be heard. In our Pledge of Allegiance, we attest that we are one nation and indivisible, that there should be liberty and justice for all. We can also consider the iconic phrase from the Declaration of Independence that all men are created equal, which goes on to declare that we have certain unalienable rights like life, liberty, and the pursuit of happiness. We should all finally recognize that embracing and being a champion for diversity is just, you know, as American as pie is, honestly. Ultimately, on a personal level, it's just the right thing to do. Embracing diversity adds so much richness to our lives, making personal and professional endeavors much more interesting. Cultural diversity and differences should not separate us from each other, but allow us to evolve and grow together. Another benefit to diversity can be seen through the value in interacting with individuals from different generations. While no generalization applies to every member or of a particular group, there is a commonality that individuals growing up in a certain era experience together that tend to shape them. For each generation, there were formative events that, you know, they have experienced collectively at that time as they are approaching adulthood that probably had some sort of impact in shaping who that individual is. So for example, the silent generation was born between about 1925 and 1945. And they grew up with the world wars, the Great Depression, the GI Bill, the birth of TV, and the rise of suburbia. The baby boomers, born from 1946 to about 1964, were responsible for the hippies, saw the JFK assassination, were aware of the Vietnam War and the Cold War, and they started the Civil Rights Movement. Generation X, born from about 1965 to 1979, they saw hyperinflation, they saw economic turbulence, the fall of the Berlin Wall and the Soviet Union, troubles in the Middle East, and a significant decline in the nuclear family. The millennials, born from about 1980 to 1995, saw the dawn of the internet, 9/11, Hurricane Katrina, emergence of mobile technology and social media. Then the youngest generation entering the workforce are from Generation Z, and they're currently age 25 and younger. Some things that have affected them are the election and re-election of Barack Obama, widespread internet and mobile usage, and the legality of same-sex marriage. For these 5 generations, you can expect that the time in which they came up will give us clues as to what their beliefs or values might be. Last year, I participated in an attorney staff meeting, and I think that was one that was really well debated, and we had a lot of input. And it was where a Latinx millennial, who's one of my colleagues, was explaining to a white baby boomer, another attorney colleague of mine, you know, about some of the nuances in a case involving racial discrimination and an exchange of words on Snapchat app. Not only could the millennial provide valuable insight on how Snapchat worked, having come from a technology, generation, but he also ended up explaining why a particular Latin slur was offensive. And so the discussion prompted me to go and try to learn more about Latinos and Hispanics and the correct terminologies to use. I've learned that Hispanic and Latino are often used in an interchangeable way, but they are actually defined differently. Hispanic refers to people of Spanish-speaking origins, and Latino, Latina, and Latinx, the gender-neutral term, refer to people whose origin are geographically located in Latin America. Based on these two defining criteria, the 2020 US Census used both terms, and an individual can identify as one or both. So I also learned that many Hispanic Americans consider themselves white, and many from the Caribbean consider themselves Black. So one thing is certain, there's a lot of intersectionality and ambiguity surrounding Latinx and Hispanic identity. And I'm glad that my millennial coworker, while trying to educate my baby boomer coworker, prompted me, a Generation Xer, to become more educated about Latinx Hispanic culture. This is just one of the many examples of how the benefits of diversity can enrich a work environment. So I see that I accidentally moved to the next slide that's been showing for a while. But the point is, when we talk about global views, we want to consider ethnocentrism. And when we consider that, let's see if it is basically the belief that the culture you grew up in is superior to all other global cultures. So because most of us have an intimate connection with where and how we grew up, most of us have a sense of pride in our culture. It's understandable then that we think our culture is like awesome. That's normal and that's okay. The problem arises when we use our social and cultural backgrounds as a standard to judge everyone else. That is, we start thinking less of anyone who's not part of our immediate culture. It's not just a problem in the United States. Citizens of all countries and all cultures are prone to ethnocentric beliefs. An obvious example would be by how people in one nation view the culture of people in another nation. So an American citizen, for example, might feel that their culture is better than the cultures of France, China, and Brazil. Likewise, a Chinese citizen might feel like their culture is superior to the cultures of France, Brazil, and the United States. So there's just that view that we have. So ask yourself where ethnocentrism might be an issue for you. So for me, I will share that, I wasn't around a lot of people who are not native English speakers when I was growing up. As a teen, when I first entered the workforce, I began to encounter people where English was their second or third language, and some grammatical mistakes were made as they spoke. And my mind just immediately associated the fact that they had these grammatical errors, so that must mean that they were not well educated. And in looking back, I realized that association was of, less than stellar English with not being educated was a problem that I had. Then I started to realize that I should not make the assumption about people not born in the US, especially considering that the ones that I would encounter, they knew how to speak 2 and 3 different languages, and I only know how to speak 1. And so I had to really work to make sure that I wasn't making that connection between the typical American view, which is poor English might mean not educated, but that may not be the case with people who are not from an English-speaking country. So ask yourself, do you have your own example of an ethnocentric view? And will you work to change your own internal dialogue? So perhaps ethnocentrism exists because all cultures have certain norms and interacting customs, and they believe that their way is the best. These norms fall on a spectrum of what we call the high-low context. And the context of high and low offers a good way to think about cultural norms of interacting from a, just a generalized perspective without stereotyping about a group. Similar to the way we can just consider how the generation that we're born in may affect us. Okay, so we're not going to stereotype, of course. So the concepts of high context and low context refer to how people communicate in different cultures. Differences between the two approaches can be seen by focusing in on the manner or style that the communication is conveyed. The context of the communication will reveal whether attitudes and true meanings are transmitted mostly through actual words used by individuals, or whether meanings are mostly implied from the context or body language. High context cultures tend to transmit a lot of unspoken information that is implicitly transferred through nonverbal cues. People in a high context culture, such as Saudi Arabia, tend to place a larger importance on long-term relationships and loyalty, and have fewer rules, structures, and implementations about how you communicate. But when you think about low context cultures, they tend to transmit a lot of information that is explicitly expressed through the message itself, and rarely is anything implicit or hidden. People in low context cultures, such as the UK, tend to have short-term relationships, follow rules and standards closely, and are generally very task-oriented. Understanding whether your international clients are high context or low context will help you to adapt your communication style and build stronger relationships with them. What are some examples of generalized characteristics of high context cultures? Again, they won't apply to everyone in the group, but you will find a tendency for those in these cultures to communicate indirectly, to take a slower pace with things like time. The communication is layered and nuanced and subtle. What are some cultures that you might think are high context? Well, Asia, Middle East, Latin America, and Eastern and Southern Europe are considered high context cultures. Low context cultures, on the other hand, tend to be more, concise and straightforward in the communication, and it's still direct and clear. What are some low context cultures? Well, Canada, Western and Northern Europe, Australia, and no surprise, the United States. So we have discussed what diversity is with its two dimensions and overall benefits. Additionally, we've discussed generational and global differences, including ethnocentrism. Now it's time to go a little bit deeper and discuss bias. On the road to embracing diversity, there will inevitably be an encounter with bias. A culture can have its own bias, and individuals with the culture can have their own personal bias. So a cultural bias is a tendency to interpret a word or an action according to culturally derived meanings assigned to it. For example, some cultures view smiles as a deeply personal sign of happiness, that it's only shared with people that they know in an intimate way. Others view smiles as an indication of just general friendliness to be shared with all. So a personal bias is a tendency to interpret a word or action in terms of a personal significance assigned to it. Personal bias can derive from culturally defined interpretations, but also can originate from other sources grounded in personal experience. A personal bias is an individual's feeling about a particular person or thing that shapes the individual's interpretation of it. So the bias can lead to more favorable or less favorable judgments that are fueled by the bias. Let me give an example of these concepts. So in general, though there is a mounting counterculture in the United States, traditionally, there has been an embracing of guns and hunting. This is, of course, rooted in the constitutional freedom that we have the right to bear arms. So nevertheless, someone raised in a rural setting, for example, might have a different relationship with nature and hunting than someone raised in an urban environment. So someone raised in the suburbs might have a slightly different mindset than both the rural and the urban dwellers. For many years, I had a personal bias against hunting until I worked with, got to know, and became very, very fond of my former secretary, who is from a rural, very small area. As a matter of fact, where she lives is actually called a village in Illinois. But anyway, she absolutely loves hunting. It represents family and fun and friends to her. Her kids and husband are avid hunters. She explained that hunting represented special times with her father, who is since deceased, tradition and respect for nature, because she was always taught to eat what she killed. She kept a picture of her son and a shot bleeding deer proudly displayed on her desk. As a matter of fact, she had this phrase that was really her go-to phrase that meant that a concept just doesn't work. That phrase was, "That dog don't hunt," she'd always say. She also told me that the good Lord made animals to eat. So she clearly has a cultural and personal bias towards guns and hunting. I, on the other hand, grew up as an urban dweller and never in life had met anyone that I was aware of who hunted as I was growing up. The absolute only real life experience that I had with hunting was when I saw a Disney movie when I was a child. And the scene where the Bambi's mother was shot by a hunter shocked and horrified me. Why in the world would someone think hunting is okay? Who would kill Bambi's mom? By getting to know and become fond of my former secretary, however, I was able to recognize my personal bias and to move away from that view. You won't find me hunting ever in life, I don't think, but I'm proud to say I no longer judge hunters as being, quote, bad people. As for my cultural and bias and personal biases against hunters, my former secretary, she would say, "That dog." So yes, I really am no longer holding the same views that I had against hunters. So biases can be based on some factors, and there's so many different ones that it can be based on. So let's consider the answers to these, 3 questions, oh, more than 3. Yeah, these descriptors up here. The first question is, you're really thinking about who's in your network, okay? And so when you consider that, consider things like 3 descriptors. For me, let's just say, I am a woman. I am an attorney. I am African-American. And as you consider that, do you see a theme or pattern when you answer questions about yourself compared to the people that are in your network? I know for me, there's a lot of commonality. What you may have found is that there's a level of homogeny in your interactions. If that is the case, we may not experience high levels of cross-cultural or diverse interactions in everyday living. Just consider looking at the slide. My neighbors now are primarily fill in the blank. People in my place of worship are mostly fill in the blank. Our conscious biases are easier to identify, and we can often articulate how they were formed because they're conscious. We're aware of them, and can go back to a situation that happened in our lives. Through open-mindedness and having diverse interactions on primary and secondary dimensions, biases can change, as was the case with me and my hunting example. I was very aware of where my mindset was. Implicit bias, on the other hand, is subconscious. Just as music is thought to communicate subliminal messages over time after you listen to it a bit, the culture that one lives in passes along messages to those living in the given society. So those that pick up on the messages should not be labeled as bad people. We all live in society, and we all pick up the messages that are being delivered. Where implicit bias can be a dangerous concept is when a barrier or roadblock is created that we are not aware of on a conscious level. The first step to check for this is self-discovery, which will entail spending time exploring one's own ideas and beliefs. There are implicit bias tests on the internet to take, like the Harvard Implicit Bias Association test. But first, you must be open-minded and have a willingness to dive deep. Now, let's look at a 3-minute clip of Dr. Robin DiAngelo, who received her PhD in multicultural education from the University of Washington in Seattle. Her area of research is in whiteness studies and critical discourse analysis, tracing how whiteness is reproduced in everyday narratives. She coined the term white fragility in an academic article in 2011, which means the discomfort and defensiveness on the part of a white person when confronted by information about racial inequality and injustice. This excerpt is from a concept from her book, White Fragility: Why It's So Hard for White People to Talk About Racism. Starting on the path of exploring your own biases is an important life-changing endeavor. It is easy to engage with the people that we know and share inside jokes and history with them that doesn't resonate with everyone. When this occurs, though, the people that aren't in on the joke or the story, they feel isolated, they feel left out. It'll be very difficult to get these folks to engage once this hasn't occurred. If we are in the dominant identity group, preferences for our in-group can have the same impact as being seen as hostility toward the out-group. So I have a challenge for you. The next time you have the opportunity to seek out a connection with someone or a group outside of your comfort zone or norm, please do so. Whether it be a cultural event, a religious event, a festival, a music performance, or the like, so long as it is something that you would not normally be involved with or do.
Many people can recognize the explicit kind of conscious dislike type of racism, racist jokes, racist expressions, the KKK. But I want to help white people see the everyday racism that's embedded and that we participate in. And I want to look at neighborhood and school segregation as an example. I'm going to start with this app here. These are the app's founders. It's a new app called The Sketch Factor. And what it does is when you go to a new city, you can put in where you are, and it tells you which neighborhoods to avoid because they're sketchy. And of course, sketchy is very much associated with race and class in the white mind. And so now we have the convenience of segregation through an app. We don't actually have to talk to other white people about, where are the good neighborhoods and the bad neighborhoods. And that good neighborhood, good schools, bad schools discourse is an example of new racism. I don't think it gets by anybody that is racially coded language. So this way we can come out and police those racial boundaries without ever kind of naming race. But we all know what we're talking about. And I think the most profound way that my life has been shaped by my race is through the power of segregation. Most white people do live in segregation. We choose that segregation. And in a lot of ways, we celebrate it. What makes a school good and what makes a neighborhood good? Well, the absence of people of color. That is the way that white people measure the value of their neighborhoods and schools. And while we don't come out and name that, we all know what it is. So I have had to think very deeply on what it means to have grown up in a primarily white neighborhood, to be born into, to go to school, to study, to learn, to play, to worship, to love, to work, and to die in segregation, and not have one single person who loved, mentored, or guided me convey that there was any loss. And I'm going to repeat that because I think it's very profound, and I really want us to sit with it. That I could live my whole life in segregation. In fact, if I follow the trajectory that my loving parents laid out for me in my good neighborhood and my good school and my good college and my good career, in which I would ideally rise to the top, I could easily never have any consistent, ongoing, authentic relationships with people of color, and not one person who guided me ever conveyed that there was loss. Just sit with that for a moment, that there is no inherent value in the perspectives or experiences of people of color. If my parents, if my schools, if my curriculum, if my teachers, if my government saw value in those perspectives, I would be given those perspectives, but I wasn't given those perspectives. And that shapes my relationships. It shapes what I care about. It shapes what I see, what I don't see, who I build my life with and who I don't build my life with. And that is the level where we really need to look at race inside of us and with us.
So how about we switch gears altogether on the topic of how to expand your business through inclusive multicultural marketing. Successfully inclusive businesses understand that embracing diversity is important to their success. Legal professionals who understand and embrace diversity reap personal and professional benefits. So in this section, we're going to cover how to identify or basically a power in local marketing ads and identifying the prospective clients in those ads or through those ads. Then we're going to talk about advertising and social media and how they will help with our business. And then the third thing we'll talk about is local demographics and trends that confirm that diverse multicultural populations exist in local markets across the United States. Fourthly, I'd like to talk about the power of networking and community outreach that should not be underemphasized. And fifth, it's important to create a specific, inclusive business plan centered around diversity and inclusion. And finally, how to embrace equity and inclusion in your practice. Multicultural marketing growth varies by state and local area. According to the 2017 Multicultural Economic Report produced by Selig Center at the University of Georgia, the buying power of minorities will continue to grow at a rapid rate throughout this decade. In 2017, the total share of US buying power controlled by Hispanic consumers was 10.3%. But this number is expected to exceed 11.1% in the near future. So in 2016, African American buying power was roughly 1.2 trillion, and that should grow to 1.5 trillion this year. Representing 6.1% of the US population, Asian Americans' buying power stands at $986 billion. As of April 2018, the combined buying power of Asian Americans, African Americans, and Native Americans is estimated to be about 2.4 trillion. While Hispanics command 1.5 trillion in spending power, without a doubt, a portion of these monies will be spent on legal services. So, what can we do? When it comes to advertising and social media, we can create an advertising and social media marketing strategy that is inclusive and compliant with state and federal laws, of course. So the internet is how a lot of attorneys are found. Commonly encountered forms of lawyer advertising include television and radio commercials, print advertisements, billboards, direct mail marketing, law firm websites, and participation in telephone directories, commercial directories, newsletter directories, referral services, and through online advertising and social media. According to the ABA and ABA survey, legal advertising has surpassed $1 billion. 80% of respondents say their firms maintain a presence on social media, the highest since 2016. Among those firms that do, use social media, LinkedIn is still the leading platform, and so it's used by about 79%. And then following that is Facebook with about 54%. But it's reported that the Facebook usage is sort of declining over the years. Consider how you advertise if you choose to do that, and will it have a multicultural appeal? Understand the value of analyzing the demographics of your community and creating an inclusive brand. When you look at this slide, what does this law firm ad say or not say to prospective clients? What could be done to change the message being sent? Is there a female attorney or other legal professional who could have been added to this photo? After all, females make up 55% of the US population. Researching local demographic trends will be helpful to expanding your business. Understanding and interpreting local demographics is critically important to avoid costly marketing and recruiting missteps. If, for example, you have a large Hispanic, Latinx, or Asian population in your community, find out their specific country of origin. Are they Mexican or Cuban, Chinese or Vietnamese? And for areas of practice like wills and trusts, examine their age segments. and, median household incomes to develop a sound marketing plan. The analysis of local demographic data will help you develop marketing strategies and business plans that address the specific needs of a diverse market. Gather data in areas such as total population and population by nationality or race, income, and employment. The American Immigration Council's Immigration Policy Center and the Migration Policy Institute are great resources. The goal for using these resources should be to provide better service to all population groups. Using an understanding of local demographics to only market to specific groups at the expense of inclusion is contrary to the goal. So we're obviously not going to target specifically. It's just you want to make sure that everything is inclusive when you're doing your data analysis. By using metrics, law firms and other legal employers and other legal, avenues, the employers can access multicultural business outcomes more effectively. For example, if you're an attorney in Missouri, you may learn that there are about 70,000 Mormons, a number which has tripled over the last 2 decades. For those of you in other markets, like let's consider Tennessee, the last 2 decades have seen remarkable demographic changes in Tennessee. Tennessee has one of the fastest growing immigration populations in the country. Although immigrants still make up less than about 5% of the state's total population, that still represents about 340,000 people, with the rate of growth, rising for business opportunities. And according to the American Immigration Council, of the 340,000 people, about 100,000 people are from Mexico specifically. And the remaining are from other places like India and Guatemala. So the importance of networking and performing meaningful multicultural outreach in your community cannot be overemphasized. Networking to get referrals is one of the most basic and effective marketing techniques available. There are many ways to initiate, build, and maintain relationships through networking, and with the ultimate goal of generating referrals and attracting prospects. With all aspects of marketing, a planned approach results in the greatest return on investment. Networking by using social media is a critical part of any networking strategy, but this slide is really focusing on face-to-face networking. Face-to-face networking is especially important when trying to create an inclusive brand, because at the end of the day, trust is established through genuine, authentic person-to-person contact. Pushing away from your desk and computer to interact one-on-one is a must. Okay, so when you think about multicultural community outreach, which is a grassroots efforts reaching out to multicultural clients where they live and work, this has proven to be a successful way to make meaningful connections with a diverse market and to expand on business. The legal process can be a confusing and very intimidating process for the typical layperson, and traditionally underserved communities are seeking opportunities where they can get to know an attorney that they can trust. Positive word of mouth within and across diverse ranges of cultural groups can go really a long way in gaining references and building that trust relationship that I mentioned. In your outreach to multicultural clients, you will often find the best points of contacts are in the heart of the community. In fact, studies have shown that community influencers represent one of the best ways to connect within various typical underserved communities. And now I'm not necessarily talking about social media influencers, but I'm just talking about your common everyday your common everyday influencer, which would be someone like them, the immediate family member or the friend or that neighbor. They can be found in places of worship, including churches, synagogues, mosques, temples, non-denominational congregations. And then there's networking with medical professionals, with teachers who could connect you with speaking opportunities at schools on maybe a student career day where parents also attend. And other attorneys, such as those specializing in immigration, may have a referral system that you could work out with them. So there are just other businesses as well that you could utilize. Effective legal professionalism, really does include inclusive mindsets, because typically those who seek to understand and develop their community network do whatever it takes to prevent there not being this sort of exclusion of other individuals. Consider the example of volunteering for an Ask a Lawyer event, such as an event like how-tos on the law, or providing useful and accurate information can help you establish strong credibility and build, relational equity over time, because it will take some time to build that trust. You could volunteer in that community, sponsor things. There's many things you can do in that community. Consider these outreach methods to market to multicultural potential clients through professional specialty associations, like groups for minorities with MBAs, for example, and ask to provide a lunch and learn event, or collaborate or sponsor a specialty minority bar effort. And please don't forget the LGBTQ plus community and other advocacy groups where they have their own community outreach efforts as well that you could be a part of. At colleges and universities, consider an intern or externship with a diverse perspective. Or there are often multicultural organizations on campuses while school is in session that you can reach out to as well. With the local media, reach out to community entities with publications in different languages to promote events. Consider being a guest writer for a specific publication or blog, or making an appearance on a local Spanish, Asian, or African-American media outlet. Remember that even if you don't speak the language, provide information that is useful and to that community, and let the host or someone else at the station translate the message, get an interpreter. You can always be creative with the internet when it comes to getting your language translated for you as you communicate it. So, but more important, make certain that the events are family friendly and accommodates children. Your inner circle network is another aspect of the planning phase to consider when you determine how you determine who's in your inner circle, I should say, not necessarily when, but your inner circle is one that's really important that you can really utilize. Your sphere of influence can include everyone you might come in contact with, including your family, your friends, your acquaintances, and people you don't necessarily know, but again, you come in contact with them. You need to identify who comprises these groups so you can market yourself accordingly. Identifying these spheres also helps you set your marketing goals. And so you can formulate an inclusive business plan as another way of embracing diversity and growing business. When developing your inclusive business plan, ask yourself the 5 following questions. Does your law firm have name recognition across all the communities within your market? And really consider that. Does it have resources to extend its reach to all communities within your market? So having the resources sometimes is different from the name recognition, as you know. 3, how experienced and knowledgeable are you about the communities within your market? 4, do you have a strong list of contacts and connections to the various communities within your market? 5, what is your current advertising strategy to appeal to all communities within the market. Assign each factor you can think of, either with some sort of strength or some sort of weakness category, and develop specific goals. Also think of other questions to ask yourself that are tailored to the type of law you practice and your specific goals. When developing your inclusive business plan, you can also ask yourself questions like, are there particular communities within your market that are heating up or cooling down? Are there any barriers like language that will make a legal representation easier or more difficult for certain segments of your market? Again, assign each factor you can think of as either an opportunity or an area for improvement. And when you look at the analysis in total, you can begin to see ways to gain competitive advantages like external opportunities and internal strengths, as well as places where you might be at a bit of a disadvantage. So, switching gears, ultimately embracing diversity on both a business and personal level leads to achieving an optimal level of diversity, equity, and inclusion. In a business context, diversity, equity, and inclusion are often discussed like, they're interchangeable, but they are not. In big firms, management might attempt to hire a diverse range of people, but that doesn't mean that the diverse hires are made to feel comfortable and welcome in the firm itself. That is, the company hasn't made any attempt to make the culture of the company more inclusive. In such instances, new diverse, hires often leave the firm sooner than later, and the cycle begins all over again. Companies that do this are said to be just sort of checking the diversity boxes. They're making a superficial attempt to say that they're doing what's right, is kind of how people might view that. But if their efforts aren't authentic, people never truly feel welcome, never feel part of the culture or team, and end up leaving as a result. The concept is just sort of, hey, we have one, we've got this group here represented, and that's it, with no effort to make them feel included. So what strategies can you use to ensure your legal practice is inclusive? A business that practices equity and inclusion is one that truly tries to create a culture that makes everyone feel welcome. Inclusive cultures are they're comprised of big things: sexual harassment policies, discrimination laws, etc., but also the small things like acknowledging the holidays and important days of all religions, making online marketing materials accessible to all, regardless of physical abilities or challenges, offering contracts translated into multiple languages, etc. So being an inclusive business is going beyond what you're mandated to do by the law, but to do what you think will make you and your employees and your clients feel valued and respected as people. It's a focused leadership approach that is intentional, a priority, and basically it's analyzed regularly for checks, for improvements, and ways to make it better. For those who are solo practitioners, these are thoughts to consider as you grow and expand. For those who plan to remain solo, however, perhaps you can consider embracing diversity and inclusion when and if you make the decision to hire support staff. In short, successful businesses understand that embracing diversity is important to their success because local demographics and trends confirm that diverse, multicultural populations exist in local markets across all of the United States. 2, a study of buying power in local markets aids in identifying prospective clients. So when you study the local markets, you're able to perhaps tap into clients that you weren't tapping into before. 3, legal professionals who understand and embrace diverse cultures reap personal and professional benefits. And finally, by using metrics law firms and other legal employers can access multicultural business outcomes more effectively. Well, so that is about my time here. I want to thank you for listening attentively. I hope that was the case. I do have a bit of a bonus in the event that I didn't fill the full 1 hour so that you can get your full credit. And it has to do with business norms and etiquette. So some quick tips beyond the proper etiquette you use during business proceedings. You know, you want to project positive attitudes toward diversity in addition to adjusting to the other person's needs for high or low context communication. So here are 10 basic principles for multicultural business norms and etiquette. 1, talk less and listen more. That can go a long way. People like to feel heard. 2, be sure to use correct names and titles. Please don't assume, just ask. I know of someone, for example, who used a first name with a person who was in her 80s from the South, and had the person known that often women who are older and from the South like to be addressed by their last name, I think the interaction would have gone a lot better. 3, show deference to the elderly. 4, learn at least a few phrases in a client's native language, if you can, and you can pronounce it properly. 5, be extra careful to show respect to the concept of one's sense of status and worth. Another example that I have is I know of an African man whose sense of self-worth is very tied to the notion of his family lineage and that he came from kings. So he probably has a different perspective of himself than maybe the typical person who doesn't think of their lineage or is aware of a lineage where they're coming from, royalty. 6, don't try to create an instant friendship. Friendships take some time. So it's just a matter of being patient and getting to know someone. 7, cultivate empathy. Put yourself in others' shoes and try to understand where they're coming from. 8, don't make jokes. Humor often doesn't translate, well, cross-culturally. So rather than making that mistake, it's probably better to skip the jokes until at least you get to know the person and are sure. 9, show respect for others, their customs and their culture. 10, acknowledge mistakes and apologize when appropriate. You'd be surprised how far a mistake can go without an apology attached to it. People really do seem to embrace apologies from time to time. So that's my time. I enjoy presenting this, and I hope that you got a lot out of it. Have a great day.
Folks, I thank Cardina, great program, a lot of things for us to think about, and thank all of the presenters today. They put in so much time and presented great topics for us. I want to thank Kelly Spiller of our staff, who was really the laboring oar in putting this together. We look forward to seeing all of you at best practice programs in the future. The next one we're starting to plan is in the early to mid fall, based on some of the things that you suggest in terms of topics, speakers, and don't forget to give us your thoughts about others to be part of our Legal Legend series. On behalf of all of us at USA&M, thank you so much for attending, and have a great evening.